It's 1 p.m. The Committee on Judiciary and Civil Jurisprudence will come to order. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye. Here.
Davis. Moody. Murr. Schofield.
Here.
Basute.
Here.
Slauson. Flores. Here. Quorum is present.
Thank you, members. The quorum is present. The chair lays out House Bill 4557 and recognizes Chairman Darby to explain the bill. I know we have a committee substitute, and so Representative Schofield lays out the committee substitute to House Bill 4557. And before I recognize you, Chairman, to explain the bill, I just want to remind everybody who's here, as well as those in the overflow room and those who might be joining us online, that members are going to be, as is customary, coming and going throughout the afternoon as other committees meet, as they have their own bills to lay out. But please be assured that your testimony is being heard, that your voice is valued, that the legislators are paying attention and their staffs are as well. And so even though the physical presence here on the dais may not be, even though the dais may not be full, we're hearing you and your testimony matters. So with that, Chairman, you're recognized to explain the committee substitute to House Bill 4557.
Well, thank you, Chairman Leach and members of the committee. It's my pleasure to lay out for you today the committee substitute to House Bill 4557, which seeks to provide liability for capturing and storing carbon dioxide. Carbon capture, utilization, and storage, known as CCUS, is the process of capturing carbon dioxide from plant emissions and storing, transporting, and reusing the carbon. This is not only positive for the environment, it is beneficial to the Texas economy and to the energy industry. It is a way for Texas to continue to produce energy for the state, nation, and world, but also respond to the demand for decreasing emissions. Texas is uniquely positioned to be a powerhouse of carbon capture. In order to create an environment that will attract businesses to invest in carbon capture in Texas, the creation of a clear and consistent legal, economic, and regulatory framework for the industry is absolutely critical. In particular, liability is key and should be resolved in statute rather than the courts. House Bill 4557 seeks to prohibit governmental entities and individuals from pursuing public nuisance claims that seek to impose policy decisions through litigation. It also declares that carbon dioxide is and does not constitute a nuisance, meaning that a plaintiff would not be allowed to assert in a lawsuit that even though the carbon capture operation was permitted and lawful, it nonetheless constitutes a nuisance that should be abated and for which damages should be paid. Nebraska and North Dakota have already made law providing carbon dioxide is not a nuisance. House Bill 4557 limits the recovery of non-economic damages, but not actual damages when the producer, transporter, or operator complies with governmental regulations. This allows a carbon capture operator who has fully complied with governmental regulations to not pay for damage for a claim like mental anguish, but would have to pay for the actual cost to rebuild a building or remediate polluted land. 4557 does not limit liability for events that are common for all businesses and industries, such as workplace injuries or contractual dispute. The committee substitutes makes several non-substantive technical corrections that were left out of the file version and strikes Section 2, which had broader implications than we originally intended. Additionally, as you might suspect, several stakeholders have come to the bill author over the last 48 hours, and we are actively engaged in constructive conversations to make the bill better. I look forward to their testimony today and continue to work with them in this committee to formulate the best policy moving forward. At the end of the day, the goal of House Bill 4557 is to contain fair and reasonable liability protection, to encourage industry compliance with safety protocols, while also deterring costly and time-consuming lawsuits that attempt to regulate the industry through litigation. With that, members, I would be happy to answer any questions or try to answer any questions you may have.
Thank you, Chairman Darby. Members, any questions? Okay. Thanks. You reserved your right to close, and there's a handful of witnesses here. I'm going to call panels of witnesses 4 at a time. When I do, if you'll just come join us here in front of the dais. The chair calls Corbin Robertson, Jonathan Grammer, Colin Layden, Jack Walker. Mr. Robertson, let's start with you. I've got you here registered twice, and so I just want to clarify the record. I have you, it's Corbin Robertson, testifying for House Bill 4557 on behalf of the Carbon Neutral Coalition. I also have you registered, go to this one, registered on behalf of yourself. Is that correct?
That's correct.
Okay. All right. We'll just, so CNC stands for the Carbon Neutral Coalition, I assume?
Yes.
Is that correct? Okay. All right. Just wanted to clarify the record. If you'll, you're recognized, so go ahead and start your testimony. Thanks for being here.
Chairman Leach and committee members, my name is Corby Robertson, and I'm the chairman of the Carbon Neutral Coalition. CNC is a coalition of diverse group of stakeholders. It includes former state office holders, academics, industry representatives working towards the goal of creating a carbon capture industry in the state. I'm here today in support of the committee's substitute for House Bill 4557. Thanks to Representative Darby for sponsoring this legislation. I applaud Representative Drew Darby for filing this bill to prevent the abusive and frivolous litigation against the oil and gas industry and other companies engaged in the capturing and storing of CO2 emissions with carbon capture, utilization, and storage technology. Carbon capture can enable the fossil fuel industry to produce affordable, reliable energy the world demands, reduce carbon emissions, and innovate and lead in the new energy frontiers. There are many current uses of CO2 and many others in research and development. Other states are jumping ahead of Texas in the competition for energy expansion by supporting carbon capture projects. By encouraging investment here in Texas, the state can continue to be the nation's leader. When deciding whether or not to invest in a state, liability protection play a critical role. CNC's goal is to ensure that Texas remains economically competitive when it comes to energy projects. This legislation will send a strong message that Texas stands by the energy industry and wants to spur new development. Texas should enact this legislation in order to facilitate the development of carbon capture, utilization, and storage projects that will benefit both the economy and the environment. The regulatory framework for carbon capture should include reasonable liability protection provisions that will require industry compliance with safety and monitoring measures, while also preventing abusive litigation against the companies engaging in this new industry. This bill does not eliminate nuisance, or does that by eliminating nuisance lawsuits, but it also allows for private lawsuits for damages on CCUS projects. Affected parties have rights, but frivolous lawsuits cannot stop development. It also addresses the limits of non-economic damages for CCS operators, providing protections for CCS operators and others as long as the operator is acting according to the EPA's strict government and permitting regulations. By ensuring liability protection, Texas will encourage investment in carbon capture, utilization, and storage. We understand that there are some concerns on specific provisions in the bill. These have been brought to our attention by the cattle raisers and land and mineral owners. As a mineral owner myself, and because Carbon Neutral Coalition has a diverse advisory board that represents those interests, I understand and respect their concerns and would support the changes to make this an even stronger bill. They are our partners in the future of carbon storage in Texas. As Texans for Lawsuit Reform Foundation stated as a recent research paper, many states in the U.S. already have operational CCUS technology and facilities, and accordingly, statutes and regulations governing their use and operations. These regulatory schemes are intended to encourage development of climate-friendly technology, while also safeguarding the viability of the energy industry. Enacting similar legislation and other liability controlling measures in Texas would promote development of CCS projects that will benefit both the economy and environment. Texas, in particular, is positioned to become the world leader in CCS due to the state's vast geologic storage capability, both onshore and offshore, and the expertise that already exists in the state from the oil and gas industry. Investments in CCS projects in Texas will create jobs, reduce emissions, and ensure the viability and the future of the energy industry. Thank you for your consideration of this important bill. Are there questions, Mr. Chairman?
Thank you, Mr. Robertson. Members, any questions? I don't have any. Representative Suit? No. Thank you for your testimony. The chair calls it Jonathan Grammer. I've got you here testifying on behalf of U.S. carbon capture in support of House Bill 4557.
That's correct.
Okay.
Thank you, Mr. Chairman, members of the committee. My name is Jonathan Grammer. I'm here testifying for House Bill 4557 on behalf of U.S. carbon capture. Beginning 10 years ago, our company began examining the carbonate formations of the Anadarko Basin for its potential to receive and store anthropogenic carbon dioxide from the over 6 million metric tons being emitted within a 125-mile radius of Amarillo, Texas. At present, we have 3 large pilot projects approaching 35,000 acres in pore space in the Palo Duro and Anadarko basins in West Texas and the Texas Panhandle, as well as the Carrizo-Wilcox Saline Reservoir southeast of San Antonio. For these, we have ongoing discussions with emitters ranging from natural gas power generation units, concrete, brick, and steel plants, as well as oil and gas refineries for emissions approaching 6.5 million metric tons per year. Based on our experience, if Texas is to move forward with Class 6 sequestration onshore, the issue of not only long-term liability, as is being addressed in House Bill 4484, but also the issue of liability for migrating carbon dioxide within and from the subsurface are the primary discussion topics keeping many of the emitters from embracing and committing to carbon capture and storage as a method to achieving net zero. For while proven oil and gas fields have known seals, mostly in the form of shale in Texas, the saline reservoirs of Texas and other carbonate formations with appropriate porosity do not have such proven seals to that extent. A storage project with annual commitments of 4.5 million metric tons per year over 30 years has the potential to migrate 3.5 miles from epicenter for a single injector. Even with the proper pressure management, monitoring, verification, and reporting, given the unknown fluid and pressure dynamics of the subsurface, the relatively unknown sciences of Texas's saline reservoirs, the potential for subsurface trespass of CO2, which is known for its buoyancy, is quite large, even though we believe its impact could be quite small. If properly managed in a controlled reservoir with an appropriate confining layer, carbon dioxide can remain safely for a millennium. Despite these scientific facts, those seeking to invest and engage in the deployment of carbon capture and storage in Texas are, as of this hour, still relatively hesitant to advance towards net zero without reassurance of protection from any potential liability for migration upward or outwardly in the subsurface of their injected carbon dioxide reservoir. It is my hope that this legislation will assist in alleviating this hesitancy and moving carbon storage as well as pursuit of net zero forward for the state of Texas. Thank you very much.
Excuse me. Thank you, Mr. Grammer. Members, any questions? Thanks for your testimony. The chair calls Jack Walker. Jack, I've got you here testifying on behalf of the Texas Trial Lawyers Association against House Bill 4557. Is that correct?
That's correct, Chairman.
Okay, go ahead.
Mr. Chairman, Madam Vice Chair, members of the committee, my name is Jack Walker. I'm the Vice President of Legislative Affairs for the Texas Trial Lawyers Association. I'm here to testify against House Bill 4557. First of all, I want to thank Representative Darby for meeting with us to discuss our concerns about the bill. We are committed to work with Representative Darby to address some of the issues that I'm going to talk to you about today. I want to start by saying this. Captured carbon dioxide is a good thing, and we are in favor of all efforts to combat global warming and the effects of excess CO2 in our environment. But we must all insist that these efforts be conducted safely and not in a manner that could cause more harm than good. This bill seeks to limit causes of action and damages available to injured parties and landowners who are or could be damaged by carbon captured dioxide activities. First, we need to understand what we mean by captured CO2. It's not CO2 in the traditional sense of the word. This bill defines carbon dioxide very broadly. It's not simply a carbon atom combined with 2 atoms of oxygen. It goes beyond that. The definition of CO2 in the bill includes phases, mixtures, and combinations of carbon dioxide that include substance incidentally derived from the source and substance added to the carbon dioxide stream to enable or improve storage. This is going to include substances like benzene, toluene, xylene, and every other dangerous material in the carbon chain of petrochemical production. The process of capturing and storing CO2 is relatively new, as admitted here today. This is a new industry. It's dangerous to grant upfront immunity to an industry where we don't fully understand the scope of the potential liability. One of the stated goals of this bill is to place limitations on non-economic damages, but not actual damages. However, the bill specifically eliminates nuisance claims by stating a person may not bring a nuisance action or similar cause of action on the basis of capturing and storing CO2. I'm going to revisit an argument or a statement I made before in the nuisance bill. Nuisance is not a cause of action per se. It's an injury. So there's confusion in the bill. Therefore, it's confusion by saying we don't bring a nuisance cause of action. It is an injury. The damages available for the injury of nuisance include economic damages, the cost of cleanup, the cost to abate, the cost of future injuries, future harms. These are all economic damages that the bill purports not to address or not to eliminate. But if you eliminate the injury, you take away the ability to recover the damage. In this case, potential significant economic damages. The second point I want to make is transport. The transport of CO2 during the process of capturing and storing carbon dioxide. The definition of a defendant is overly broad, as it includes not only the process of storing CO2, but extends the protection of the statute to transport of CO2 to the storage facility, whether it be by pipeline, truck, train, or boat. Remember, we're talking about potentially dangerous materials, and the materials that we're talking about have the greatest potential to cause injury during the transport process, not when they're stored, but when they're being transported. And while we would grant immunity to those in the transport process and then take away their rights for cause of action. Mr. Chairman, I'll end my testimony there and take any questions.
Okay. All right, thank you, Jack. Members, any questions? Okay. All right, Chair calls, is it Colin Layden?
That's right.
Okay, Colin, Mr. Layden, I've got you here on behalf of the Environmental Defense Fund testifying against House Bill 4557. Is that correct?
That is correct.
Okay, go ahead.
Chairman, members of the committee, Colin Layden on behalf of Environmental Defense, here to testify in opposition to HB 4557 and the committee substitute. And thank you, Chairman Darby, for sharing that with us. Carbon capture and storage is a critical climate change solution and a technology that can bring significant economic benefit to Texas. Texas will be a major center of this activity due to its favorable geology and the presence of existing infrastructure. For Texas to do CCS right, there needs to be a legal framework that is commercially reasonable, gives developers incentives to do high-quality work, and satisfies the public that CCS will be safe and effective. Because of this, we believe it's harmful to the geological storage industry, carbon management industry at large, and most importantly, the safety of citizens of the state and their personal property and natural resources to offer extraordinary liability and responsibility limitations included in this bill. We'll be granting tort liability protections for CCS that the industry does not have for all its other operations, production wells, saltwater injection wells, et cetera. While we and the industry believe CCS can be done safely, accidents do happen. Sites can leak in certain circumstances. Projects can induce a meaningful seismicity. Pipelines can rupture. In short, safety isn't 100% guarantee, and engineered projects fail. Further, it's feasible, if not likely, that incidents that occur will not always be tied to intentional concealment, misrepresentation, of falsification of information in the permitting process, which is the lone scenario in the bill where an injured party could potentially seek damages for impacts to them or their property. EDF believes that this creates a moral hazard for industry, establishing a scenario where operators are not incentivized to pursue diligent operations and outcomes that protect not only the climate, but also other operators' activities, groundwater, public safety, and personal property. Additionally, granting these extra liability and tort protections could diminish public support for CCS. On the one hand, industry is telling the public that CCS is safe, but on the other hand, this legislation suggests it's not. This disconnect is likely to further damage public confidence in CCS activities. Thank you, and happy to answer any questions.
Okay. Thank you, Mr. Layden. Members, any questions? All right, thank you each for your testimony today. Chair calls Lee Parsley, Philip Riley, Nicholas Miller, and Arthur Earl. Hold. Mr. Riley, if we can start with you. I've got you testifying on behalf of Riley Exploration, Permian Inc., and the Carbon Neutral Coalition, and yourself in favor of House Bill 4557. Is that correct?
Yes, sir, that's correct.
Okay, you can start your testimony.
All right, thank you, Chairman Leach and committee members. Yes, I'm here in support of 4557. My name is Philip Riley. I'm the CFO for Riley Permian Exploration. We are an oil and gas company focused in Texas. We've got a core asset in Texas and produce oil and gas, but we're also focused on oil and carbon capture and storage projects. We're not doing this because we have to, but because we want to be good stewards, to set an example among energy companies, and to pursue new business ventures as a logical extension of our core business. Mr. Robinson, Representative Darby spoke about the many positive qualities. I'll state a few more and my own point of view on some of the risks there. A quick, simple, but I think profound statement. Energy companies should lead the energy transition. We shouldn't leave this to the new startups on the West Coast and East Coast. Texas energy companies have vastly more experience handling gaseous molecules, storing them, probably more than all the other companies in the other states combined. As Mr. Robertson stated, Texas is positioned to become a world leader in CCUS. We've got the vast geologic storage. We have the largest concentration of CO2 pipelines in America. It really makes sense. It's going to create jobs, reduce emissions, ensure the viability of the energy industry. However, these deals are tough. There's lots of parties involved. They are new. We acknowledge that. They are complex. We're talking about storing a gaseous molecule about 2 miles under the ground. You have many controls and regulations to keep that in check, but it's an imprecise science when it's that far down. We think the bill helps quantify some risks here. One of my core jobs as a public company CFO is to manage risk. We want to pursue these deals, but we can't do so purely out of charity, and we need to understand that level of risk. So the legislative regime on these type of projects, it's developing, but there's still some gray areas. And so we think the legislation would help to increase the ability of investors to quantify those risks associated with it. I also think it would help Texas to keep pace with some of these other states. Louisiana has put a cap on non-economic damages. Nebraska, North Dakota, they've passed laws clarifying that CO2 is not a nuisance or a pollutant. And then finally, I think this helps to discourage progress through litigation. You know, these type of projects are always subject to complaints and litigation to disincentivize development via the trial or litigation. We think these can be done, CCUS and CO2, in and of themselves. It's not a nuisance when operated in compliance with the laws and regulations. Thank you for your time and your support.
Okay, thank you, Mr. Riley. Members, any questions? Okay, the chair calls, let's go with Nicholas Miller. Mr. Miller, I've got you here on behalf of the Texas Land and Mineral Owners Association testifying against House Bill 4557.
That's correct.
Okay, go ahead.
All right. Thank you, Mr. Chairman and members. Yes, my name is Nicholas Miller. I'm here today representing the Texas Land and Mineral Owners Association against House Bill 4557. A lot of what I'm going to say has already been mentioned today. We certainly respect the need for new industries to avoid frivolous lawsuits that may tie down, especially the oil and gas industry or anything related there too. That said, because this is such a burgeoning and new industry, we think that the limitation on non-economic damages goes far too far. We imagine a potential scenario where one of our members, who are all surface and mineral owners and who will be the ones primarily affected by carbon capture, at least on the land side, being injured or perhaps killed by the potential explosion or some other potential inadvertent consequence, and don't think that their non-economic damages should be limited in that respect, or the estate of someone who may have passed away due to some sort of unforeseen accident. The industry has a long way to come. We were very excited about it. We think that this is going to be something that can be very good for our clientele as well as for the state of Texas. We just think it is inappropriate and goes too far to limit the non-economic damages. We also understand that there's a lot of discussions going on about the language in the bill and that it is unlikely to look just like it does today. And we really appreciate those conversations. And we'll continue to have those as we move forward in negotiations. Thank you.
All right. Thank you, Mr. Miller. Members, any questions? Okay. Lee Parsley. Lee, I've got you here registering on behalf of Texans for Lawsuit Reform in favor of House Bill 4557. Is that correct?
Correct. Good afternoon, Chairman. Lee Parsley on behalf of Texans for Lawsuit Reform in support of House Bill 4557. During the interim, TLR Foundation did some study of carbon capture and storage laws throughout the United States. We published a foundation paper, which is lime green, and you probably have in front of you by now. It discusses the industry nationwide at this point. I think the paper details pretty well what other states are doing. There are 6 states that are currently dealing with the regulatory environment and the statutory environment for liability related to carbon capture and storage: Louisiana, Indiana, Montana, Nebraska, North Dakota, and Wyoming. And their liability schemes all provide that once the carbon is captured and stored and the permit and the site is closed, that the state takes over liability for that. But what the other states are not really doing that would put Texas ahead of the curve in this industry is the other states are not talking about the liability risk that exists during the time between when you start the site until you cap it and you turn it over to someone else. And Chairman Darby's bill then, I think using the foundation paper, at least in part, has created a liability regime for that period of time, which is when I think you would have some liability risk. The bill, as you all already know, does not eliminate damages from anyone who is injured or has their property injury. It just doesn't do that. It provides for economic damages, which means the person is supposed to be made whole for whatever their injury is. But if the industry, into the person storing the carbon, running the site, has complied with the law and is complying with the regulations that are in place for that person, then there would not be non-economic damages or punitive damages if the carbon leaks unexpectedly, or if the carbon transmits outside the site and therefore is an underground trespass, or if it's injected and potentially causes a rumbling of the earth, for example. So these are things that need to be addressed in the liability scheme, we believe. We think that it encourages industry to comply with both statutes and regulations by giving them some protection if they will do that. And so what you hope for is a robust regulatory regime and the industry in compliance with that robust regulatory regime that then helps develop an industry in Texas that potentially is worth multi-billions of dollars and has some positive benefits on the environmental side potentially too. Thank you and happy to answer questions.
Members, any questions? Okay, thanks, Lee. Appreciate you being here. The chair calls Arthur Ohl.
Yes.
Okay, Mr. Ohl, I've got you here on behalf of the Texas and Southwestern Cattle Raisers Association testifying against House Bill 4557.
That's correct. Thank you, Chair Leach, Vice Chair Johnson, and members of the committee. My name's Arthur Ohl. I'm appearing here as president and on behalf of the Texas and Southwestern Cattle Raisers Association, which opposes this bill as introduced. I'm also an attorney at the law firm of Wool Fitzsimmons, PLLC,
which handles oil and gas and natural resource matters for landowners and mineral owners across the state, including this type of CO2 storage agreement. And I'm part of family ranching business headquartered in San Angelo. The mission of the cattle raisers is to protect the stewards of land and livestock in Texas and the Southwest. That's why we oppose this bill, because we believe it will unfairly harm landowners. No one should argue with the conceptual benefit of carbon storage. But this bill attempts to benefit private CO2 storage companies at the unreasonable expense of surface owners, mineral owners, and mineral operators. There are two broad conceptual concerns that we have. First, this bill creates an unreasonably, perhaps impossibly, high burden of proof which a land or mineral operator must hurdle in order to have any meaningful recourse at all against a storage operator which has prevented or impeded access to water or minerals. As you can imagine, economic damages on account of a lack of access to water or to minerals will be very difficult or impossible to quantify, much less prove up, leaving the harmed parties without recourse at all. And there's also the difficult fact question of whether access to water or to minerals is actually impaired or prevented, or to what extent. Second, this bill would cut off private contract rights and obligations which are negotiated at arm's length between a landowner and a carbon storage company. Because this bill, at least as introduced, does not say that it will not impair private contract rights, it would have the effect of relieving a storage operator of liability to which it is contractually agreed, thus depriving the landowner of bargained for contractual protections. And there are other concerns we have about this bill. First, the storage operator is not required to notify the landowner of what additional substances are added to the CO2 stream, or even identify what those substances are. And there's no requirement that the stream not include any pollutants or contaminants. Second, the bill shields not only the CO2 storage companies, but also CO2 producers and transporters as well, even though it is not stated whether the CO2 generator or producers will be subject to the scrutiny of the storage permit application or subject to the storage regulation. Finally, the surface owner itself is not protected from liability from a leak or other damage from CO2 or related pollutants, but it should be, because the landowner will not be the party that caused the harm. We respectfully submit that the special benefits that this bill confers on private storage companies is not only unnecessary, because the free market right now is working just fine. We handle, and there have been plenty of these contracts, and there are many being negotiated now. Texas does not yet have primacy for Class 6 carbon storage wells from the EPA. So it's not only unnecessary, but instead will harm land and mineral operators. So in summary, because this bill unfairly subordinates land and mineral interests to private storage company, we oppose its passage. Thank you for your consideration.
Okay, thank you, Arthur. Members, any questions? Yeah, Representative Sue.
You raised very, very interesting points. You know, it's been a while since I've looked at this, but, you know, isn't it, if you have a contract that sets forth rights and remedies of the parties, that can provide additional rights and remedies that would otherwise be precluded by statute or tort law. That's my understanding. Is that right?
Not necessarily. And in most laws that, such as another law that's being heard, or another bill that's being heard today, specifically provides that it does not impair any private contract rights.
Is that clause, is it put into the statute itself, or is that one of those provisions that we kind of throw at the back of the bill right at the end where it's not underlined? It just says, I think, you know, this cause of action doesn't apply unless it accrued after the date of the statute. You know what those look like?
Well, I don't think it matters where in the bill it is, but it should expressly be stated.
And then I think your second issue was regarding the loss of access to water, which is, and correct me if I haven't memorized the bill, but there's 3 prongs, and one of which is number 3 on page 6 that talks about if only if the aspect of the defendant's conduct, oh no, maybe not that one. But tell me a little bit more about why economic damages would not be available if they impede, impair, or block your access to subsurface water.
I think that that's primarily because they would be very difficult to prove, very difficult to quantify. For example, if a mineral operator has got a strata of minerals that it wants to drill to, but it can't because it can't because of the carbon storage facility, well, then it'll have to sue for economic damages. But what are your damages? How can you prove that that well that they would have drilled would have been successful? How can you tell what their, percentage of, a return or capture of the percentage of the reservoir would have been? It's the difficulty of proving them up and quantifying that makes this a problem.
Okay. Thank you very much.
Chairman Murphy.
Mr. Rule, it's good to see you. Since you practice in this world a little bit and you've already had exposure to these types of activities and negotiations between landowners and what's going on, and I'm asking you a big picture question, do you perceive that the state should step in? Essentially, we're always reactive. We're never that proactive. We always wait for something to happen, and then as policymakers, we try to attend to it. Mm-hmm. Do you perceive that this is some area that the state should weigh in on a policy level to some degree to provide some uniformity and some constraints or guardrails about what's going on?
Yes, I think it has. There's current, and it already has. The state is already, has a law which gives the Railroad Commission the jurisdiction over this matter. It's already filed for its EPA primacy. There already is somewhat of a regulatory scheme in place, even though this industry is in its infancy. So what we're saying essentially is, and the point's been made earlier, because it is in its infancy, there is still a lot that is not known, certainly a lot that's not commonly known. Why are we rushing to exempt these parties from liability when assumably it's so safe? Let's study it a little more.
And then the only other question I have is I respect the bill author a great deal, and you mentioned in your testimony that you were in opposition to the bill as filed. I didn't know if you've had discussions with the bill author about any recommendations to make changes to it, because your input's valuable, and there's an entire industry that you represent that deals with the land. So I know that that's a weighty issue for all of us to deal with. So have y'all had some dialogue, and do you expect to continue dialogue?
Yeah, and I have had a brief opportunity to speak with Chairman Darby, and he assured me that he would share the committee substitute and give us cattle raisers as well as other stakeholders an opportunity to comment on it and review it, and I appreciate that opportunity and being part of that process.
Thank you. I appreciate your time.
Members, other questions? All right. Thank you, TG.
Thank you.
Appreciate you being here. Chair calls Bruce Gates, Charles Maley, Sarah Stogner, and Ashley Watt.
I think Mr. Gates is in SB 2107.
Sarah had to head out too.
Okay, hold on.
Is it 2107?
Okay. Ms. Watt,
Yes.
I have you here on behalf of yourself on House Bill 4557. Is that correct?
Against.
Okay, so we need to correct the record here because it says on. So you want the record to reflect you're Ashley Watt, you're testifying on behalf of yourself, and you're testifying against House Bill 4557.
Correct.
Okay, you can go ahead.
My name is Ashley Watt. I'm a fourth-generation rancher in West Texas. We have extensive holdings across Ector, Ward, Briscoe, and Crane County, which is now in Representative Murr's district. So I'd like to invite you to come out and see it sometime on the far western edge. I would hazard to say I am probably the single landowner in the state most familiar with subsurface problems would be a euphemism, blowouts, disasters, catastrophes, not carbon dioxide produced water. And I'm excited about carbon capture. It's a new line of business for us and potentially very lucrative. But I think what all the people testifying for this bill are missing is this vastly disincentivizes landowners to ever enter into these contracts. If this is passed, I'm not crazy enough to sign a carbon capture bill. I'd be an idiot to do so. I have no recourse if it goes wrong. So there will be a lot of business that never happens because no sane landowner is going to agree to this. That's the first thing. The second thing, and this is a point to Representative Darby and something he mentioned, our problems now are produced water from Chevron, and it's our aquifers, and it's 22,000 acres that are just gone, just ruined, unusable for anything. And I thought I was being reasonable by just asking that to be cleaned up. I don't want money. I don't want the trial lawyers to get involved. I want to go back to ranching and sitting in the desert and doing nothing. But cleaning up 22,000 acres costs $1 billion, give or take. And so these companies then invoke the economic feasibility doctrine, where they don't have to spend more to clean up the land than the land is worth. And so anytime that there's a problem with one of these issues, it will cost more to clean it up than the land's worth. So they're just going to buy out the landowner. So passing this bill is a fast track to oil and gas and carbon capture companies eventually just owning all of West Texas. Like, that is what this bill leads to. I don't think people are thinking through the consequences. And then third, I would argue no one up here testifying for this bill actually drinks well water and is putting CO2 under land that provides that well water. Like, until you've had your water wells come up salty and bubbling and sulfurous and you have felt earthquakes, that is biblical in nature. This is potentially a good industry, but to say that there's unknowns is an understatement. And so this bill wants to handicap any legal remedies off the bat for that we're way ahead of the horse. And this has been brought up, but why is CO2 so special that it gets a separate set of treatment? We don't give dry cleaners state coverage on their land after they're done. We don't give gas stations state coverage, and those are important industries too. We don't give trucking state coverage. Like, all of this should fall under the courts. We have a good court system. Why is carbon different than everything else? With that, I welcome any questions.
Members, any questions for the witness? Okay, thank you for your testimony. Is it Charles Maley?
Yes, sir.
Is that right?
Yes, sir.
Okay, you're here testifying on behalf of yourself and the South Texans Property Rights Association against House Bill 4557.
That is correct.
Okay, go ahead.
Good afternoon, Chairman Leach and members. My name is Charles Maley, and I'm the Advocacy Director for South Texans Property Rights Association, testifying against House Bill 4557 as drafted. With a membership base representing some 6 million acres of private agricultural land across South Texas, STPRA is a leading advocate for the rights of property owners. We advocate not just for their rights, but also the understanding that property rights are the most basic foundation upon which a free nation is built. When an assault is pursued upon those rights, it is a very foundational liberty that this state and nation were built upon that suffers most. House Bill 4557 is itself perhaps the best argument against fast-tracking CO2 injection projects, which is what this bill's cousins, House Bill 4484 and Senate Bill 2107, would aim to do. Any endeavor that needs this much state-granted liability protection just so the businesses involved can pocket millions of federal dollars while ignoring the rights of private landowners should definitely not be further incentivized. The Inflation Reduction Act, which we all know did nothing to combat inflation, should not now become an excuse to trample on private property rights. The language of the bill clearly assumes that there will be multiple problems in the actual process of geologic sequestration, and they want you to let them off the hook even before they start drilling. The bill cites the need to relieve them of liability for leaks, migration of gases, which in layman terms means trespass without compensation, and even earthquakes that might occur. Earthquakes? That sound familiar to other industry-related injection processes? The bill also tries to define CO2 as harmless, and in its natural form, we agree. In fact, it's plant food, and it is an absolute necessity to healthy grass, trees, and soils. But what happens in 10 years when we find out that the air scrubbers used to collect this plant food out of the air actually are depriving neighboring lands of the necessary CO2 for healthy plants and soils? Under this bill, I see no recourse. Can we table this idea of running over Texas landowners and depriving them of recourse, and perhaps consider that the natural carbon cycle works and is the most efficient, cost-effective, and universally accepted way to deal with CO2? Texas private grasslands and forests are the single most significant contributor to clean air, clean water, and healthy soil and healthy food and fiber, based on recent studies by the Texas A&M Natural Resource Institute. Landowners should be incentivized to continue to improve their land management activities rather than being threatened with one of the largest state-sponsored takings since the Trans-Texas Corridor. Across South Texas, as already mentioned, there are already responsible operators that are signing up landowners in freely negotiated deals that assume their appropriate levels of future responsibility under existing law. It's the marginal operators that need this kind of help, and it's the marginal operators that end up going broke and walking away from a terrible mess every time. Marginal operators chasing millions in fast federal cash are private property rights and fair recourse.
All right, thank you. Are there any questions, members, for the witness? All right, thank you both for your testimony. Is Sarah Stogner here?
She's not.
Okay, thank you. Mr. Gates, are you here? Bruce Gates? Sarah Constantine? Okay, Sarah, I've got you registered on behalf of yourself testifying on House Bill 4557.
I'm testifying against it.
Okay, we need to correct your registration. I want to just remind everybody as you're registering at the kiosks for, on, or against any bill to please be careful to correctly identify your position on any bill. So to correct the record, Sarah, you're Sarah Constantine, you're here on behalf of yourself, and you're against House Bill 4557.
That is correct.
Okay, you could begin your testimony. Thanks.
Good morning. My name is Sarah Constantine. I'm testifying in my capacity as a licensed professional engineer in the state of Texas, with an undergraduate in petroleum engineering, close to 20 years of relevant professional experience in both geology and petroleum engineering. I think I'm actually the only professional engineer you'll hear from today. Now to be clear, I'm for the Texas oil industry. In fact, I currently have a high-dollar drilling rig running right now in the Eagle Ford Shale. So I am very much for the Texas oil industry. However, I am not for this bill. As we have seen in West Texas, injection of fluids, which by the way, gas is a fluid, has resulted in all sorts of unintended consequences, including subsurface and surface blowouts, corrosion, pollution of the water table, lakes of brine on the surface of the earth, and most recently, major earthquakes. CO2 being injected into reservoirs can result in the same issues. CO2 as a gas can migrate. We just heard previously in testimony how it can migrate several miles. I'm aware of multiple cases where CO2 has actually traveled along fault lines and ended up in other operators' fields. It can form precipitates, and combined with water, it can form an acid that will corrode away casing, which acts as a barrier to protect aquifers. In fact, it is so corrosive in the presence of water, you need specialized pipe to handle it. There are also other questions about what happens to the CO2 after it is left there. Who owns it once a CO2 lease expires? Can it be used, produced beneficially at some point for CO2 injection for enhanced oil recovery? What happens when it enters an existing oil and gas field, which is not set up for it, that has 70-year-old casing that is already partially corroded? Absolving companies of all responsibility, as this bill does, is not the right answer. We need to address this issue with best practice in engineering, geology, and the law. This relatively short bill does not address any of this. We need a comprehensive task force approach. We are here in Austin, which has the highest rated petroleum engineering school in the world, of which I am a graduate of, and those Texas law grads aren't a far step behind. I think we can do a lot better than this, and I welcome any questions you may have.
Thank you for your testimony. Members, any questions? Okay, thank you. Does anyone else wish to testify on, for, or against House Bill 4557? Seeing none, the chair recognizes Chairman Darby to close on the bill.
Thank you, Mr. Chairman. As you can tell by the testimony, this is an important issue. A lot of people have important positions. I recognize that. I'm a strong proponent of private property rights. Clearly, these type of facilities will not exist without the consent of the surface owner. I think there's various legislation pending, but typically the pore space is under the control of the surface owner. So there will never be a storage facility that doesn't have the consent of the surface owner. And I appreciate Arthur Uhl. He's from San Angelo area and represents an important industry in my part of the world. And, you know, we have, I'm sensitive to that. And so to Cody's comments about contractual language, certainly this bill should include language that says if there's a surface use agreement or other contractual document that describes liabilities and responsibilities in addition to those in this statute, then certainly that needs to be honored. So we will continue to work with the stakeholders and try to arrive at a good point, and we'll come back with a bill that you can be proud of. With that, members, absent any questions, I'll...
Thank you, Chairman. Members, any questions for Chairman Darby? All right. Thank you, Chairman. The chair withdraws the committee substitute to House Bill 4557, and we'll leave House Bill 4557 pending at this time. Mike, you ready? Yes, sir. The chair lays out House Bill 3952. I'm sorry. Hang on. I'm sorry. The chair withdraws House Bill 3952. Yeah. The chair lays out House Bill 1179 and recognizes Representative Ramos to explain the bill.
Good afternoon, members. Thank you, Mr. Chairman, for the hearing today and for the opportunity to lay out HB 1179. This is a quick, simple bill. It's a refile. And what it does, it informs the public about the availability of provisions and protective orders, including provisions regarding pets and companion animals. Currently, when an individual is seeking a protective order, there's already provisions there allowing the individual to remove their pets and companion animals in the protective orders. And so what this bill does is just require that the Attorney General's office and the State Bar of Texas jointly develop information to provide for the public the details on who can be included in protective order. This bill came about a visit with the Dallas Domestic Abuse Shelter. And they're in that space, they have certain areas where an individual family can take their pets with them and house their pets with them while they are in the domestic abuse shelter. And what we found, or what they informed us, is that a lot of individuals don't know, and children are scared to leave their home when they can't remove their pets and companion animals with them. And so many times they stay in a domestic abuse situation because they're not able to remove their pets. And so what this does is make sure that people are adequately informed about that. And I do have some witnesses here. With that, I reserve my right to close.
All right, members, any questions for Representative Ramos? Okay. Yeah, you've got several witnesses here. We'll call you again in panels of 4. We've got 7 witnesses total. So the chair calls Hillary Shurtleff, Stacy Sutton-Kirby, Murray Betcher, and Delia Jasso. Ms. Shurtleff, let's start with you. I've got you here registered on behalf of Texas Pets Alive for House Bill 1179. Is that correct?
That's correct, yes. Thank you so much.
Sure, you can start your testimony.
Okay. My name is Hillary Shurtleff, and I am testifying in support of HB 1179 on behalf of Texas Pets Alive. We want to thank Representative Ramos and the other co-sponsors for bringing this important bill forward. Texas Pets Alive advocates for legislation that keeps families together, and according to a recent survey, 95% of pet owners consider pets family. Research from the National Coalition Against Domestic Violence indicates that up to 65% of domestic violence victims delay leaving a dangerous situation because they don't know where to place or how to protect their pets. This percentage is a staggering number that this bill would impact directly. Texas has already taken the important and meaningful step to include pets in protective orders. HB 1179 builds upon that great work by implementing a framework to ensure people experiencing domestic violence are made aware that protective orders encompass pets. The Attorney General and the State Bar of Texas will jointly develop the information to be distributed by prosecuting attorneys. Learning that this protection exists may be the final barrier for individuals who are fearing for their lives to feel empowered, take action, and escape. The Human Animal Support Services Project states that when an individual or family flees domestic violence, it is important to offer resources that provide safety for both the family and the pets. Their pets, excuse me. For these domestic violence victims to break a significant emotional bond and depart with a pet due to a mere lack of awareness is unnecessary and only compounds the trauma of the situation. In fact, up to 71% of survivors said pets had already been harmed or killed. Those experiencing domestic violence have already endured extensive trauma, and their anxiety and willingness to leave is only exacerbated by the fear of their abuser harming their pet. Passing HB 1179 will allow these victims a peace of mind when fleeing a dangerous situation. We respectfully ask that you vote yes, as it will amplify protections already in place for the most vulnerable populations across our state. Thank you so much.
Okay, thank you. Members, any questions? Okay, thank you, Ms. Shurtleff. This chair calls Stacy Sutton Kirby. Ms. Sutton Kirby, I've got you here on behalf of the Texas Humane Legislative Network and yourself in favor of House Bill 1179. Is that correct?
That is correct.
Okay.
Thank you. Good afternoon, Chair, Vice Chair, and committee members. Stacy Sutton Kirby, Director of Government Relations for the Texas Humane Legislation Network. We're a 45-year-old animal welfare nonprofit that focuses exclusively on policy and legislation that protects Texas animals and their people. Since 2011, when our organization partnered with the Texas Federation of Animal Care Societies to help pass the original Pets in Protective Order legislation, Senate Bill 279, we have promoted this option for victims of family violence with pets. When pets are not in protective orders, abusers continue to use the pets as a way to control victims and inflict pain. I think you're going to hear plenty of testimony on that. I would like to speak to the scale of the problem. 2/3 of households have pets, and 1/3 of American adults will experience some form of domestic abuse or partner abuse in their lifetime. We know that the link between animal abuse and domestic abuse can be deadly. A 2017 study showed that 89% of women who had companion animals during an abusive relationship reported their animals were threatened, harmed, or killed. And one study showed that the death of a companion animal by one's domestic partner was one of the highest predictors of lethality, meaning one of the highest predictors the abuser would escalate to killing the partner. Children who witness pet abuse are 5 times more likely to commit violence against animals and other humans, including pets in protective orders, is something that the state has already said is possible, but victims don't often realize that they have this option. 37 states, including Texas, give this option to victims, but a national study showed that domestic violence intake interviews do not typically involve questions about pets. Because of that, folks don't realize they have this resource, they have this legal tool to help keep their pets and their families safe. While victims are often given information about other resources, for example, special needs populations like folks with disabilities are given information about resources and assistance they can get. Talking with legal professionals during intake or with prosecutors is far less common. That's the gap that this bill fills, informing people of a right they have, but they don't often exercise because they weren't asked a simple question. I'll continue just to say the next logical step is to inform those in peril that they have this option so that we can keep more Texas families safe and prevent additional family violence and animal cruelty. We ask that you vote yes and support House Bill 1179.
Okay, thank you. Thank you for your testimony. Members, any questions? Okay, the chair calls Marie Betcher. Hang on. I have you here testifying on behalf of yourself and on behalf of the Austin Police Department in support of House Bill 1179. Is that correct?
Yes.
Okay, go ahead.
Yeah. Thank you, Chair. Thank you, Vice Chair and Committee. I'm testifying here today on experience From 1988 to today, I have served in clergy in Austin, Texas, and for the last 10 years as a chaplain and now senior chaplain for APD. Over these many years, I have seen and counseled so many women who have gone through domestic abuse. I, being a lover of animals, would always empathize when the woman would come in and there was a dog or a service dog or a pet that they were worried about. And many times over the years, this animal would be a pawn within the situation. As we all know, this happens. The fact that now that we can tell them, you can bring this animal with you, will just be such a help, because many times they think, well, I can't leave because my pet is there. I can't leave because I don't want anything to happen to my pet. That is definitely something that happens all the time. Doing ride-outs with the PD, hundreds of them, and my husband's a former APD officer, having seen in domestic violence cases when there is a pet or a service dog involved, the magnitude of the suffering that goes on between the wife or the children is just compounded because this tug, do I leave the dog, do I take the dog, or whatever the pet is. And yes, many times the spouse will take it out on that animal. So this bill is so important that these women know that they can take their animals with them, that they can save them, that they be informed. I am 100% in favor of this, and I hope and pray that you all vote for it.
All right. Thank you. Yeah, Chairman Murr.
I have a quick question for you. In all of your experience, and I know the language of the bill suggests that other parties will come up with draft language that would be applicable to the scenario. What type of outcome can occur because of the proposed language in the bill, in your experience? And I guess is, what do you want to happen? Do you want it to be where the protective order says that they can take their pet, or the protective order applies to the pet so that the pet is also protected? I'm just trying to wrap my head around that. Trying to figure out what are we solving?
Yes, not being an attorney, I wouldn't know how to word that. My goal would be that the woman that is seated there knows, yes, you can bring the pet with you.
Okay.
Because a lot of times they don't. And yes, that I've seen pets killed, so that pet is saved. I don't know how that would be worded. I'm not, you know.
So that in a short sense, it's when the discussion is occurring about what to do, the discussion also includes what to do with the pet.
I would hope and pray.
And that's
yes.
your experience
Yes.
and because you were able to incorporate that, but a lot of folks don't have the time or the understanding that might be something to discuss.
Yeah, yes,
Okay.
that's terribly important.
Thank you.
You're welcome. Thank you, sir.
Members, any other questions for the witness? All right, thank you and for your service on the Austin Police Department.
Thank you.
The chair calls Delia Jasso.
Yeah, Delia Hasso.
Hasso, okay. Hold on.
Thank you, Chair.
Hold on. I've got you here registering on behalf of the family place and yourself in support of House Bill 1179. Is that correct?
Correct.
Okay, go ahead.
Hello, Chair and committee. I know some of you. The data we have is actually from the American Veterinary Medical Association, and the last one is from the National Coalition Against Domestic Violence. 3% of domestic violence shelters have on-site animal kennels. 3% out of all the shelters in the country. 97% of survivors state that keeping their pets with them are a deciding factor in leaving an abusive relationship. 71% of pet owners entering a domestic violence shelter report that their abuser had threatened, injured, or killed their pet. Women in DV shelters are 11 times more likely to report animal abuse than those not experiencing violence. And from the National Coalition of Domestic Violence, 52% of survivors had to leave their pets with their abuser due to lack of animal kennels where they were going. So the answer is yes, we're in favor of 1179, House Bill 1179. The family shelter did the talking points. I personally have been on the board of the family shelter for 6 years. And my colleague behind me, Aaliyah Miranda, also is a board member with the family place, and she is also a survivor. And she wholeheartedly supports this bill. So I think the answer partly to Representative Murr's question was, we need the information to get to the clients. And if it takes the American Bar Association to work with another group to get that into maybe some of the judicial training, I myself am married to a judge, and I think that they would, accept this training in any of their CLE stuff. So it just needs to be highlighted. That's all.
Okay.
That's my testimony.
Thank you for your testimony. Members, any questions? Yes, Representative Flores.
Yes, just to reiterate Representative Murr's question and to clarify for myself, currently, am I understanding that you can include protection of a pet within a protective order? Yes. Currently. The problem is that victims don't understand that they can ask the judge to include that in the protective order. So we're asking basically for public awareness and knowledge. So they already can be, and that's already in law that they can protect their pets, but we want them to create information basically so folks can put out a PSA program about it or something, or I don't know. But okay, I just needed the clarification because I was a little confused, but thank you, I appreciate that.
Sorry. Are you done with your, members, any other questions for this witness? Okay, the chair, is it Ms. Sutton Kirby?
Thank you. My understanding
Hold on,
was...
I have to re-recognize you.
Oh.
The chair recognizes Stacy Sutton Kirby. You're already registered on behalf of the Humane Legislative Network and yourself for the bill. Is that still the case?
Correct.
Okay, you can go ahead.
I just wanted to dovetail that in response to your question, not only that public information campaign produced by State Bar of Texas in conjunction with the Attorney General's office, but that in the lower part of the bill that prosecutors would be required to do that. So not just the public information campaign.
All right. Members, any other questions for any of the witnesses? All right, thanks to each of you.
Thank you.
Appreciate you being here. The chair calls Aaliyah, pardon if I mispronounced that, Aaliyah Miranda, Sherry Soltez, and Zequias Castro. Miss Miranda, I'm gonna let you go. Miss Miranda?
Yes.
Okay. How do you pronounce your name again?
Aaliyah.
Aaliyah Miranda?
Yes.
I have you here testifying on behalf of the family place and yourself in favor of House Bill 1179. Is that the case?
Yes, sir.
Okay, go ahead.
Okay, well, my name is Aaliyah Miranda, and I am a board member of the family place. I've been in the board for 6 years. And I'm also just not support the initiative of the family place. I was also a victim, a former client of the family place. So I support it with all my heart. I am a domestic violence survivor. I was in an abusive relationship for 8 years until I was able and I had the courage to leave. I ended up at the family place emergency shelter. At that time, I had a 12-month-old baby and a 6-year-old boy. I also just had a high school diploma. And thanks to the help and support I received from the family place, I was able to build my confidence and my self-esteem. I then enrolled at a community college and received an associate's degree. I then transferred to UTA and received a bachelor's degree and later on a master's in education. I recently graduated with a doctorate in education from Texas A&M Commerce. So I just want to say that please continue to support initiatives like this because they do change lives. Our organization, the Family Place, already has a place for pets. It's just that, like one of the people were saying, there's not information out there. So the victims don't know that they're able to bring in, that there is a place for their pets. And the abusers often threaten or they harm their animals just to intimidate the victims. So we just need to inform and have more information out there so the victims can leave without feeling bad and having to leave behind their pets. So thank you.
Okay, thank you, Ms. Miranda. Members, any questions? Okay, thank you for your testimony. Sherry Soltez, I have you here on behalf of Service Dogs, Inc. And yourself in support of House Bill 11. Is it Service Dogs, Inc., Assistance Dogs International, North America?
And Assistance Dogs International, North America.
Okay. Okay, and yourself and your
There's
testimony
three of
in
us.
support of House Bill 1179.
Yes, sir.
Okay, go ahead.
And I want to leave 30 seconds to add to Representative Muir and Flores' question. I'll start with that. These are protective orders, so it's not always about taking the animal with you. It's about realizing the protective order, which tells the abuser hands off, includes the animal. Okay. Thank you, honorable members of the committee. I'm Sherry Soltis. I'm the founder and CEO of Service Dogs, Inc., a local 35-year-old nonprofit that trains service dogs for wounded veterans and other Texans living with disabilities free of charge, including people who are deaf, people who have mobility-related injuries like spinal cord injury, stroke survivor, Parkinson's. I also serve as chair of Assistance Dogs International North America. Assistance Dogs International is our global accrediting body. And as chair of ADI North America, I represent 105 accredited service dog training organizations and 15,000 users of guide dogs and service dogs just in North America, which we begrudgingly include Canada, but it's mainly the United States. I'm testifying in favor of House Bill 1179. Guide dogs and service dogs are lifelines to people living with blindness and other physical disabilities. In the home, they guarantee safety by alerting deaf individuals to sounds like the oven timer, door knock, phone, smoke alarm, baby's cry. Or if it's a service dog, picking up things someone in a wheelchair drops, like their cell phone, their keys, or even helping them up from a fall. In public, they guarantee full and equal access by guiding those who can't see, opening literal and figurative doors, and ensuring those who are deaf are aware of dangers like cars approaching in the parking lot, people on skateboards, or even their children calling their name. Psychiatric service dogs help military veterans with PTSD by nightmare interruption, turning on lights in a dark room, things like that. And they perform tasks that directly mitigate the traumatic aftermath of military service. HB 1179 will help wounded or disabled Texans who are veterans and others living with physical challenges navigate one of life's most traumatic and dangerous situations, domestic violence, with the full information about what Texas has already done to protect them. Thank you.
Thank you, Ms. Soltez. Members' questions, Chairman Murr.
Would you remind me again, I was reading actually about emergency protective orders when you spoke. What is your background? Are you in a...
Once upon a time, I was a civil trial lawyer and appellate lawyer. And
Right. So, and the reason I'm asking is because I was going to ask about specific sections of the code that relate to emergency protective orders. My familiarity with them, and in a different life, I actually prepared and granted those. So that's under the Code of Criminal Procedure, Article 17.292 talks about that. And so I know we actually haven't addressed that, but whenever you have someone, it could be the victim, the guardian of the victim, a peace officer, or even the attorney representing the state, can put those forward. And it's not prescriptive as to what the form looks like. It is prescriptive as to what the order says and how it's delivered. But what I don't know, and I don't know if we have resource witness, is I feel like there may be some model forms that have been drafted and prepared by the state for use for those, because I don't think that every justice of the peace sits down and makes up a form on their own. I think that they're out there. And so my question is, should our legislation that we're considering here not simply target that form and direct that specific language be included?
I think you said it with a negative, so I'm trying to make sure I understand. You said, should it not? So if you
Let me rephrase it. We're talking about trying to do something here that involves notice regarding a pet. Should we not consider just putting language directing the parties to consider that whenever they're going through the language that would ordinarily be in the form?
Well, it seems like whatever the solution is it most directly results in the victim knowing that they have their protective order can include this, however that mechanism is. I was a civil lawyer, so I didn't deal with this, and I just researched it on the phone while other witnesses were testifying.
Understand completely, and I'll just highlight one thing. So under that, it says that a magistrate in the order for an emergency protection may prohibit the arrested party from, 1, committing certain acts, 2, communicating, and then we list how that happens, going to or near, and we identify places, and then 4, possessing a firearm. And so there is a list there. I don't know the best way to go about addressing a pet or animals, for example, but it seems like that could just be part of that list, and then it gets addressed each and every time there's a discussion with folks about that, because there's always going to be a discussion about where do you reside, where do you work, does the person have access to a firearm, and we need to prescriptively include those. So I'm just going down the road to the heart of it, and you may not have comments for that, but your testimony took me there. So
thank you. It seems like you might as well cover all your bases, so do what they're saying in this bill and add anything else you think of. And we're all happy to help draft the language and enact it. And I also want to point out to everybody that this will also result in a fiscal benefit to different municipalities and counties, because it will save further incidents of domestic violence that have to be addressed by emergency services, law enforcement, and the courts. So besides being a humane thing to do, it's also a fiscally responsible thing to do.
And I understand that this is a very important issue to Representative Ramos, so she has a high priority for it. So thank you, Mr. Chairman, for indulging me.
Sure. Members, any other questions? All right. Thank you for your testimony. The chair calls, is it Zacchaeus Castro?
Zacchaeus Castro, thank you.
Zacchaeus Castro. Zacchaeus, I have you here on behalf of the SAFE Alliance, testifying for House Bill 1179. Is that correct?
Yes, sir.
All right, you can start your testimony.
Okay, first I would like to thank you guys for the opportunity to provide my testimony in support of House Bill 1179. My name is Zacchaeus Castro. I'm the family court legal advocate with the SAFE Alliance. Currently, I work alongside the Travis County Attorney's Office to provide court accompaniment for protective order applicants. I'm speaking on behalf of myself and my agency. The SAFE Alliance is a Central Texas nonprofit that serves survivors of domestic and sexual violence, child abuse, and human trafficking. Our mission is to stop abuse for everyone. We have worked in the field of domestic violence and sexual assault for nearly 45 years, and we have spoken with tens of thousands of survivors, providing them with a variety of services to assist with their safety and stability. The SAFE legal team serves over 1,000 clients a year by helping them navigate the criminal and civil legal system. Our clients share their fears about their abusers' control over themselves, their children, and their loved ones, including their pets. And they ask us, how can we keep ourselves safe? In a continually confusing world where survivors find themselves overwhelmed within their situation, it is imperative that they know their beloved pets do not have to be left behind. Those who use abuse threaten the safety of pets as a form of control and manipulation. Protective orders are meant to provide peace of mind for survivors and ensure that those who use abuse can be punished. Safety and security are what a survivor should expect once being granted a protective order. But failure to include pets within a protective order fails to adequately protect survivors. During my time within this field, I found myself encountering several instances where survivors are unable to access safety resources due to requirements necessitating they leave their pets. When I worked at a different shelter in a rural area, we often had many clients call in search of shelter for themselves and their pet. However, I would have to deny them entry into the shelter and give them a short list of shelters, about 10 different shelters throughout all of Texas, which will allow pets. This is a single example of a barrier to receiving services for survivors, but this happens far too often. When a survivor has a beloved pet, they should not have to choose between their own safety and the safety of their pet. When a survivor is reaching out for support and assistance, they should not have to worry about the safety of their pet. When a survivor applies for a protective order and gets one granted, they should already know that they can include their pet in that protective order, and they should not have to worry about the safety of their pet. The right for a survivor to be aware of their rights when it comes to the protection of their beloved pets is essential. I ask you to please vote in favor of passing House Bill 1179, as this bill will result in increased survivor safety, increased pet safety, and remove barriers that so many survivors face, choosing between their own safety and their pet safety. Thank you all for your time and the opportunity to share this testimony.
Thank you, Mr. Castro. Members, any questions for the witness? All right, thank you each for being here. Does anyone else want to testify on, for, or against House Bill 1179? Seeing none, the chair recognizes Representative Ramos to close on her bill.
Thank you. And the questions that you all highlighted, I think, emphasize the importance of why we need this information available, because the law already states that, but many of our committee members didn't even know that that was part of the provisions in our law. As a family law attorney, we, part of the, when you file a divorce or a SAPS or what have you, at the end of every pleading, when you file your petition, there's a standing order that says this is a status quo and it must stay that way. Part of that includes the pets and companion animals. So it's part of every divorce or what have you, but people still don't know. So what this bill is doing is ensuring that when you're in the prosecuting attorney's office, when you're seeking a protective order, that you are adequately informed that this is something that you can do. So the language is already there. The law is already there. What this simply does is make sure that people are informed. And Representative Murr, I think that would be a great idea, and I'd love to work with you on that to make sure that that's included as part of the initial application in the form, so that's not something that we miss when individuals are applying for that protective order. It's not, when you're in that space, in that headspace, it's not, there's so many things going on, but when you can be assured that you can include that protection for your extended four-legged family member, I think it would help a lot of families. With that, I close.
All right, thank you. Members, any questions? All right. Thank you for bringing that bill, Representative, and we will leave House Bill 1179 pending at this time. The chair now lays out House Bill 3696 and recognizes Chairman Landgraf to explain the bill.
Thank you, Mr. Chairman. I appreciate the opportunity to lay out House Bill 3696, which just very simply stated would commission a study through the Office of Court Administration to evaluate and search for opportunities for increasing the effectiveness of protective orders, specifically those that are issued in domestic or family violence cases. Happy to answer any questions or go into some of the background, but that's very simply what the bill does.
Okay. Members, any questions for the bill author? Okay. We don't have any. You have three witnesses who've registered for the bill, but none of them want to talk to us. So does anyone want to testify on, for, or against House Bill 3696? Seeing none, the chair recognizes Chairman Landgraf to close.
Thank you, Mr. Chairman. I wouldn't take it personally, but I close unless there are any other questions.
Members, any questions? Okay. We will leave House Bill 3696 pending at this time. The chair now lays out House Bill 3698 and recognizes Chairman Landgraf to explain the bill.
Thank you, Mr. Chairman. I appreciate the opportunity to lay out House Bill 3698. For those of you who were serving during the 86th legislative session, you may remember that we adopted through Senate Bill 325 the Texas Protective Order Registry, which is administered by the Office of Court Administration in consultation with courts across the state, and it allows the Attorney General's office, district clerks, county clerks, municipal attorneys, and law enforcement to access an online registry that includes information on applications for protective orders all across the state, regardless of any jurisdictional boundaries. There's also a public version of that same database that has been very helpful in being able to identify perpetrators of domestic violence that was very difficult prior to our adoption of that registry. In subsequent sessions, I've always been looking for opportunities to update and make sure that that registry is working well for the public as well as for other stakeholders. So House Bill 3698 updates that registry and the law that operates it in a couple of ways. First, it provides the public with the ability to search the protective order registry by any commonly known name, including misspellings of a person subject to a protective order, as well as any known aliases of a person subject to a protective order. Second, it provides magistrates with the same level of restricted information access as district judges, district attorneys, county attorneys, city attorneys, and peace officers. Taken together, these two provisions strengthen the original intent of the database and registry, which is to keep Texans safe by providing access to critical public protective order information. And we also I'm asking for these changes because of specific concerns that we've heard throughout the state. And Mr. Chairman, I'm happy to answer any questions.
Members, any questions? Okay. All right, thank you, Chairman. And again, you've got support, but no one wants to testify. So does anyone want to testify on for or against House Bill 3698? The chair seeing none, the chair recognizes Chairman Landgraf to close.
Thank you, Mr. Chairman. I close.
All right, we will leave House Bill 3698 pending at this time. Let's go ahead and do Morales' bill. It doesn't have any witnesses. The chair lays out House Bill. All right, the chair lays out House Bill 3115 and recognizes Representative Morales to explain the bill.
Thank you, Mr. Chairman, members of the committee. House Bill 3115, as you may know, certain retired or former judges are eligible for assignment to a case in the judge's respective area of specialty as a visiting judge under the Court Administration Act. However, certain retired and former district judges are currently ineligible to be named on the list of eligible judges subject to this assignment if they have ever been formally reprimanded by the State Commission on Judicial Conduct. This bill would allow judges, as long as they have not been reprimanded or censured in over 15 years from when the offense occurred, to serve as visiting judges. Due to the high caseload in many areas, specifically in border communities with respect to the border migrant surge that we're having, especially in regions just like my district, where I represent 750 miles of a shared border with Mexico, this bill can help alleviate the caseload by providing this eligibility requirement to these judges that would otherwise not be able to serve as visiting judges. This bill is about providing a second chance to those that have learned from their past mistakes. This is only for instances where the judges were reprimanded, not removed from office, not for egregious offenses. It's the lowest level of infraction where a judge was still allowed to serve in office, was not removed from office. And so we're not addressing anyone that may have received a felony or that may have been removed from office, but just simply either reprimanded or censured. And since that period, for 15 years, they have not been censured or reprimanded in another manner. Thank you, Mr. Chairman, members. If there's any questions, I reserve the right to close.
All right, thank you, Representative. Members, any questions? Okay, does anyone want to testify on for or against House Bill 3115? Seeing none, the chair recognizes Representative Morales to close.
I close, Mr. Chairman.
All right, thank you, members. Questions? Okay, thank you. We will leave House Bill 3115 pending at this time. The chair now lays out House Bill 653 and recognizes Representative Allison to explain the bill.
Thank you, Chairman Leach. Members, for the opportunity to lay out House Bill 653, which is known as Caleb's Law. Those of you that were on this committee last session will recall we presented this bill, identical bill.
Representative, can you just bring the mic a little closer to your mouth?
Sure. We presented, is it better?
Yeah, that's great.
Presented this bill last session. It passed overwhelmingly out of this committee. Similarly, passed overwhelmingly on the House floor, and then died in the Senate, surprisingly. What it does is it's intended to reasonably streamline the unnecessary, intrusive, costly, time-consuming guardianship process for parents of severely disabled children who will never be able to make decisions on their own or care for themselves. It carves out a very limited guardianship provision. It involves limited situations where the guardian is the primary caregiver for all or most of the life of the child, being called the ward. The minor child or minor either at the time of the guardianship or after. And mostly as here, the birth parent and the only caregiver the child has ever known. It's due to those special life circumstances that House Bill 653 provides for some relief from the more onerous, distracting, and costly guardianship provisions that simply are not warranted or necessary in these unique situations and settings. There remain more than adequate oversight protections, though. It requires a diagnosis by a physician, certification by that physician as the need for a guardianship, an affidavit by the parent or caregiver as to the same and the background, a finding by the court of the necessity for a guardianship, so there's a constant court involvement and overview, the appointment of an ad litem, and continuing oversight by the court if and as necessary. But without the onerous and costly disruption of an annual investigation, we think the ad litem covers that situation. Without the necessity of an annual report, without the necessity of the constant renewal of the guardianship, but includes the continuation of an ad litem as necessary by the court, but otherwise not an ongoing ad litem, and no requirement for a bond. Unless the court finds that there's a reasonable basis that the actions that are existing are not in the best interest of the child or the ward, however we want to describe them. But with that court constant involvement and opportunity to intercede if and as necessary. You know, we're talking about just unique, limited situations where this child with these disabilities has only known these one parents or caregivers. Here, like I said, it's the birth mother. But it's always a situation under the bill where it's been someone that has been, for the majority, if not all of their life, known just as a single caregiver, and that's what we're trying to carve out to avoid the intrusion that others go on in a normal guardianship that's just not necessary here. I know that I'd be happy to answer any questions best of my ability, but I know there are witnesses that have dealt with the situation that'd be much more adept to explain to the committee exactly what we're trying to address here. So with that, I'll stop. Again, to answer any questions the best I can. Respectfully reserve the right to close.
All right, thank you. Members, questions? Representative Schofield.
Mr. Allison, as you pointed out, we passed this out of committee last time. Could you sort of lay out for me any differences between the bill we passed last time and what we have before us today?
Right now, it's identical.
So it's the same bill?
Yeah.
Thank you very much.
Members, any other questions? All right. Thank you, Representative, and you've reserved your right to close. We've got a handful of witnesses who've registered to testify on for or against this bill. Let me call the first panel, David Thompson and Ann Thompson.
David is outside of Caleb.
Okay.
And then we're going to switch.
Okay. Okay, so then Terry Hammond and Marcia Karras. I want to remind the witnesses, we've got several bills left on our agenda today that have a pretty full slate of witnesses. Again, on behalf of the committee, we welcome your input. We are eager to receive it, and I mean that sincerely. Having said that, I would ask that to the extent that you're able to offer the committee new information, maybe to try to be careful not to repeat what other witnesses have previously said. That would be of great benefit to the committee as we approach the remainder of our what's going to be a pretty long day. So with that, the chair recognizes Deanne Thompson. Ms. Thompson, welcome back. You're testifying on behalf of yourself for House Bill 653, is that correct?
Yes.
Okay, go ahead.
Good afternoon. I would like to thank the committee for giving us this hearing on HB 653, Caleb's Law. I'm Deanne Thompson, mother of Caleb. When most children turn 18, there are graduation celebrations and preparations for college. When our profoundly intellectually disabled children turn 18, we are dragged into a court of strangers to defend 18 years of exceptional parenthood required of our extremely complex children. It is no exaggeration to state that if we were not fully committed to the care of our children, they would be dead. To require us to spend our precious resources of time, money, and energy on this ridiculous process is not only an injustice, but an outrage
It was to us anyway, and that's why we're here. Representative Allison said that Caleb's Law is a common sense approach that would protect and support familial relationships. The current system is a nonsensical approach that creates familial stress and financial hardships, as well as medical safety issues that cannot be passed up. My son turned 18 on a ventilator, okay? When our children turn 18, the paperwork is massive and many of our support services are cut. At the stroke of midnight, for no good reason, our children become wards of state. They legally kidnap them from us, and we must pay ransom money to get them back. I cannot tell you how dehumanizing, degrading it is to have my son called the ward. Just because some misguided legislators wanted to set up an industry. In the past, wards of state were incapacitated individuals with no family, no money, no loved ones to care for them. A last resort, as you will. Where are the data that prove this ridiculously cumbersome process benefits those that it's supposed to protect? How can a 15-minute court hearing full of strangers determine parental fitness? How can a person speak on my son's behalf when his issues are so complex and my son cannot communicate? The answer is they can't. The testimony and public comments given by our families today will underscore what a heinous and unjust process obtaining guardianship is, especially to the poor. The industry will preach about LRE and self-determination, but these children do not have the intellectual capacity to make sound decisions of consequence. They are completely dependent on their families and to give them their best life. We are giving them their best life, and it's all documented. Teachers, therapists, social workers, doctors are people who have chosen as their life's work to help us give our children their best lives possible and are required by law to report any suspicion of abuse or neglect. Let me repeat, our children are surrounded by mandatory reporters who have been writing reports on our children for 18 years. Please restore our God-given rights that were taken from us without cause. We need to spend our precious resources of time, money, and especially energy caring for our children, not this ridiculous process that deems our children to be subhuman orphaned wards. I detest that word because it does not fit our situation and it is highly degrading. Thank you very much. I am not nervous. I'm just upset and angry. Thank you so much for listening to our stuff and read our comments. They're excellent. Thank you.
Understand, Ms. Thompson. Thank you for being in front of our committee. I tell you what, I'm gonna call another witness in place of David, and I'll put David on the next panel. Is that okay? You.
Oh, I'm sorry.
I'm gonna put David on the next panel. So let him know he doesn't need to rush in here right now. I'm gonna bring up another witness and tell him to take his time. Members, are there any questions for the witness? Okay, thank you for your testimony. Kristen Parker. Ms. Parker, if you're in this room or the overflow room, please make your way to the panel. Marcia?
Yes, sir.
Okay, Marcia Karras?
Close, Karras.
Karras, okay, I'm sorry. Testifying on behalf of yourself, and you're testifying against House Bill 653, is that correct?
Yes, sir.
Okay, go ahead.
Thank you. Thank you, Chairman Leach and the members of the committee. I am Marcia Karras, a licensed clinical social worker for the Probate Court of Travis County. I have been a social worker for over 37 years. Unfortunately, I started when I was 4, so I'm still very young. I retired from Austin State Hospital, and I worked my entire career with wards and guardians. Thank you for allowing me to speak. I have some concerns with the House Bill 653. Initial investigations start with an overall, just a review of the situation. I have entered homes where the parents would have qualified under the proposed 653, but the proposed ward had a peg or a stomach tube, and the family did not seek help on how to use it correctly, so they were pumping roaches into the stomach. One way to avoid dealing with that was to stop feeding. So their ward at that time was not yet the ward, the child lost weight down to 40 pounds. Another concern, well, what happens if the guardian or the co-guardians die? Who will notify the court? Even now, we have difficulty in finding out information if a ward's guardian becomes incapacitated or they pass away. We are not notified. We also use the visits to help communicate resources, link referrals, offer community contacts if there's a specific family that is looking for a resource, for example, for a Medicaid provider. We will link with other family members of other wards to see if they have any resources or suggestions. The ward's rights can also be restored, and who will notify the court if there's not the timely visits. A parent may also qualify under the proposed law and there may not be any oversight. But what about the visitors in the home? The visitors may not qualify, yet the guardian could be deemed as being ideal. That has happened on a couple of occasions. The guardians were providing good care. They were excellent, except that they allowed predators into the home. One ward was actually locked into one room for 5 years, with the last 2 years in chains. So that was certainly a concern as well if there's not an annual visit. If a ward is moved to a nursing home or a group home, who will then be the primary caretaker? The guardian no longer provides the day-to-day care, so would the nursing home assume that? I hope not. Surely a parent would always want additional contact if a child is removed from their care. I spoke here 2 years ago, and since that time, I've been part of a removal of a couple of guardians through the court. Some realized it was time to go, others needed more interventions. During the last 2 years, I've fallen through rotted floors looking for my wards. The home was so poor in disrepair. In each of those situations, there had to be interventions. Who will watch over those wards if there's not the court intervention? Thank you.
Okay. Thank you, members. Any questions? All right, thanks for your testimony. Terry Hammond.
Thank you, Chairman Leach. Good afternoon to the committee. My name is Terry Hammond. I'm the Executive Director of the Texas Guardianship Association. I also am the Guardianship and Probate Attorney in the Brazos County Courts at Law in Bryan, Texas. Speak first to the issue of this committee hearing, we at Texas Guardianship Association learned about the hearing on 1675, which was the bill last session, late. I was in this hearing, Chairman, and when I realized that this bill had come before you, I raised my hand and did mention that TGA would have some concerns. You wanted me to talk to Representative Allison, which I did last session. I spoke with him about the bill, that I felt like we could perhaps work together to improve it. And he was very insistent that this is the bill that needed to pass. And so we ended up having considerable testimony in the Senate, and that's part of what happened over on the Senate side. I want to talk about the kind of broader systemic issues. Representative Schofield, you talked about your interest in systemic issues and problems. You know, this isn't a statutory scheme that's just been cooked up in the last 5 or 10 or 20 years. This is all under the parens patriae doctrine, going back to civil law in England and before that in Roman times. So there's a long, long history of jurisprudence of the king or the state, in our case, looking after those who cannot care for themselves. So the system that we have in place now requires monitoring by the courts after an adjudication. And as you know, this committee's been very involved in strengthening the guardianship system in this state the past 15 or so years. Going back to 2005, we had Senate Bill 6, cases emanated out of El Paso, Representative Moody, where the protective services system was failing people. And so we got certification for professional guardians in place. We got JBCC set up to do the judicial monitoring. Now we have criminal background checks. We have registrations of all guardians. And people who apply for guardianship have to get a criminal background check. And they also have to take a training. All of that would be exempted under this statute. That's an issue. I want to tell a little bit of another family story. About 80 years ago, the father of Rosemary Kennedy, who was 23 years of age at the time and intellectually disabled, consented to a transorbital lobotomy on her that rendered her totally incapacitated. She had no rights that we have under law now in Texas. She had no consent, no advocacy. She was rendered totally incapacitated and lived the rest of her life in a nursing home. That led to the passage of the Americans with Disabilities Act, which would likely be violated by this bill. Thank you.
Okay, members' questions? All right, thank you both.
Thank you, sir.
Is it Ms. Parker? Okay, come on up. David Thompson. Someone might want to step out and.
He's out in the hallway.
All right. Representative Allison, you might want to sneak out there and grab Mr. Thompson. All right, so Kristen Parker, David Thompson, Al Benedict, and Leonard James.
Okay. Okay. All right.
Hold on.
Okay.
Okay, Ms. Parker, is that correct?
Yes.
All right. I have you here registered on behalf of yourself, testifying in support of House Bill 653. Is that correct?
Yes, sir.
Okay, you can go ahead.
Okay. My name is Christine Parker, and I was the mother of I was the mother for 27 years of a critically, chronically ill, handicapped child, Landon Parker, who suffered from cerebral palsy, seizures, blind, quadriplegic, and severe brain damage. He was unable to speak. Landon was cared for 24 hours a day by his father, Chevette Parker, and I, and numerous, hundreds of home care nurses over that 27-year period. Landon had countless doctors, nurses, teachers, therapists, and Medicaid and nursing agency staff, as well as medically dependent children's waiver program. It was a continuous revolving door of witnesses. It was like being on a camera 24 hours a day for 27 years. Landon's life, he also suffered and had years of hospitalizations throughout Texas. And it was his care in life was witnessed by countless doctors, nurses, social workers, and chaplains. Landon always had parents by his side. And whether we were in the ICU, ER, IMC, my husband and I never left him. We took turns rotating. And we also had twins at home. And we had to get care for them, too. There were many stays at the hospital, not to mention the private doctors. My husband and I made countless life-saving, life-enhancing decisions on a daily basis, and all witnessed by medical staff and educated staff who, by law, must report abuse or neglect. So in the 27 years, that was never an issue. We were told at 16 to prepare, even though we had been millions of dollars into medical bills, millions. We were told at age 16, well, you better get some more money, because at the magic age of 18, we would have to apply to be his guardian, even though he was our biological child, or we would lose our parental rights, no exceptions to that rule. We were shocked and devastated to think of this upcoming financial burden to secure a lawyer for thousands and thousands of dollars to just continue to be the parents we always were. Landon's medical bills were, of course, in the millions, and now we needed more money to legally be his biological parents. It was so degrading and a financial hardship. We felt we were always his guardian. We paid the money, of course, we had no choice, and it was a hardship and secured that lawyer. The thought of losing our decision-making process for our son would be catastrophic, because people who did not know him and would make decisions for his life would kill him. Just before obtaining his legal papers to guardianship, he fell critically ill. He was in the ICU, with critical life-saving decisions needed to be made when the ICU doctors and nurses came up to us and said, oh my gosh, where are his guardianship papers? And we told them we had applied for them a year and a half prior, but the lawyers were taking their time. And we had to call the law office, and they said our lawyer was out of town. They would send a substitute to our son's bedside. He was dying. We could not sign the papers for the doctors at Dell to do their job. Of course, at that time, the doctors were, they had known us all of our life, and they loved us and trusted us and saw our impeccable care, and they were just shocked and astounded. We all had to wait on those guardianship papers and pray that my son wouldn't die at that moment until those papers, literally with the lawyer in front of the doctors and nurses, were signed. Even though we had signed countless times since our son had been hospitalized for 18 years of his life with critical care. We were also the parents of twins adopted from the state and had been heavily investigated already. We found the guardian process prejudicial and demeaning, creating an angry environment. I was also a school teacher and taught for 9 years.
If I could just get you to come to a stopping point on your testimony.
Okay.
Thank you.
All I am saying is, as an ex-teacher, I believe in checks and balances for children, but not our children, because they had been checked and balanced all their life with those doctors and nurses and therapists. And also, I would like to say, no human eyes ever came, even though we paid for the guardianship, no human person from this state ever came into my home from 18 to 27 and did one single check system on our son. And I would say this, all we had to do was once a year sign a paper that stated he was alive and send it into the state. No witnesses, and I understand what that other lady was saying. Nobody ever came into our home from the state. It was always, you know, our personal private nurses, this, that, and the other.
Thank you.
Vote for Caleb's Law, House Bill 653, and give the parents some credit for what they did all those years. And I didn't get to finish, but I have copies for everybody.
Thank you, Ms. Parker. It's very powerful testimony, and I know the committee appreciates it.
Thank you so much.
Representative Schofield.
Thank you.
And gentlemen, I'm going to go ahead, Representative Schofield, before your question, if you wouldn't mind maybe taking a seat over here, or there's 2 seats available right behind you. I'm going to ask Mr. Thompson, and you've got Caleb, correct? Yes, sir. I just want to make room. Caden, you might have to move that table, but Representative Schofield, if you don't mind, let us do that while you're asking your question. Go ahead.
Ms. Parker?
Yes,
Here.
thank you.
They're going to move some things around, but if you just answer my question while they're doing that.
Okay, yes, sir.
You mentioned in your testimony that you both obviously went through this process, but you also went through an adoption process from the state.
Yes, sir.
Of those 2, which of the investigations into your background and behavior was more rigorous and more invasive?
The adoption.
So the adoption was
we first became foster parents. We went through the foster care program and did foster parenting. And then by the Lord, we were able to adopt a set of twins. But we were heavily investigated in our home and everything, which was proper. And, you know, I understand that.
Thank you.
And we appreciated that.
Thank you for coming
Thank
here.
you.
Thank you, Representative Schofield. Members, any questions? Thank you, Ms. Parker. And have you given us your written testimony?
I am.
Okay.
I have copies.
Come hand it directly to me, and I'll make sure everyone gets it.
Okay. There's at least 20 copies. And then I also have one from another lady who adopted 5 children from the state. that are disabled, and she did a testimony. but
thank
she
you.
couldn't be here.
Thanks.
Thank you.
Okay. All right. The chair recognizes, thank you, gentlemen, for making those arrangements. The chair recognizes David Thompson. Mr. Thompson, it's good to see you. Thank you for being here. If you, I've got you here registered on behalf of yourself, testifying in support of Caleb's Law.
That is correct.
Okay, you can begin your testimony.
Okay. The very first thing I'd like to do, Mr. Chair, is introduce Caleb Thompson, my son, my wife's and my son. Caleb, would you be kind enough to say hi to everybody? You say hi? Hi.
Hey, Mr. Thompson, so I welcome that, and Caleb, but we're really glad you're here. I do, for the record, I'm going to need you to add him to the record, which I was going to suggest anyways, adding him.
I'm happy to do so. I actually registered him in favor, but not testifying.
Okay, so that's easy. We can, before you start, let me go find him here. Okay.
And is pretty happy right now.
So the chair recognizes, all
right.
I need to be kind of careful about how I do this. The chair recognizes Caleb Thompson. And
can you say thank you? All right.
And Caleb, you are clearly in support of House Bill 653, and we're really glad you're here. The chair recognizes David Thompson.
Yes, sir, and my son is wearing a shirt for the record that says my name.
Just again for the record, and the reason I do this is because there is substantial opposition to this bill, and I want to make sure the record's clean. And so the chair recognizes David Thompson. I've got you here on behalf of yourself in support of House Bill 653. Is that correct?
That is correct.
All right.
Yes, sir. So, Caleb, for the record, is wearing a shirt inscribed with the language, "My name is not Ward." And I would like that in the record. And it says, support House Bill 653, Caleb's Law. My name is David Thompson, and I'm blessed to be Caleb's father. I'm testifying in strong support of House Bill 653, authored by Representative Steve Allison, whom we just think is a wonderful statesperson. There is also a companion bill bearing the same name, authored by Senator Middleton, referred to already to the Judiciary Committee in the Senate, Senate Bill 2594. We're grateful to both lawmakers, Chairperson Leach and Vice Chair Johnson, who's not here. And members of this committee, thank you for taking our testimony today. Thank you also to this committee for its fabulous support of Caleb's Law in 2021. We stood before you just over 2 years ago to tell the story that has caused us to advocate for a guardianship pathway for parents of profoundly intellectually disabled children that respects rather than punishes these parents for the efforts that they have made. Most of you have heard our story, and I've attached to this testimony my 2021 testimony for your reading and for the record. There you will also see 3 hyperlinks to media stories that were produced in 2021 that tell our story. To be sure, this story is no longer about us, and it's actually no longer about Caleb. It's about those who precede or follow us, rather, in seeking the guardianship of their profoundly intellectually disabled children. It was not until Caleb was 5.5 years old that we were able to obtain a diagnosis of his epilepsy syndrome, even though his first grand mal seizure occurred nearly 5 years prior. Our neurologist presented us with 3 non-exclusive treatment options. 1, to continue his drug therapy. Number 2, to implant a vagus nerve stimulator. And 3, resect his right hemisphere. Distinguished committee members, you heard that correctly. Resect his right hemisphere. I couldn't sign that consent form. We chose options 1 and 2, and Caleb miraculously regained the ability to walk after losing it 2.5 years earlier. This is but one example of the complex decisions that parents like us must make for our profoundly intellectually disabled children. When Caleb turned 18, Representative Flores, I got to turn to you because I want to make sure that I look at you as well. And by the way, Michael, your aide was incredibly helpful when I called in the other day. And welcome to the House as well, okay? He was intubated, ventilated, and one step above a medically induced coma due to breakaway seizure activity. He was in this state for nearly 96 hours, and even though we had started the guardianship process 7 months earlier, we still did not have our get out of jail free card to legally make his still life impacting decisions. The idea that an officer of the state is equipped to determine our fitness as parents or legal guardians of our child's person when we have made these gut-wrenching decisions without incident is quite frankly an affront to each parent like us who has poured our love, heart, soul, time, energy, and resources into bringing our children to adulthood in age only. Caleb's Law makes it possible for parents of this small subset of children to opt into the streamlined pathway to guardianship of their child's person so that they may, without the unnecessary time, cost, and state intrusion, continue to do what they have done for the last 18 years. Finally, Caleb's Law will not somehow confine profoundly intellectually disabled adults into some dark corner of their parents' homes without due process protections, as many of those opposed to this humane legislation would disingenuously have you believe. In fact, any suggestion to that effect is quite frankly intellectually dishonest. Among other protections, there are 9 factors already in the Estates Code that disqualify a person from becoming appointed a guardian for another person. And they're in my testimony, and you're all attorneys, you probably know what those are by memory. Even while this bill streamlines the guardianship process for parents of profoundly intellectually disabled children, due process protections remain tattooed throughout the bill. At all times, the court retains jurisdiction over the guardianship, and it's empowered to act at any time when it receives a claim that the guardianship no longer serves the child's best interest. Because adults like Caleb are in the constant presence of mandatory reporters, this bill cements the necessary protections available to disabled adults. I ask that each of you support Caleb's Law and send it to the floor, to the Calendars Committee, and then hopefully to the floor of the House. I appreciate your time, and I'm very happy to answer any questions you may have.
Thank you, Mr. Thompson. I appreciate your powerful testimony. And Caleb, thank you for being here as well. Members, are there any questions? It speaks for itself. There doesn't seem to be any questions. Mr. Thompson, thank you. And Ms. Thompson, to you as well.
Thank you very much.
Okay. Al Benedict and James Leonard. Let me go ahead and call, Leonard James, I'm sorry. Let me go ahead and call Elizabeth Hart and Lauren Hunt as well to join you here on the dais. Mr. Benedict, let's start with you. I've got you testifying on behalf of yourself against House Bill 653. Is that correct?
Yes, sir.
Okay, go ahead.
Good afternoon. Thank you, Chairman Lynch, and members of the committee. My name's Al Benedict. I'm the guardianship coordinator of Travis County. I have come to testify against House Bill 653. First off, I'd like to acknowledge the extreme restrictions of guardianship. When we create a guardianship, we're removing a person's ability to pursue their right to self-agency. This is an extreme action. We only create a guardianship over a person as a last resort to give a voice to somebody who doesn't have one. If the state removes a person's rights and entrusts that care to anyone else, then the state has a responsibility to ensure that the guardian is acting in an ethical manner. We all live with varying ability and disability. There's no promise for anyone that they will remain at the same level of cognition that they have for the past 5 years. If the court only verifies the well-being of a ward twice a decade, as this bill proposes, then we run the risk of failing to protect the most vulnerable and invisible populations in our community. During my time at the court, I've seen guardians change in very short periods of time. Those changes have led to the need to remove guardians and have new guardians appointed. We would never have known that those wards were in danger without our court visitor program and yearly annual reports. It's true that the vast majority of guardians work very hard to provide wonderful, safe, fulfilling lives for their children, for the wards. I believe I'd act in the same manner. However, not everybody is me. Not everyone has the same values of compassion and care that I have, and there is no guarantee that something will not happen to me that could alter my cognition, like a traumatic brain injury. House Bill 653 removes the court's ability to appropriately assure the well-being of vulnerable Texans. Thank you.
All right, thank you. Members, any questions? All right, thank you. The chair calls Leonard James. Leonard, I've got you here registered on behalf of yourself testifying against House Bill 653. Is that correct?
That is correct, Mr. Chairman.
All right, go ahead.
Good afternoon, Mr. Chairman and members of the committee. As you've heard, my name is Leonard James III. I appreciate the committee allowing me to appear today to provide testimony regarding House Bill 653, better known as Caleb's Law. Unlike some of the testimony that you've heard from today, I am not an attorney, nor am I a program manager. Similar to the testimony that you've heard from Mr. and Mrs. Thompson, as well as Mrs. Parker, I am a family guardian. I am also the proud parent of a severely intellectually and developmental disabled son. I have been his father. I have been his supportive decision maker. I have cared for my son now, as of November the 7th of 2022, for 50 years. 50 years. My wife's odyssey and mine began at birth. When we found out that she had a placenta preview, the navel cord was wrapped around my son's neck several times. And due to the oxygen deprivation, as I mentioned earlier, he was subsequently diagnosed as severe and profound mentally retarded. My son, William, when I saw Caleb earlier, reminded me of my son. My son, unlike Caleb, has the intellectual level of a 2 or 3-year-old child. He's also nonverbal. He has no personal skills and he requires 24-hour supervision. I'm here today because my wife and I have always operated under the proverb that goes back to our African-American heritage, and it talks about that it takes a village to raise a child. That village, members of this committee, includes training. It includes the background checks. It includes annual court visits. It includes periodic visits by state and others. And it also includes, at the point of guardianship, the appointment of an ad litem. I have included copies of my testimony in blue folders. I want to make a couple of other points. It's been talked about the expense of an ad litem. My experience is that something different occurs. Harris County has a maximum of 5 hours at $125 an hour that can be charged by an ad litem. Members of this committee, I think you would agree that $625 is not an exorbitant amount to pay. I'm also aware of pro bono situations where people who have indigent circumstances can apply for those as well throughout our wonderful state of Texas. There's also been testimony about something called an annual report. I've included in my testimony a copy of what I filed May of last year. It takes me exactly 5 minutes to fill it out. It doesn't take an attorney to fill it out. There's a $12 filing fee. Once again, it is not a major step in the overall care and well-being of my son. As my time comes to an end, I'll pose the same question, Mr. Chairman, that I did when I was before you in October of last year. The guardianship process is not demeaning, as you've heard, but if you were an individual seeking to become a family guardian, wouldn't you want to ensure that the 30-plus years of reforms that have been enacted to hold individuals and courts accountable under JBCC regulations remain in place to ensure that our children, our loved ones, and all individuals with intellectual and developmental disabilities and otherwise incapacitated are never abused, neglected, or exploited? Mr. Chairman and members of the committee, I am William's proud dad, and I thank you for allowing me to provide comments regarding House Bill 653. I'll answer any questions that you might have at this time.
Members, any questions? All right. Thank you for your testimony. The chair calls Lauren Hunt. I want to, no, I'm going to do my job and remind all the witnesses that there is a 3-minute time limit, and we've got a number of other bills and a lot of witnesses left today on our agenda. So please be respectful of their time and stick with the time limit, if you would. Ms. Hunt, you've been in front of us a lot today, and glad you're back. If you could, I've got you here registered on behalf of T-Rep and yourself against House Bill 653. Is that correct?
That's correct.
Okay, thank you.
Good afternoon, Chairman Leach and members of the committee. Thank you for having me today. My name is Lauren Hunt, and I'm a trust and estate and guardianship attorney in Austin. I'm here today on behalf of T-Rep, who has, the T-Rep board has unanimously voted to come out against this bill. It is out of our respect and our deep care for the welfare of those who are incapacitated that we speak out today. And we are here because of the bad things that can happen and will happen if certain protections are not in place for these people. On Monday, I provided the committee with a letter outlining a number of positions that T-Rep has taken on this bill. I'm only going to highlight a few of those, particularly the due process issues here. A person who's placed under guardianship loses their civil rights and personal decision-making powers. Because individuals are at risk of losing their independence, Texas law provides certain protections so that we are in compliance with the due process clause of the 14th Amendment. Some of those protections include the right of a proposed ward to be represented by an attorney, known as an attorney ad litem, and the right to have a hearing on the need for the guardianship, as well as the right to compel, confront, and cross-examine witnesses, and the right to present evidence. And this bill utterly does away with the proposed ward's due process rights. Under this bill, the proposed ward would not have the right to an attorney ad litem. I know last session it was almost laughed at, the job of the attorney ad litem, but I assure you, having served in that role many times, it is very important. Last fall, there was a guardianship that was filed here in Travis County, and the attorney who was representing the parents didn't have much experience with this and didn't realize that guardianship was not the process that they needed to follow. As the attorney ad litem, I was able to intervene and get the parents on the right path to the resources that they needed so that they could avoid the expensive route of guardianship that would not have met their needs. Additionally, the bill does away with the hearing for the guardianship and would require the court to grant a guardianship based simply upon the application and the doctor's letter. The judges who are here today, I think, will tell you that often the reality of a situation is not apparent on paper until they get people in front of them. If a parent has a serious drug or alcohol problem or mental illness, that is not going to show up in the paperwork. And it's not going to be apparent until the parents or the family members are in front of the judge and they can see perhaps in this situation they are not the correct person to be the guardian. So I know there are a lot of other witnesses here today. I'm happy to answer any questions. Thank you.
All right, thank you, members. Any questions? Okay. The chair calls Elizabeth Hart. Elizabeth, I have you. Is it Judge Hart?
No, it's Elizabeth
You're
Hart.
just here on behalf of the Tarrant County Probate Court number 2?
Yes.
And yourself, and you're testifying against House Bill 653?
Yes.
Correct? Okay.
I am staff with Tarrant County Probate Court 2, initially employed as the Court Visitor Program Manager, and have since moved into the role of an Assistant Court Investigator, reviewing those 1102s, otherwise known as suggestions of need that we receive from the community. Anyone in the community telling the court that there may be someone that requires a guardian. I also review the allegations made in an application for guardianship of anyone from 18 to 108. So my spectrum is very wide. And in my career that I started in 2010 with the courts, I have worked for 4 statutory probate courts. And with the changes in elections, that covers about 9 or 10 statutory probate judges and associate judges. In those 13 years, I've touched about 5,000 guardianships. And I do that, of course, with the help of a lot of social work interns. My profession is I'm a licensed social worker. We reach out to the local universities in our area and contract with that university to provide the field education for social workers that are pursuing bachelor's and master's degrees. I do want to comment on the Thompson case. They're exceptional parents, and they are the majority of parents that I meet in my 13 years as a social worker working in the courts. They are the parents that have the PhD in services. They are the parents that I want to send my interns to and say, go spend an hour with them because they're going to teach you everything you need to launch into your career about supports and services and IDD, intellectual developmental disability services, that are provided through our local authority. They are not the problem parents. And we do not pursue our court visits looking for problems. That's a lot of work. We are looking at the person in the environment. How is it working for them? Are there things missing? Do they need additional supports or services that are available and that they are entitled to? And that is our role as court visitors. Over the course of 5,000 cases, I did keep statistics at one point. It was about 8% of our cases had problems. I'm happy to take questions.
Thank you very much. Who else? Okay, thank you all very much. Somebody? Okay. Chair calls Calvin Tillman, Al Zito, Ingrid Warren, and Chris Ponder. I'm going to remind everyone of our time limit. If you'll please be respectful of that. Okay, Mr. Tillman, the record is saying that you are here testifying on behalf of yourself for the bill. Is that correct?
That is correct, ma'am.
Okay, please proceed.
Thank you very much. Thank you, Chairman and committee members. My name is Calvin Tillman. I'm from Valley View, Texas, and I'm representing myself in support of House Bill 653. I actually wrote down a bunch of different stuff, but I think that there is some better dialogue. Chairman Leach asked us to not waste your time and tell you the same thing over and over again.
That is awesome.
I am a parent of an intellectually disabled child, been through this process, and so a couple of things that have been brought up. So I don't know if you know this, but the studies have shown that it could cost over $2 million to raise an intellectually disabled child. And so parents who do that are having to put out a significant amount of money. That process, it involves you dealing with multiple therapists, other medical professionals. So there's a huge strain. There's actually a pretty high rate of divorce as well. Fortunately for me, I've not had to deal with that. So there's been some very alarming stories that have been brought up here. The roaches in the ventilator. And those things are meant to scare you. And they're meant to portray that if you take this away, there's going to be 8% of the wards of the state that are going to have that happening to them. That they're going to fall through the floor because the house is in such disrepair. I submit to you that if that happens, all of the other fail-safe safety nets have failed. If you get to a point where that's happening, This process is not going to fix that. This process is not going to solve that. I've also heard it brought up that this really isn't a lot of money. It cost me about $5,000. I live in North Texas. I don't live in Harris County. I don't know what the law is in Harris County, but I know I paid a lot more than $625 for my ad litem attorney. And I also know that I did not, thank God, I did not get all the attorney I paid for. So this idea that, oh, if you have this process, then it's going to detect all of these problems. It's simply not. The fact of the matter is no one's come to my house. And maybe, as the last witness said, they look at us and think, okay, you're great parents, so we don't have to come check on you. Maybe that's what they say. Maybe they see our son is happy, healthy, and enjoys life. And maybe they don't do that. But our experience with the process would not have detected any of the things that have been told to alarm you. I think it's very disingenuous to come up here and portray that as though that happens every time, because it doesn't, and this process would not detect it. Thank you.
Thank you.
Sorry, I'm a little passionate about this, so.
Understandably. Any members, any questions? Okay, Mr. Zito?
I'll keep my.
Oh, wait, the record reflects that you're here on behalf of yourself in favor of the bill. Is that correct?
Yes, ma'am. Al Zito, South Lake, Texas. Thank you very much, co-chairperson. Well, you know. I'll keep my comments succinct. These people, these families are some of the most beautiful members of our society. They're from the get-go, they're put through tremendous heartache, hardship, both intellectually, emotionally, and financially. And that goes on for quite a long time through the life of these children that become adults. 17 years, 364 days, opposed to 17 years, 365. That's what we're talking about. What changes at that point? The child becomes an adult as far as the law is concerned, an 18-year-old. Well, for us to have such an egregious process on these parents that have loved, cared, nurtured these children from birth is just, it's atrocious. It's just atrocious. We need to be doing everything we can to streamline this process, of course, with the appropriate safeties and due process that's built into all of the other safety guards and safety nets that are there, to make this easier, to make it less egregious. This is what this bill is about. This is about making something just a tiny bit easier, a tiny bit.
Thank you very much.
Thank
Members,
you.
any questions? Thank you, sir. Okay. Chair now recognizes Ingrid Warren. We're supposed here that you're here to testify on behalf of yourself, as well as the statutory probate judges in Texas against the bill. Is that correct, ma'am?
It is not correct. I'd like to make a correction to the record.
All right, let's do that.
I am testifying on behalf of myself. I've also received support from two of my other colleagues, Judge Jan in Denton County and Judge, can I testify on their behalf as well?
No.
Okay, only on mine.
Okay, just yourself, but not for
Just
the
for my-
statutory probate judges? Okay, we'll take that off.
Correct.
So with your permission, we'll adjust your testimony to say that you are reflecting on behalf of yourself against the bill. Is that correct?
Yes.
Okay, please
That is
proceed.
correct. My name is Ingrid Warren. I am the statutory probate judge for Dallas County Probate Court Number 2. I've presided in this position for over 9 years. Our county has, under its management, approximately 3,300 guardianships. In the 9 years that I've been in that office, I routinely hear guardianship matters on a regular basis. And I'd like to share with you some of my opposition to this bill and why it is that I'm opposed to this bill. As you all have recognized today, this is an extremely emotionally charged area. I have the utmost respect for these parents and what they go through from day one with respect to their children. But what is important to understand is that these children, as well as the adults that they become, are people too. And they have rights. And those rights don't change because they are intellectually disabled, whether it's profound, substantial, whatever the nature of their disability, it doesn't change. When they turn 18, they have the right to determine whether or not they should marry. They have the right to determine where they should live. They have the right to determine whether or not they should vote. And those are rights that we all get. What's different about this process is because of that disability, they can't speak for themselves. And their parents recognize that. And their parents love them, their parents adore them, and their parents want the best for them. But their love and affection cannot be trampled over the fact that they have legal rights. And the courts are there to ensure that their rights are protected. So what do? We give them an attorney ad litem, whose job it is to make sure that the parents have met their burden of proof, that there is clear and convincing evidence that they're incapacitated, that there is evidence to prove that that parent, because we don't know at that time if it's a good parent or a bad parent, has met their burden to establish that they are eligible to serve. And so that's what this process does. We have in large counties like Dallas County the ability to appoint court investigators, and they go in and they review these cases. We work with them closely. We also have in Dallas County 7 court investigators, well, technically 6. We have the ability to hire 1 more. And then we also have 16 court visitors that we work with. They're volunteers that are working on their social masters program. And so what I'd like to reiterate, again, as Chairman Leach mentioned before, something that you haven't heard before, is that as these guardianships evolved, what I am experiencing is that parents are wanting the authority to allow their incapacitated child to have electroconvulsive therapy. I would be remiss if I didn't tell you it scares me to death if that were to occur without ongoing review. The powers that the guardian has are substantial, and I will leave my testimony with that.
Right on time. Members, any questions? Thank you, Your Honor, for being here. Okay, Chair now recognizes Chris Ponder. The record shows that you're here on behalf of yourself against the bill. Is that correct, sir?
That is correct, Madam Vice Chair. My name is Chris Ponder. I am judge of Tarrant County Probate Court Number 1. Probate Court Number 1 is one of 2 statutory probate courts in Tarrant County. You heard from Elizabeth Hart in the last panel. She's an investigator for my sister court, Probate Court Number 2. And I am opposed to this bill. One of the most serious and consequential things that a judge can do is to deprive an individual of their rights, deprive them of their liberty. Those very things that make us Americans. And it's somewhat arbitrary, as Mr. Zito said, that 17 years and 364 days versus 17 years and 365 days, that's the difference. But the minute that individual turns 18, they are granted certain unalienable rights that I take very seriously as a judge, depriving somebody of those. And the legislature has taken wonderful efforts over the last 30 years to strengthen those protections. I regularly have conversations with families, with parents like those you've heard from today that come into my court. And generally speaking, I will lead off those hearings by telling them that I wouldn't pretend to understand the difficulties that they've had to undergo for 18 plus years, but that the law charges me with a very high responsibility. And I'm not fussing at them, I'm not questioning them, but I feel it is my duty to protect and make sure that the process affords them all of the protections that are necessary. And some might say, well, my child's never going to get married, my child can't feed themselves, my child can't speak, can't walk. I understand that. But the system should protect and ensure those things. And that is why I am opposed to this bill, because I don't think it affords all the necessary protections for every potential person every person potentially placed under a guardianship. Thank you.
Thank you, sir. Members, any questions? Okay, thank you all very much. Okay, Chair now calls Deborah Wallace, Gary, Jeff Miller, and Diane McCulley. Okay. Chair recognizes Deborah Wallace. The record shows that you're here on, well, this is confusing, on behalf of yourself, and then what is PART?
It's the Parents and Allies for Remarkable Texans.
Okay. ICF, Advocates for Choice,
And the National Council on Severe Autism.
Okay, and you're here testifying on behalf of all of those organizations in support of the bill, is that correct?
Yes, I'm an active member in all those.
All right, please proceed.
Okay. I'm going to kind of go off script here, and I'll just leave everything else because we're kind of rehashing some things, and I'm hearing some dialogue here that is kind of troublesome. We're talking about a very small and specific population of the IDD population because they're not all alike. IDD people are not all the same. My son is severely autistic, and I have been his guardian and his mother for 42 years. And my late husband was an attorney. We're very familiar with what families have to go through to get guardianship. I think that there needs to be some dialogue here. I think it's a good bill in that the families, when you have a child that is severely disabled, and I do mean severe, I'm not talking about a little bit, I'm talking about possibly ripping the walls apart, putting their heads through windows. That takes a terrible toll financially, emotionally on families. And families need support as far as being able to get that guardianship. If you've been doing that, taking that kind of care for all these years, and you come up on that 18th year and you're supposed to get guardianship, and one of you is having to stay home and take care of that child, and the income is not coming in that needs to be coming in, how do these families afford? I mean, we did because my husband was an attorney, but $5,000, that's a prime example. This kind of thing we're talking about. The other thing is, can we just come back down to earth a little bit? Severe and profound people have rights. Of course they do, but they don't have the right just to, like we all do. They have the right from abuse and neglect. And more of that occurs when guardianship is taken from families or the parents die than when the parents are in charge, because those parents have put in those years of time and they love that child and are willing to do anything for that child. Last session, my husband submitted some information. He wrote some, there was a guardianship bill that came out that was very harmful. We felt like again, fine for everybody else, but for our population, it's a whole different matter. And I'm talking about a small percentage of a small percentage, but it's an incredibly important difference. I mean, you met Caleb, you've heard some of these families, but my husband defined, I'm trying so hard quickly, y'all, it's very distracting.
Your time has expired, ma'am.
Okay, well, I'll just submit this, what my husband wrote.
Yeah, I think you can give that to our assistant there, and he can.
Well, just to remember who we're talking about, though,
Yes,
this is a severe population.
I do need to clear up, just make sure that the record's clear for your testimony, that you are speaking on behalf of the organizations we identified?
Yes.
Okay, thank you. Okay. Chair now recognizes Jerry Semino, and
Good afternoon,
record
Madam
says
Chair.
you're here on behalf of yourself as well as the statutory probate judges against the bill. Is that correct?
That is correct.
Okay, please proceed.
So my name is Jerry Semino. I'm judge of Harris County Probate Court Number 1. I'm also the assistant presiding judge of the statutory probate courts. And if Guy Herman were here, Judge Herman would be talking to you rather than me. So I'm stepping in, but I do have some concerns. I appreciate and I hear and I understand the frustration of these parents. But this bill is not the way to address their needs. I'm going to talk about the way that courts are going to have to look at this, and I'm going to talk about a solution. All right? This bill is asking a judge like me to find by clear and convincing evidence, that's what the law says, that a person is incapacitated, remove all of their rights, and find that a guardianship is in their best interest and that their proposed guardians are qualified. I'm supposed to do this based on an affidavit submitted by that person that's never been looked at, never been challenged, and I'm supposed to do that based on a doctor's letter from a doctor I've never heard of or seen or is not present in the court. How do I meet that burden? How do I get to clear and convincing at that point? That's going to be problematic. They've all talked about constitutional problems, and I hear that coming, that constitutional challenges are going to be coming to this very, very quickly if it passes. I promise you that will happen. But the bill also has taken away the court's ability to gather facts independently, just to test the facts that are before it. And so I don't know, even if we were to have this information, how we can meet that very high burden and help these people. So here's the solution. And this has not been talked about at all. Although I talked to Representative Allison 2 years ago about it, I talked to Representative Schofield and to Senator Colcourt, who did it last year or last session. We already have a medical consent law on the books for intellectually and developmentally disabled people. We already have that. That's what these parents are asking us to do as a government, is to help them continue to consent to their care after they become an adult. That law's there. It's a weak law. If the law were enhanced, if it were given some document, some certification that this is a proper situation for that, they can take that and use that. We have something like that already. It's the do not resuscitate law, where doctors sign off on that. Lawyers and judges don't sign off on that, and there's a form for that. We can do that in the consent law. Give them the consent that they need between them and their doctors. Leave the courts out of this entirely. That will solve their problem. Thank you very much. I appreciate your time.
Thank you very much. Members, any questions? All right.
All right. Thank you.
Chair recognizes Diane McCauley on behalf of yourself and TREP. Can you tell us what that is?
Yes, TREP is the Texas Real Estate and Probate Institute, known as TREP, which took over the legislative efforts of the Real Estate, Probate, and Trust Law section of the State Bar.
Okay, and you're here against the bill, is that correct?
Correct.
All right, thank you. Please proceed.
Thank you, Chairman, Vice Chairman, and members of the committee. My name is Deanne McCauley. I'm a guardianship attorney in Fort Worth with 36+ years experience in guardianship. I'm speaking against HB 653 in my capacity as chair of the Guardianship Committee for TREP and in my capacity as a guardianship attorney. I'm just going to focus on two problems. There are many more, but I will, to keep it short. There's not adequate due diligence performed before the guardianship is granted under this bill. Currently, a person named guardian, before a person is named guardian of another person, they have to have a criminal background check. I know you've heard about that. This becomes part of the guardianship process because it turned out we needed to have that. Unfortunately, people do not always disclose their criminal history voluntarily. Under this bill, the parent seeking the guardianship just signs an affidavit that they haven't abused the ward and they don't have to go through a criminal background check. Well, unfortunately, people don't always tell the truth. As a matter of fact, I just learned from Judge Semino that he recently had a parent who applied for guardianship, didn't disclose to his own attorney or court that he had a felony conviction for family violence. But the background check uncovered the felony and the person was disqualified from serving. Additionally, the proposed bill, the affidavit only requires disclosures of crimes against the ward. It doesn't require disclosure of family violence against other family members, so the parent could have a felony conviction for spouse abuse, and under this bill, they would still qualify to serve as guardian for their child. Violence against any person should disqualify anyone from serving as a guardian. Yes, most people are good people. Unfortunately, that is just not always the case. And in my 36 years of practice, I've served as attorney ad litem, guardian ad litem, and also for applicants of guardianship. And there are serious problems that do come up. And to say it's just a small percentage is really not a good idea. If one person is injured or harmed because of lack of due diligence or because of fraudulent affidavits, that's one person too many. The other issue with this bill is the lack of the requiring of an annual report, and I've handed the clerk a copy of Travis County's 5-page report. It's super simple to fill out. The court websites make it very clear a guardian does not need an attorney to assist, and the cost to file it is very low. Sometimes, well, we've heard this before, so I'll skip that. So the annual report is a simple way for the courts to ensure they have regular basic information about the ward and that all is well. So just to cut it short, I just ask that the committee not pass this bill on behalf of myself and on behalf of TREP. Thank you.
Thank you very much. Members, any questions? Okay. Chair recognizes Jeff Miller on behalf of Disability Rights Texas against the bill. Is that correct? Pass it out. And you're here for Disability Rights Texas against the bill. Is that correct? Okay. Thank you. Please proceed.
Jeff Miller, Disability Rights Texas, and in its current form, we are opposed to the bill. I'm not going to go into, although Disability Rights Texas very much supports the discussions that have been held this afternoon around the due process or potential due process violations of the individuals with disability involved here. And we do believe that this bill, as it's written, potentially violates the Constitution and the Americans with Disabilities Act. But I just wanted to raise something that hasn't specifically been said yet today. In 2015, this legislature started something that was really different from most of the states in the country. We looked at guardianship as a process and tried to figure out how do we design or redesign the guardianship process in Texas to make it easier for families, but more specifically, to ensure that the guardianship protections are in place, but that individuals were treated as individuals. We didn't make it about how do we make it just easier for families. We tried to protect the rights of individuals with disabilities to ensure that they weren't placed in a guardianship unnecessarily, because unfortunately, at that time, we knew of too many situations where in many places in this state, just because someone had a diagnosis of a certain disability, namely an intellectual disability, they were apt to get a guardian. And so one of the cornerstones that this legislature started with guardianship reform in 2015 was all around the concept of person-centeredness and looking at an individual as an individual, regardless of their strengths and their support needs. You all determined that they were worthy of the court taking a look at what could they do by themselves? What could they do with supports and services in place that could be available to them and help them? What alternatives to guardianship could be used to allow them to live the most self-determined lives that they can? And I know that some people don't like to talk about that, but I think there was a statement earlier during the hearing that for these kids, it's not about what's important to them, it's about what's important for them. Well, I disagree. I think for every human being, what's important to us is also as important as what is important for us. As the father of a young adult with intellectual disability, I truly know that what he wants and what he thinks about and what he cares about are as important to him as other things that we know that are important for him. And so that's why what was so brilliant, or I think, about what the legislature did with guardianship reform is it recognized that. And just real quickly to finish up, in October of last year, this committee held an interim hearing on guardianship. And one of the recommendations of this committee after that hearing was to continue the person-centered approach to guardianship laws in this state to ensure that each person is treated as an individual, not a blanket rule.
Okay, thank you. Members, any questions? Representative Flores.
When you said alternatives to guardianship for them, taking the individualized approach, can you explain that for me?
It could be things as simple as a medical power of attorney. or someone that's concerned about their loved one, their adult child being able to make appropriate medical decisions. It could be a durable power of attorney for financial situations or those sorts of things. Or one of the things that the legislature also did in 2015 was adopt supported decision-making as an alternative to guardianship, allowing an individual with a disability to choose someone that they know and they trust and they can communicate with to help them make decisions about important things to them in their lives. Not to make the decision for them, but to help them. And we have seen a tremendous success of that program since it started in 2015.
Last thing, just because I'm not familiar so much with the guardianship.
Sure.
But it does not preclude a parent from becoming the guardian, or does it? I mean, you have to have somebody independent doing that, becoming the guardian, if for somebody with intellectual disabilities, or do they just, can they become the child?
I don't think I'm following the question.
Well, I thought I heard one of the folks say at the beginning that it was very disruptive and they lost, they were no longer the parent and at 18, but do they not get to continue in the role, or can
Well, I mean, a parent can continue to take care of an adult child that has support needs without getting guardianship, and they can support them in other ways. What this bill specifically speaks to is the legal process of removing the civil and legal rights of an individual with a disability and giving those decision-making powers to someone else. And that's the part of this that has the constitutional ramifications, because we are dealing with someone's constitutionally protected rights. Right. Do I think that most parent guardians have absolutely the best intentions? Of course I do. But I also think that we owe it to individuals with disabilities to not discount them by taking away with their rights without due process protections in place.
Okay, thank you.
Thank you. Members, anyone other questions? Thank you all very much.
Thank you.
Okay, Chair now calls Dennis Borrell, Belinda Carlton, Victoria Siebold, and Lauren Gherkin. Okay, do we have Dennis Borrell?
I'm okay, thank you.
Are you Dennis?
Yeah.
Okay. The record here shows that you are here testifying on behalf of the Coalition of Texas with Disabilities against the bill. Is that correct?
That's correct.
Okay,
I'm
please
Dennis
proceed.
Borrell with the Coalition of Texans with Disabilities and speaking in opposition to the bill. So I think this bill is less about process, and what it's really about are actually children with disabilities, and it has a statewide focus. It's pretty large. We as a society, you as a legislature, have recognized that this is a population that needs protections, and you have put those in place. And as some of the previous witnesses have talked about, improved and refined and developed alternatives. This bill would nullify or remove many of those protections. Now, I get that for parents in this situation that the paperwork can be maybe onerous or they don't want to do it. I get that it's costing them some money, and most importantly, I get that they can take offense, that they're being accused of not being a good mom and dad. I get all that. But really, this is a statewide bill. It would impact many. Do we really want to forfeit the protections of the many for the preferences of the few? I think this is not a bill that should pass. Thank you.
Thank you, sir. Members, any questions?
Lauren?
Chair recognizes Belinda Carlton.
She's not here. Yeah, she's handling.
She's not here. Okay. Thank you. We'll show her just not testifying. Okay. Chair recognizes Victoria Siebold, and you are here on behalf of yourself against the bill. Is that correct?
That's correct.
Please proceed.
Thank you, Vice Chairman and members of the committee. My name is Victoria Siebold, and I am a guardianship attorney and was previously the court investigator for the Travis County Probate Court. I'm appearing today in my individual capacity, and I am speaking against House Bill 653. For almost 5 years, I served as a court investigator for Judge Herman at the Travis County Probate Court, and now I represent families in seeking guardianships for their family members. I want to start by saying that most, but not all, parents who are serving as guardians are good and noble people. But in my role as court investigator, I unfortunately had the opportunity, I wouldn't call it an opportunity, but the chance to get a little insight into the families where the individual subject to the guardianship was not as fortunate to have parents who loved them and cared for them as well as the parents that you heard from today. My role as a court investigator was unique because I didn't represent the proposed guardian. I investigated the need for guardianship of the individual who would be subject to the suit. The bill does away with the requirement that the court investigator be involved in the guardianship process in cases of profoundly intellectually disabled persons. The role of the court investigator is an important one and varies from county to county. I had the opportunity to speak with you all in October and then spoke about some of the conversations that I had had with other counties, including Harris and Dallas and Bayer, about what their investigation looked like as part of the 1101 processes, which is how a guardianship gets created by a private attorney. The court investigator acts as a safeguard on behalf of the individual subject to the guardianship. As a court investigator, I investigated the potential need for guardianship. I served as attorney in cases where the families couldn't afford a private attorney. I assisted in reviewing and advising on application for guardianship. I investigated the potential need for removals of guardians, and I insisted in ensuring that guardianship matters were kept in compliance with statutory requirements. I also served as a valuable source of information to families on resources available to the proposed ward and their family. In one case, for instance, while working to collect annual reports, which would be done away with by this bill, and are currently required by all guardians under the Texas Estates Code, my coworker discovered that the individual subject to the guardianship, who was living with a family member, was residing in unsanitary conditions, which included a hoarding situation. Together, we as court staff were able to provide that family with resources to not only clean out the home, but to get them supports and services to ensure that the home continued to be clean and safe. I believe most families I worked with as court investigator found my presence in the case to be helpful, and I believe it's important to keep this component of the process for all guardianships. I thank you for your time today. I'm open to any questions should you have any. Thank you.
Thank you so much. Members, any questions? All right, thank you. Okay, Chair recognizes Lauren Gherkin. You're here on behalf of the Texas Council for Texas Council for Developmental Disabilities on the bill. Is that correct?
Correct.
Okay, please proceed.
And do have written.
Thank you.
Thank you. Thank you, everyone, for sticking with us on a long day. And I want to extend my gratitude to every one of your officers and your staff who were delightful as we met with them yesterday. So, extending my gratitude there. I'm not going to reiterate everything that's already been said. I will get into one of our concerns, which is the lack of definition around the term profound. Profound is a pretty bad word, and it's not defined in statute right now. And, disabilities change, definitions change. How we define disability and intellectual disability has changed over the years. IQ levels have changed. So, what I would like to ask y'all to consider is, as we're looking at guardianship, and we're looking at the folks that this bill will impact, thinking about the ability for change to occur. A lot of people have talked about how a person with a severe ID is born and they never change. That is not always the case. People with ID do grow and develop, even if it's in their own way. And also, technology develops quickly. The technology that is going to support people with ID in the future has not even been invented yet. So things are going to adapt and change. I won't reiterate the fact that, yes, abuse and neglect can occur in 5 years. And one of the things that we have to consider is when you are under guardianship and you're being abused and neglected, you're very isolated. You don't have a large group of people in that instant checking up on you at work, asking, why are you thinner than usual? Where did that bruise come from? You look like something is going on. If a guardian is abusing the person that they are overseeing, they're gonna keep that. And the court is gonna be the one to recognize it. And I'll just close with this. The laws that we establish in the U.S. and in Texas are created to protect good people from bad things. They are not designed to harm bad, and they're not designed to harm good people. They're designed to protect good people from bad things. The provisions for guardianship that currently exist in the state of Texas are designed to protect individuals with disabilities and their rights from being violated and being harmed by dangerous people. And I am happy to answer any questions. And for in that packet that I handed out, I detail supported decision-making agreements and the cost variation from, just a relationship all the way up to the most restrictive guardianship. So it details it and it details the cost. And if any questions come up, I'm happy to meet with the office. Thank you.
Thank you so much. Your testimony is very inspiring.
Thank you.
Members, any questions? Thank you very much.
Thank you.
Last panel is Rebecca Japko, Drew Farmer, and Rebecca Galinsky. Okay, we have Rebecca.
Which one?
Japko.
Farmer.
Huh? Nope. Is Rebecca Japko here? Going once, going twice. Okay, we'll register for her. Drew Farmer, the record reflects that you are here on behalf of yourself testifying on the bill. Is that correct?
That's correct.
Please proceed.
Thank you so much. And thank you, Vice Chair, Chairman, and the panel of committee. I appreciate so much being able to testify here in front of you today. I am just a retired judge from County Court at Law Number 2 in Lubbock County. The way our county works is we don't have a probate court. Our county judge handles all of the probate, and then any contested matters come up to the county courts at law. And so I bring a little different perspective here today because you've heard from some very fantastic witnesses from the probate courts, but please understand that most of the counties in Texas are not lucky enough to have specialized courts. And so that means the majority of probate matters in Texas, in other counties, are all handled by your county judge. And then if they're lucky to have a county court at law, they have that backup. I want to first thank you very much for all of the time and attention y'all have put into our guardianship system here in Texas over the last few years. and the last few sessions. I think it's so very important that you have increased the visibility of our guardianship and probate system across Texas by giving OCA the ability to focus on transparency and accountability for guardianships in Texas. I want to remind you that the results of many of those projects that we have gone through have shown that there were some shortcomings in Texas. I also want to point out to you that I totally believe that all of the families you've heard here today are very dedicated to their children. They love their children and they have done the very best for them. But you do have cases where the parent is not acting in the best interest or is just not able to. Parents that are in this circumstance are under a lot of stress through having to care for a disabled child, and the oversight that y'all have provided through your last efforts with the OCA have only improved our system, but this bill, I point out, would take a lot of that oversight away. And I'd be happy to answer any questions.
Okay, thank you. Thank you, Ms. Farmer, is that right? Okay. Thanks for your testimony, and the chair now calls Rebecca Galinsky.
Yep.
Hey, how are you?
Hey, I'm good.
Good. Here on behalf of Protect Texas Fragile Kids and yourself testifying on House Bill 653, is that correct?
Yes, that's correct.
Okay.
I'm Rebecca Galinsky. I'm with Protect Texas Fragile Kids. We're a grassroots advocacy group that advocates for about 5,000 families in Texas with medically fragile children, and that includes children with medical diagnosis, IDD, et cetera. We have adults in the population also. Many of our families have had to go through this very expensive, onerous process of getting guardianship, and we've heard the horror stories from them, ranging anywhere from $5,000 to some families have spent up to $12,000 to get guardianship. And what you have to realize is most families with a special needs child, a medical child or IDD, are a one-income family. One parent has had to stay home. Or in our families, the divorce rate with special needs kiddos or IDD is 80 to 90%. So you may have a single parent raising a child and then having to come up with this money to go get guardianship to be able to continue to make decisions for their child that they have made consistently in good faith for 18 years. If it had not been done well for 18 years, I can guarantee you the home health nurses, the therapists, the school system, the doctors, somebody would have stepped in, somebody would have called CPS, somebody would have reported them if they were questioning their decision-making ability at any point. And so when they get to that point at 18 and suddenly they have to go through this very expensive, very lengthy, very stressful process, it is very difficult on the families that are already still dealing with that disability and all the issues that go with it, all the appointments, all the expenses. So as a state, I appreciate us looking out for the best interests of the individuals, and I think that is very important. But I think this is a good bill. I think this helps families streamline that process where it doesn't make it cost prohibitive for families that may not have the funds to apply for guardianship. And you know, there are families that happens to, and they're like, what do? I cannot afford this, I cannot do this. So I think this process is good, it streamlines it, it gives them an ability to apply for that and become that. We are testifying on simply because of one concern in the bill in subsection A1B, where it says has never been the subject of an allegation, complaint, or investigation concerning the abuse, neglect, or exploitation of the proposed word. We have a concern over that because anybody can make an allegation or a complaint against you completely unfounded, unsubstantiated, and it happens in the medical community quite often when you upset a doctor or a provider by challenging them, or you have a family member who doesn't agree with decisions you've made, or an ex-spouse going through a contentious divorce or custody battle. They can make complaints on you. You can be found innocent, but this would preclude you from going through this process. So I think there needs to be a simple addition of a word saying substantiated, that they have never been the subject of a substantiated allegation or complaint or investigation. And then I think that would be, from our perspective, this would be a good bill, and it would enable many of our families who love their children and care for their children to be able to go through this process without it causing additional burden. Many of our families have had to declare medical bankruptcy over the years. So coming up with this additional money is not always an option. And I think as a state, sometimes we forget that. We want the best interest and we still need to do that. But we also need to make it affordable and we need to make it streamlined where it doesn't take a year to go through this process. So thank you for your time.
Okay. Mr. Chairman. Yeah, Representative Schofield.
So, Ms. Galinsky, to summarize your testimony, you're testifying on the bill because it doesn't go far enough to protect the parents, or you'd want to take out the provision where if they've had any accusation against them, they couldn't get the benefit of this bill.
I want to add a qualifier because I don't know, many of you know, or may be familiar with the Pardo case. It's a family in our group where they were accused of medical neglect, abuse, et cetera, by a hospital, had their child removed, et cetera. And it was all proven to be false because they had asked for a second opinion and challenged a doctor. That happens, and people don't realize it happens a lot. And our families go through that. That just happened to be a very public case. Most of them are not public. Most of them are private cases. And so because of that situation, that family would not qualify under this, even though they were completely exonerated of all charges. So our thing is we just want a qualifier in there of substantiated or proven guilty.
So if you were able to bring that to the author and they were able to find some language at work, y'all would be in favor of the bill?
Absolutely.
Okay, but currently you're testifying on. The second thing is you mentioned, and it went past me really quickly, the amount of money it typically costs these families to get the guardianship. Could you reiterate that again?
So we've had families in our group, because we represent families across the entire state, prices vary across the state and where you live for lawyers and the fees of averaging around $5,000 to start. And we've had families spend up to $12,000 for the process.
And you're saying, and I know some of these families, as you say, typically, at best, you're a one-income family because somebody has to stay home.
Mm-hmm.
It kind of amazes me, Mr. Chairman, we spend tens of millions of dollars of taxpayer money on access to justice, and families that just want to be able to be guardian of their own child are having to go out of pocket for money that they can't afford and that could be better spent on the child or adult child. That, first of all, we ought to be dealing with that. But in addition to whatever we can do here in this legislation. Thank you very much, I appreciate it.
Can I add one thing? There's also the safety of children that are IDD are able to remain in the school system until 21. So you also have that as an additional oversight is the parent may get guardianship at 18, but that child's still gonna be in the school system for 3 more years. If there's anything going on at that point, they're mandatory reporters. They need to report it to the authorities where it can be investigated. Thank you for your time. I appreciate it.
Okay, thank you. Members, any other questions? Okay, thank you both. Does anyone else wish to testify on, for, or against House Bill 653? Seeing none, the chair recognizes Representative Allison to close on the bill.
Thank you, Chair Leach. Members, appreciate the time and attention you paid to this bill. I'm somewhat dumbfounded in a way, but also I have the utmost respect for our guardianship process and the estates code. But hearing some of the testimony today, and it's been one of my concerns from the start, and I think I may have mentioned it last session, we can't allow this to be a one-size-fits-all situation. And what I'm hearing is, when I hear such words as all guardianships from some of the testimony, that's not what we should be looking for. What I think we're losing sight of, or maybe just intentionally avoided, and I get trying to protect the guardianship process and trying to protect territory. I don't agree with it, but I get it. But what we're trying to do is just carve out a very small subset to protect families and protect individuals who can't protect themselves. And that's it. And I think we've loaded it with protections, including the continuing court oversight. There was never any complaint about the cost of the ad litem. In fact, the cost is beyond that. I think there's a recognition of the absolute essential need for an ad litem, an attorney ad litem, and that's inherent in the bill, and I think that's understandable, and that ad litem plays a very important role to be able to visit the home, see if there are any problems. You know, we talk about finding roaches and things. Maybe that's in some guardianships, but I think when we're dealing with a situation here where it's been a family that's had this child for 18 years, I think if there are problems like that, it show themselves earlier. Plus, if you've got a situation like that where it's a bad parent, a bad home life, a bad situation, they're not going to survive the process in this bill. They're not going to get the doctor's certification. They're not going to be able to provide the affidavit. They're not going to be able to provide the ad litem visit. You know, and the ad litem can still say, go back to the court and say, it's a wonderful home life. This child is perfectly protected. They can afford it. He's provided for properly. Or he can say, Judge, you know, I've got some problems. Maybe you ought to keep me on this, or maybe you ought to do something further. That's within this bill. And I think there's perfect protection from a due process point or otherwise. And what, you know, just is inherently wrong. Again, it's someone who has been in this home, as the bill sets forth and the code sets forth, as someone who is either the birth child or has been in this guardianship situation or in this home for the majority of his or her life. And that's what we're trying to carve out, to protect that and not make something that is so intrusive particularly on the child or the ward, whatever characterization we want to provide. We can't lose sight of that and what the impact. We're in a very delicate situation. So I just caution you and beg you really to look at what we're really trying to carve out. And it's not the overall guardianship. We're not trying to bring down the guardianship program. My gosh, it's to protect one certain element. You know, I intentionally wanted to keep this bill exactly like it was when we left last session, including the ad litem in particular. But I think the comment about the provision about the affidavit is spot on. I think that is something that could be a problem. It was mentioned. Like I said, I just didn't want to address it in the bill as yet, but I think it would be an appropriate portion for a committee substitute. So with your permission, I plan to do that to try to address that issue. With that, I'd be happy to try to answer any more questions. I know it's been a long hearing. I appreciate that. Otherwise, I close.
Thank you, Representative Allison. Members, any questions? Okay.
Thank you.
Keep us posted. Thank you, Representative Allison. With that, the chair will leave House Bill 653 pending. Members, the plan is to take up right now, because of some witness travel, House Bill 4239, Representative Vasut. And then we're going to go to depending on if they're in the room or not, Representative Vice Chair Hull, Representative Spiller, and Representative Temesh. So sit tight. This should be, got a couple witnesses on yours. So with that, the chair lays out House Bill 4239 and recognizes Representative Vasut to explain the bill.
Thank you, Mr. Chairman, members of the committee, for the opportunity to lay out House Bill 4239. Concerns have been raised that workers injured on an insurance restoration project in which a contractor or subcontractor does not maintain workers' compensation insurance may seek recovery for damages from a property owner, and that such recourse may encourage contractors and subcontractors to elect to not carry workers' compensation insurance coverage and to instead divert personal injury claims to property owners and their insurance policies. House Bill 4239 seeks to address these concerns by exempting property owners from liability for certain personal injury claims arising from work on an insurance restoration project in which a contractor or a subcontractor does not maintain workers' compensation insurance. We're still working on this bill a little bit, so I'd love to hear some of the testimony, and we've had some preliminary meetings and working on some language that I may bring to you later. But happy to answer any questions that you may have now, or if not, refer those questions to the witnesses if necessary.
Thank you, Representative. Members, any questions? Okay, we've got three witnesses who've asked to speak on the bill. I'm going to ask all of you to come up at the same time. The chair calls Laura Tamez, Rick Levy, and Craig Island. Laura, let's start with you. you know the gig. If you'll, well, let me ask you. I've got you here testifying on behalf of the Texas Trial Lawyers Association against House Bill 4239. Is that correct?
Yes, Mr. Chairman. Good afternoon, Mr. Chairman, members of the committee. My name is Laura Thames. I am the president of Texas Trial Lawyers Association. I want to thank Representative Asut for meeting with members of the team to hear some of our concerns. On this particular bill dealing with Chapter 95, as we know, for the last 27 years, Chapter 95 has limited liability by affirmative defense for business and commercial property owners in work injury premises cases that involve construction, renovation, modification, repair. The common law has expanded the definition of property owners to owner-occupier under Chapter 95, which includes home builders, well operators, general contractors. So if at reading House Bill 4239 of the proposition of the bill is to protect homeowners, the Section 01 in terms of applicability, which a defendant would have to, that would be the burden to show applicability. Homeowners are not included in the code at the moment. It's really for primarily business and commercial purposes. And secondly, again, just from a strictly construction or statutory construction perspective, the concerning section is Section B, where a property owner is not liable for personal injury or death if the employer of the worker who is injured or killed does not maintain workers' comp insurance. The Chapter 95 actually incentivizes all to carry workers' comp in subsection 04 by actually giving a discount in the event of a judgment for those benefits that have been paid out to either the family or the worker. So we are more than happy to continue the conversation, and I'm happy to answer any questions.
Okay, thank you. Laura, members, any questions? Okay. All right. Rick? Craig, sorry. Come back to you, Craig. Craig, I've got you here testifying on behalf of the Texas Trial Lawyers Association. It just says Texas Trial Lawyers. Do you want it to say Texas Trial Lawyers Association?
Yes.
Okay. And yourself, and you're testifying against House Bill 4239. Is that correct?
Yes.
Okay, go ahead.
Thank you, Mr. Chairman, and Representative Asut for meeting with us yesterday. I think one way to put this bill as currently drafted is there's a policy decision for y'all to make. And that is right now, the legislature has decided that Texas will not require workers' compensation to be purchased by employers. What this bill would do would punish an injured employee of an employer who has made a very lawful decision to not carry workers' comp. And so that's a policy decision for y'all if y'all want to now, in essence, punish an employee who works for an employer that chooses not to carry comp. It's not the employee's choice to carry comp or not. So, and I was waiting to hear proponents for the bill. What I think this is about, perhaps, is that after a storm, we have out-of-state contractors come in, and maybe, you know, they're not as good as our contractors or roofers or whatever. And so perhaps you want to consider, in this limited instance, requiring workers' compensation on an insurance restoration project to require workers' compensation, and then you have alleviated your concern about the homeowner. Because this, as it is now, as we talked yesterday, if I'm the homeowner and if the contractor, the general contractor, and the subs don't carry workers' comp, I'm immune, then I would tell them, don't carry workers' comp on my project at my house. Because that way I know I can't be sued by anybody for any purpose. I think that's, you know, as we discussed, I think that's not a good policy. But anyway, and if you are going to do something, and if you are going to put it in Chapter 95, then I would suggest that you create a new subchapter, because Chapter 95A has a lot of history, has a lot of law, and if you throw this into it, I don't know what that mix-up is going to look like. So create its own separate chapter so we don't jack with this main one. And if you're going to do something like this, I would suggest you do it only for residential, not commercial. But again, the state has made a policy decision to not require workers' comp. I'm happy, I'd be supportive if we decided to require people to have workers' comp, or even in this limited circumstance. Otherwise, I think there's a lot of unintended consequences as written. But we will continue to work with you.
Yeah, we'll continue to talk. Rick, I've got you here testifying. You okay? Do you want to ask questions? Okay, members, any questions? Okay. Rick Levy here on behalf of the Texas AFL-CIO testifying against House Bill 4239.
Thank you, Mr. Chairman. My name is Rick Levy. I'm the president of the Texas AFL-CIO. We have 240,000 members around the state, and I'm here to talk about the perspective of how this bill affects workers. I think they've hinted at it. We came by and talked to your folks in your office. We didn't get a chance to talk to you about it, but our concerns are similar. Texas is the only state in the country that doesn't require workers' compensation. And so our concern is in situations like this, oftentimes in disaster recovery, as Mr. Island mentioned, some of the employers aren't the most stable, haven't been here for a long time, come in, and to the extent that they don't carry workers' compensation, the employees are going to be totally out of luck if anything happens where they get hurt, because the companies don't have assets, even if you can find them. And the employer under Section 95 still has to have knowledge of what's going on and some control over the situation that caused the injury. So it just seems like the way the bill is drafted, and I don't think that this is the intent, but the way the bill is drafted kind of shuffles everything, all the risk involved in this whole situation down on the employee. So that's our concern with the bill. Again, there are bills I know that are in this process that would require workers' comp for construction. So maybe, again, that's something you'd want to look at in this kind of situation. But the concern here is that very likely in many cases, if this bill were to pass, injured workers would be completely without remedy when they get hurt.
Okay.
That's all I have. Thank you, Mr. Chairman.
Members, any questions? Okay, thanks to each of you. Appreciate it.
Thank you very much.
Does anyone else wish to testify on, for, or against House Bill 4239? Okay, have you registered?
Yes, sir. I didn't register to testify, though.
Okay, hold on. Hold on.
Words?
Who?
Al Zito.
Okay, yeah, come on up. The chair calls Al Zito. Al, I've got you now registered as testifying on behalf of yourself for House Bill 4239.
For, yes.
In favor?
I like it, yes.
Okay.
Point, counterpoint with everything, so I'll wait for you, sir.
Okay, so you're here you're here testifying on behalf of yourself in support of House Bill 4239, correct?
Yes, sir. Yes, sir.
All right, go ahead.
Okay, thank you, Mr. Chairman, and for allowing me to testify, et cetera. Thank you for doing this. I do have a few comments. One, not being limited to just insurance claims, and the other is we need to protect the homeowner. For someone who's dealt with contractors before and their shenanigans, and it's not just people that come from out of state, they'll subcontract, they'll bring people in. The homeowner needs to be protected somehow. I could ask questions. I could say, do you have insurance? Do you have this? Do you have that? And you get the AAA. Sometimes you get insurance certificates, et cetera. But you don't know what the contractor's going to do. And for the homeowner to be left holding the bag, as it may be, for a bad contractor, that is what I see this bill to be about, is how do you protect that homeowner that doesn't have control over that bad contractor? And if, gosh forbid, somebody does get hurt on my property or yours or whoever's property, now all of a sudden that employee is coming after the homeowner that had nothing to do with anything, any particular accident or whatever may have you. So quick and easy, quick and simple, point, counterpoint. I'm very for this. I would like to see it expanded not just to insurance issues as well, though.
Okay. Members, any other questions? Okay, thank you. Thanks for being here.
And thank you.
Does anyone else wish to testify on, for, or against House Bill 4239? Seeing none, the chair recognizes Representative Massoud to close on the bill.
Thank you, Mr. Chairman. I mean, these are good points made about the scope of B, and particularly the interplay with Chapter 95. The purpose of the bill is targeted principally at protecting homeowners and providing an incentive for workers' compensation insurance coverage. But I think as worded, there are some issues on that front. We're looking at modifying this just into Chapter 95. And so we've got some language we'll work on. We'll bring it to you, work it with the interested parties that have testified here today, and hopefully come to an agreement or the best bill we can, and we'll be back in touch with you.
Okay, thank you, Representative. Members, any questions? All right, the chair will leave House Bill 4239 pending at this time. The chair now lays out House Bill 2731 and calls on Chairman Lozano to explain the bill.
Thank you, Mr. Chairman and members. Chairman Leach and members, thank you for allowing me to discuss House Bill 2731, which seeks to grant the Texas State Board of Education members the ability to request an opinion from the Texas Attorney General's office. Currently, only specific individuals and organizations, including the governor, the head of a state government department, the chair of a committee in the legislature, can formally request an AG opinion. This bill would extend this ability to State Board of Education members who set policies and standards for all Texas public schools. Granting State Board of Education members the ability to request an AG opinion would allow them to become better informed and have more resources for their constituents. We do currently have members, for example, in the Board of Education itself, the chair of the board is able to request an opinion. However, very similar to our higher ed institutions, the regents and trustees are also allowed to request an opinion, not just the chairman. And so this is very similar in nature. We'd like all State Board of Education members to be able to request AG opinions. And we do have, I believe, 1 or 2 witnesses members.
Okay, Chairman, members, any questions? Okay, thank you, and you've reserved your right to close, I assume. Okay, there are 2 witnesses. The chair calls Carrie Moore and LJ Francis. LJ?
Yes, sir.
Okay. Is Carrie Moore here? Okay. LJ, I've got you here registered as a member of the State Board of Education from District 2, testifying in support of this bill, House Bill 2731. Is that correct?
That's correct, Mr. Chair.
Okay, you can go ahead.
Mr. Chair, members, good afternoon. My name is LJ Francis, member representing District 2 on the State Board of Education, and I'm testifying before you today in favor of HB 2731 by Chairman Lozano. As a newly elected State Board of Education member representing District 2 with Regional Education Service Centers 1, 2, and 3, and representing almost 2 million constituents, I have been meeting with administrators, superintendents, and parents in being an advocate for change and policies that enable parents to make decisions that are best for their children. As a member of the State Board of Education, we set policies and standards for Texas public schools with primary responsibilities to include approving curriculum standards, reviewing and adopting instructional materials, establishing graduation requirements, overseeing the Texas Permanent School Fund, appointing several board members to military reservations and special school districts, and also reviewing the commissioner's proposed award for new charter schools with authority to veto a recommended applicant. Recently, many constituents have raised concerns about their inability to seek legal guidance through their State Board of Education member on accountability standards and education issues, both at the state and local levels, with many citing the issue as a restriction of their parental rights. In closing, HB 2731 seeks to add a member of the State Board of Education to the list of officials allowed to request an Attorney General's opinion, and provides an additional avenue for all interested parties to increase their involvement in their child's academic journey. This bill would provide an additional tool to ensure school accountability in delivering a high-quality education. Thank you, Chairman and members, for your time.
All right, thank you.
Stand by for any questions.
Members, any questions? All right, thanks for your testimony. Appreciate you being here. Okay, we've had an additional individual register to testify. The chair calls Lee Spiller. Lee, I've got you registered as testifying on behalf of the Citizens Commission on Human Rights, testifying for House Bill 2731. Is that correct?
Yes, sir, that's correct.
All right, go ahead.
Great. My name is Lee Spiller. I'm with the Citizens Commission on Human Rights. This is actually pretty important. Most recently, during the health instructional materials review, there were a lot of parent-unfriendly provisions in the proposed materials, particularly in the area of mental health, including teaching kids how to get around their parents when seeking care. And we brought these up in testimony, but the questions that were raised to us really could have benefited from an AG opinion. And really the only way we could see to accomplish that would have been to come to one of y'all. And so I think that allowing the SBOE to seek opinions is just a great idea. That's it.
Okay. Members, any questions for Mr. Spiller? Yes, Representative Flores.
Doesn't the head of the State Board of Education already have that authority, and couldn't you all just ask them to request an opinion?
Never thought of asking Mr. Ellis for it, but I know that there's plenty of members that, you know, feel differently on an issue, and I think that having them individually be able to ask would be good. I think it could settle arguments.
Representative, any other questions? Okay. All right, thank you.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 2731? Seeing none, the chair recognizes Chairman Lozano to close on the bill.
Thank you, Chairman and members. Unless there are any questions, I do request your favorable consideration, and I'm ready for questions.
Okay. Members, any questions? Okay, thank you, Chairman. We'll leave House Bill 2731 pending at this time. Okay, the chair now lays out House Bill 3519 by Vice Chair Hull, and I think there's a committee substitute. So Chairman Murr lays out the committee substitute to House Bill 3519, and the chair recognizes Vice Chair Hull to explain the committee substitute.
Thank you, Mr. Chairman and members, for allowing me to lay out HB 3519. Currently, judges of district courts and statutory county courts and associate judges must complete 12 hours of training related to family violence, sexual assault, trafficking of persons, and child abuse and neglect within the judge's first term of office or the judicial officer's first 4 years of service. Of the 12 hours, at least 4 hours of training must be dedicated to issues related to trafficking of persons and child abuse and neglect, and must cover certain topics. Of the 12 hours, 6 hours must be dedicated to available community and state resources for counseling and other aid to victims and to offenders, gender bias to the judicial process, dynamics and effects of being a victim of family violence, sexual assault, trafficking of persons, or child abuse and neglect. Additionally, these judges must complete an additional 5 hours of training during each additional term or 4 years of service, 2 hours of which must be dedicated to issues related to trafficking of persons and child abuse and neglect. A judge who files an affidavit that they do not hear any cases involving family violence, sexual assault, trafficking of persons, or child abuse and neglect may be exempt from these subsequent training requirements. HB 3519 would dedicate an hour of the 12 hours of training required of new judges to the dynamics of family violence. It also requires 1 hour of training on the dynamics of family violence during each subsequent 4-year term, and removes the ability for judges who don't hear family violence or family law matters to opt out. Family violence can affect all types of judicial proceedings, not just applications for protective orders and family violence proceedings, but criminal cases, divorce and custody, CPS cases, and even civil suits. Under the current law, judges serving additional terms may have only received this training lumped in with training on effects of being a victim of all violent offenses 16 or even 20 years ago. Finally, HB 3519 would require judges that give preference to family law or family violence matters 1 additional hour of training every 2 years. and requires that the training on dynamics of family violence be developed in consultation with the statewide family violence advocacy organization, which is the Texas Council on Family Violence. While this bill only applies to district courts, statutory county courts, and associate judges, I have verified with the Texas Municipal Court Education Center and the Texas Justice Court Training Center that both municipal judges and justices of the peace receive this training in their judicial training, as these judges often do magistrate orders of emergency protection. Thank you for allowing me to bring this bill, and I'm happy to take any questions. And I believe there are a couple witnesses and reserve the right to close.
Okay, members, any questions? Okay, and Vice Chair, you can just sit tight. You've got two witnesses that have both registered for the bill, and I'll call them up to join you here at the table. The chair calls Heather Bellino and Krista Delgallo. Great to see you two again. Heather, let's start with you. Heather, I've got you registered on behalf of the Texas Advocacy Project for House Bill 3519. Is that correct?
Yes.
Okay, go ahead.
Yes. Thank you, Chairman Leach and Vice Chair Johnson and representatives. As you said, I'm Heather Bellino, and I'm the CEO at Texas Advocacy Project. And it is on behalf of the survivors that we serve and the attorneys that work with them that I am here in this capacity. So we have been providing free civil, legal, and social services to survivors of domestic and dating violence, sexual assault, stalking, human trafficking, and unfortunately child abuse for over 40 years now. We have also been providing trainings to the judiciary, law enforcement, medical practitioners, many people that intersect with survivors. We do believe that training these folks in the judiciary is very important. After we have provided these trainings, we get responses and feedback that has been very helpful. And being able to provide these trainings on family violence dynamics is really important. And as she said, this is for people that are hearing those cases and others. You know, 1 in 3 Texans will be a victim of domestic violence, or somebody in their immediate family will. I mean, that's a statistic that's well known at this point. So it does serve to say that in any court proceeding, there could be somebody that is either the defense or whatever that is that has been impacted in some way in their life with family violence. And so for the judiciary to understand what that looks like, what that response looks like in a human being, can be very helpful, right? We know that trauma-informed care is something that we're all paying close attention to. We know that in previous law enforcement cases, they would use the Reid interview skills, saying, you know, if this happened at this time, then this happened, and there's a chronological order. Well, we know once you've experienced crisis or abuse that your brain's not going to work that way. It's not going to process that way anymore. So how you might present might be different than how somebody expects you to. We know that there is coercion and control. All abuse starts with power and control, right? We also know that grooming occurs. Nobody falls in love with their abuser. You don't walk up to the person and say, oh my gosh, I'm going to spend the rest of my life with you. You seem fantastic. Oh, wait, you're an abuser? No, it happens over a period of time. That power and control is taken. Your self-esteem is diminished, and then you have been groomed. People that are abusers groom society also. How often have we found somebody who's been accused and convicted of abuse, and we think, oh my gosh, I never would have imagined that. It doesn't seem possible. That person goes to church with me. That's my doctor. That's my teacher. That's my pharmacist. They don't present as abusers. So I think that it's just very important for the judiciary to be able to understand the differences in family violence dynamics, how that can affect how somebody presents, and to be able to do a much better job of, you know, being able to play that crucial role in addressing domestic violence in our legal system.
Thank you. Well said, Heather. Members, any questions?
Short.
Yeah, no, it's great. Thank you. Krista, I've got you here testifying on behalf of the Texas Council on Family Violence for House Bill 3519. Is that correct?
Yes.
Okay, go ahead.
Good afternoon. I'm Krista Delgallo, Legislative Director at the Texas Council on Family Violence, here in support of House Bill 3519, related judicial training requirements regarding family violence, by Representative Lacey Hull. Thank you so much, Representative, for filing this legislation. And just to state that For the record, it's been a joy and a delight to work with you and your office and see your commitment to survivors of domestic violence. We also would like to thank both Chair Leach and Vice Chair Johnson for your ongoing leadership and support of survivors, and of course, the committee members for your consideration of this bill that falls squarely in the purview of the committee's jurisdiction, but also in terms of TCFV's advocacy. The Texas Council on Family Violence is a statewide membership-based coalition. We work on public policy, equipping service providers, and also initiating strategic prevention efforts to further our mission to create a safer Texas. We're an advocacy organization. We support, partner, and train family violence centers, our batterer intervention and prevention programs, to which many courts refer parties who have used violence, as well as other systems, stakeholders, and courts, including but not limited to child welfare specialty courts and 4D child support courts that also do establish child custody orders. And we work with all of these stakeholders in efforts to increase safety and opportunity for domestic violence survivors and their families. We look forward to providing support to the working group and to work in consultation in the development of this required training component for judges on the dynamics of family violence, with an emphasis for courts that have the primary responsibility of hearing family law or family violence matters. I think it's probably intuitive for many to assume that family violence issues show up in certain types of criminal cases in those courts or in a protective order hearing. But it's also important to note that survivor parents become frequently and almost sometimes disproportionately represented in parties in litigation across the gamut, particularly when you're talking about the child welfare system, because survivor parents might become impacted by that system because of the elevated risk and co-occurrence of child abuse that's associated with the presence of domestic violence. We work often with survivors that are in that system. And obviously, as survivors that are also going through the family courts for different things, divorce, child support, child custody, orders of protection. And what might be surprising to folks is that the courts that handle what we call quote unquote family matters and our child welfare courts and that system actually have pretty divergent perspectives and direction for survivor parents and their families around domestic violence. And so we look forward to this training requirement to promote a more consistent and domestic violence informed approach to decision making so that we see better outcomes and more workable outcomes for families in all of these cases. And I'll just close with saying that being a domestic violence informed judiciary does not contradict, but in fact, it complements the neutral role that judges are called upon to play. A working knowledge of the issues in front of a judge will help them to better recognize and account for these dynamics, which can throw off the balance of power between parties. It can exacerbate violence and obfuscate facts that are critical in the decision-making that will impact families' lives before them. And so thank you so much for continuing to prioritize the safety of Texans through this type and other initiatives. And we would urge the committee to vote House Bill 3519 favorably out. And we look forward to continuing to work with our legislators and our courts to our shared goal of creating a safer Texas.
Okay, Krista, thank you so much.
Just a comment.
Yes, absolutely, Representative Flores.
Thank you all for your testimony and for the work that you do. I just want to give you a little piece of random history in Women's History Month that I worked for State Representative Irma Rangel in 1979. She was one of the co-authors of the first, created the Texas Protective Order, as well as the first funding for domestic violence shelters. And we also tried to make it a separate criminal offense back then, and eventually it succeeded, but I was proud to be her chief of staff and worked on this legislation. So I'm happy to see the evolution of the law and the protections that have been afforded to families and to victims of domestic violence. So just a little bit of history.
Yeah, thank you. Thanks for filling us in on that. Well said. Members, any other questions? All right, thank you to both of you. Does anyone else wish to testify on for or against the committee substitute to House Bill 3519? Seeing none, the chair recognizes Vice Chair Hull to close on the bill.
Thank you again, Mr. Chairman and members, for allowing me to bring this important bill forward. And if anyone has any questions, I'm happy to answer. And I ask for your favorable consideration, and I close.
Okay, members, any questions? Okay, thank you. Good bill. Members, we're going to withdraw the committee substitute to House Bill 3519 and leave House Bill 3519 pending at this time. We're going to do Representative Timish's bill. First, I think you've only got one witness, and then we'll get to you, Representative Spiller. And so the chair calls, or the chair lays out House Bill 3331 and recognizes Representative Timish to explain her bill.
Good afternoon. Thank you, Chairman Leach and Vice Chair Johnson, and members of the committee for allowing me the opportunity to lay out House Bill 3331. Earlier this session, a constituent of mine reached out to me and to our office in tears because he was in the process of writing his will and learned that his only son would not be able to be the executor of his estate because of a felony conviction on his record. Since his son has been released, my constituent son has turned his life completely around. He has a family, he has a job, and he's learned from his previous mistakes. But because of the felony on his record and the way our law is written, he will not be able to fulfill his dad's wishes in becoming the executor of his will. In Texas, there are approximately 550,000 convicted felons. Many of those who have this conviction on their records have demonstrated in the years following their release that they are not the person that they were before they went to jail. Many are reformed and are on their way toward a new lifestyle, yet they are constantly reminded of their mistakes that they made in their earlier youth. And during this time, they're grieving the loss of a family member or friend. Family members and friends who are preparing their wills should be allowed to provide the designator or executor of their estate to someone they deem trustworthy, no matter what that individual's prior conviction may be. House Bill 3331 states convicted felons would be able to be appointed as an executor of an estate if they are named in the will of the descendant, they're otherwise qualified to serve as an executor, and the court approves of the person serving as an executor. Current statute excludes convicted felons from becoming an executor of an estate, no matter of the descendant's wishes, unless they've been pardoned or they've had their civil rights restored. HB 3331 simply amends the estate code in order to qualify convicted felons to serve as an executor to a decedent's estate under certain instances. Chairman, members, thank you again for giving me the time to lay out this bill. I would appreciate your favorable support for this bill, and I'm happy to answer any questions that you have. And if there are none, I reserve my right to close.
Great. Well, okay. Members, any questions? Great bill. Stay there. You have one witness who's registered to testify for the bill, Lauren Johnson. So, Lauren, if you're here. Does anyone wish to testify on, for, or against House Bill 3331? There is a witness here on behalf of the Texas Real Estate Probate Institute who has registered against, but doesn't want to testify. I just want to encourage that individual to get with Representative Timmitt.
Oh, absolutely. Our door's open. I mean, literally, we're not leaving our office till 7 p.m. We have people coming in and giving us feedback. We welcome that. Even though I'm a freshman, we want to work.
Well, it would seem to me that whatever concerns there might exist out there at first glance can be resolved through conversation.
And absolutely, we're willing to work.
So, Representative Asut.
Yeah, I appreciate the bill. I struggle with this. I tend to be of the opinion that once you have served your time, you ought to be restored. That's a very biblical principle, forgiveness, right? And if your rights can't be restored through some mechanism, then what are we doing? And so I know that there's maybe some balancing with that, with the trustworthy position, but I think the way you got it in the bill balances that, by having a court approve them. I think it's a great bill.
Yeah.
Thank you. Just trying to keep it simple.
Yeah, it's simple, but very, very important. So does anyone want to testify on for or against House Bill 3331? Seeing none. Okay, come on up. Caden, do we have the iPad or no? Okay, can you go out to one of the kiosks?
Okay.
We'll wait for you. Go out to one of the kiosks, and this is House Bill 3331.
I'll be right back.
Sure, we will wait for you.
Yep.
I can fill some time. Can I ask you a question?
Yes, Representative Vasut.
So was your first bill layout yesterday or was it today?
It was actually a couple of weeks ago.
Oh, really? Lulu? Oh, okay. We thought this might be your first bill layout.
No, we had a really small cleanup bill that I'd had some help, so it was laid out. It was already in the works.
That's a code word in the legislature. I have just a really small cleanup bill. Really small cleanup. When everybody says that, I give them about 10 seconds. If their bill layout goes beyond 10 seconds, it's not a small cleanup.
And I'm learning, I was informed earlier in lap that I need to shorten my bill layout, so I'm working on it.
Fair enough. Fair enough.
Okay, the committee will stand at ease while we wait our witness. After, just for planning purposes for those here, after Representative Timish's bill, we'll hear the two bills by Representative Spiller, and then we're going to take up and consider my House Bill 2384. There's some witnesses that have some travel, some logistical challenges as well. So, no, not all. House Bill 2384. No.
Oh, thank you. I don't have my phone. I didn't want to be distracted.
Thank you. Is it Stephanie Perdue?
Yes, it is.
Okay. The chair recognizes Stephanie Perdue. I've got you testifying on behalf of yourself for House Bill 3331. Is that correct?
That is correct.
Okay, go ahead.
I was hesitant to actually register, but I figured I should make my voice be heard. I am in support of this bill. I am a convicted felon from back in 1992. I have served my time. I have had no further convictions, no arrest or anything like that. And I have been named as the executor of my uncle's will, and I had no idea this was even an issue that could have come up. And I'm left wondering, if he had died, what could have happened if they had said, oh, you can't be the executor? Then who's the executor? How does this happen? There are so many things that as a convicted felon, we do not get rights back on that we don't always know about. This is an important issue. And I'm pleased that she proposed this bill to make a solution and to restore me those rights.
The process worked. Look at that.
Yes. Thank you.
A new friendship. You can help testify on the Senate side when her bill gets over there. And so this
I'd
is
be happy to.
anyone who questions whether these hearings mean anything or whether they work. I think this is proof that they in fact do. And so, members, any questions for Stephanie? All right. Thank you. Thanks for. I'm glad we took the time to hear from you. And did Lauren Johnson come back in? Okay. All right. Does anyone else wish to testify on for or against House Bill 3331? Seeing none, thank you. Thank you, Stephanie. The chair recognizes Representative Timish to close on her bill.
Well, thank you so much, and I appreciate the opportunity to listen to Ms. Perdue. I don't have anything further, and I close.
Okay, members, any questions? Great bill, thank you.
All right,
Thanks
thank
for bringing it. Members, no questions? All right, the chair will leave House Bill 3331 pending at this time. The chair now lays out House Bill 1130 and recognizes Representative Spiller to explain the bill.
Thank you, Mr. Chairman. Chairman Leach, Vice Chair Johnson, members, thank you for allowing me to lay out House Bill 1130. I would say that this is a very simple bill. It only changes actually one word, but it's going to take me a little bit longer than 10 seconds to explain it. So currently, Article 2.08 of the Texas Code of Criminal Procedure, under the chapter dealing with general duties of officers, disqualifies county attorneys from being appointed as attorneys ad litem for children or other parties in CPS cases. Normally, county attorneys can have and maintain private law practices in addition to their duties as the elected county attorneys.
Go ahead. Yeah, you're fine.
For their particular counties. However, Article 2.08, the Texas Code of Criminal Procedure, provides that county attorneys shall not be of counsel adversely to the state in any case. That provision in its current form presents a problem in smaller rural counties because where district judges need to appoint qualified attorneys to represent children and other parties in CPS cases. In those instances, where the county attorneys do not represent the state of, sometimes in those instances, the county attorney actually represents CPS. But in those instances where they do not represent the Texas Department of Family and Protective Services, known as CPS, in handling those cases, CPS and or judges have sometimes taken the position that since CPS is the petitioner in those cases and CPS is the state, that county attorneys may not be appointed in those cases if and to the extent that they are adverse to the state. Many times these smaller rural counties are short on attorneys that are qualified to serve in that capacity and live and practice within a reasonable distance to the venue of the court. And by not being able to appoint a county attorney, judges are sometimes forced to appoint attorneys to serve in that capacity that don't live or practice anywhere near that particular venue or a reasonable distance to the court. So sometimes that does a disservice. It does a disservice to the children or other parties that they're appointed to represent. But also it's costly to the county because the county then has got additional cost, expenses, legal fees, travel expenses paid to court-appointed counsel that have to sometimes travel a great distance. That's also, I say, problematic because if they're that great distance away, they do a disservice to the child and to the client if they're not able to have that attend court, attend those meetings and other things that are involved in CPS cases. So House Bill 1130 addresses this problem. The bill in its current form only adds one word, criminal, to say that county attorneys shall not be of counsel adversely to the state in any criminal case. However, after discussing, consulting with stakeholders here, I believe I have a committee substitute, or will have a committee substitute. I don't have it yet, but we'll have that to address any unintended consequences from that provides county attorneys shall not be of counsel adversely to the state in any case, in any court, except as a court-appointed attorney ad litem under Chapter 262 of the Family Code. So individuals in rural counties are already somewhat limited by sources for legal representation. By modifying this statute, we will remove this burdensome barrier placed on rural counties and ensure that individuals have access to qualified representation regardless of their zip code. So with that, Mr. Chairman, subject to any questions you may have of me, thank you for the time and respectfully reserve the right to close.
Okay, thank you. Representative members, any questions? Yeah, yes, I'm sorry, Representative Schofield.
Mr. Spiller, I'm glad that you explained that, and we can't talk about the committee sub that isn't in front of us, so I won't. But I'll tell you, I could not vote for this bill the way it is written, given the breadth of just allowing the county attorneys to just start suing the state anytime they don't like something. What you have explained to us that we might see coming is something I could wholeheartedly support. So I'm sure when we see that, I'll be very happy.
Well, I appreciate that, and I would say that sometimes folks in rural areas that may not understand the implications of a bill, on one or the other way around, sometimes that helps, and it was brought to my attention that would be a potential problem. So we've worked with some folks and come up with some language that I think and hope would be acceptable. So appreciate it.
Thank you so much for doing that.
You bet.
Yeah, good points, Representative Schofield. Thank you. Members, any other questions? Okay. Sit tight. You've got one witness on this bill. The chair calls Christopher Barron. I'm not sure if I pronounced that right. I apologize, but I've got you here testifying on behalf of yourself for House Bill 1130. Is that correct?
That's correct.
Okay, and how do you say your last name?
Baron, like the Red Baron.
Okay, all right, so I did say it right. All right, go ahead.
Chairman Leach, members of the committee, I want to appreciate your time in allowing me to testify today. I'd also like to thank Representative Spiller for allowing this to come forward. I'm the county attorney in Young County, Texas, and I work in a very rural area in Texas. We have a great problem in rural Texas in finding enough qualified attorneys to fill the mandatory required appointments for CPS cases in these small counties. I've spoken with numerous judges that have stated, look, we don't have enough attorneys in the area to appoint them for these CPS cases to represent children, to represent parents. I know that some of these attorneys are having to come over 100 miles to sit and to represent these children as ad litems or court-appointed attorneys. I believe this is a good bill because it's going to allow the county attorneys that are in rural Texas to be able to serve the needs of these children. If someone is within, say, 30 miles or so of a child, they're going to obviously be able to visit with them more often, be more involved with the case, be more involved with what's going on than if somebody has to travel a very long distance. They get to serve those children better. And so I am in support of this bill, and I would ask for the consideration of this as to be amended where it is for court appointments for these children. And I believe that would be in the best interest of the children of this state.
All right, thank you, Mr. Barron. Members, any questions for the witness? Okay, thanks for your testimony. Does anyone else wish to testify on, for, or against House Bill 1130? Seeing none, the chair recognizes Representative Spiller to close.
Thank you, Mr. Chairman. And I would say that Mr. Barron is a county attorney. I practice law in Jack County. He's in a contiguous county in Young County, which is part of House District 68. In my private practice of practicing law for a number of years, he has been beating up on me for years. And so I respect his opinion, and he is actually the one that brought this situation to my attention. And so I appreciate that very much. I would just request your favorable consideration, and I close.
Okay. Members, any questions? Okay, thank you, Representative. We will leave House Bill 1130 pending at this time. The chair now lays out House Bill 2930 and recognizes Representative Spiller to explain the bill.
And thank you, Chairman Leach and members. Thank you for allowing me to lay out House Bill 2930. Due to Texas dual high courts, the Supreme Court of Texas and the Texas Court of Criminal Appeals, there are instances when the same legal provision, either statutory or constitutional, has been given two different meanings, both of which are binding on the state. This happened most recently in the State versus Stevens case decided in December of 2021, which addressed the issue of the legislature's ability to empower the Attorney General of Texas to represent the state and prosecute election law offenses. This overlap of authority and inherent conflict has gone on for years. This is nothing new. Even back in 1910, in the case of State versus Schwartz, the Supreme Court addressed the problem and discussed it of the independent jurisdiction of the two courts of last resort and that conflict. As a result, there can sometimes be confusion about which court should address a particular question or issue about which there could otherwise be a conflict. So this creates confusion. It creates confusion for the legislature. It creates confusion for elected and executive officials, and also, of course, for individual Texans. So House Bill 2930 is written to create a very limited mechanism to address constitutional questions upon which the Supreme Court of Texas and the Texas Court of Criminal Appeals may disagree. Specifically, House Bill 2930 permits the Supreme Court of Texas, in the exercise of appellate jurisdiction, to consider a specific question of constitutional interpretation, upon which it may disagree with the Court of Criminal Appeals, by means of a petition for writ of certiorari. This process should fall within the Supreme Court's constitutional jurisdiction under Article 5, Section 3 of the Texas Constitution, and as allowed by Article 5, Section 5 of the Texas Constitution relating to the jurisdiction of the Court of Criminal Appeals. A writ of certiorari is appellate in nature and calls for the judicial review of another court's ruling. It is neither inherently civil or criminal, and the grant of such a writ as to a particular legal question doesn't appear to give the Supreme Court jurisdiction that it doesn't already constitutionally possess. Simply put, this bill allows the Supreme Court of Texas to give a uniform interpretation of a constitutional provision, avoiding potential for conflict. And that, with that, Mr. Chairman, subject to any questions that you may have of me, I thank you for your time and respectfully reserve the right to close.
Okay, all right, Representative, thank you. Members, any questions? Okay, all right, you reserved your right to close. You've got a few witnesses that want to testify, so I'll call them all at the same time. Jack Rohde, Nidhi Chanchlani, Alan Place, and Grant Dorfman. Nidhi had to leave? Okay. Okay, Jack, let's start with you. Good to see you again.
Yes, sir.
Jack, I've got you here testifying on behalf of the the Galveston County Criminal District Attorney and yourself. So on behalf of your office and yourself, against the bill, is that correct?
Yes, Mr. Speaker.
Okay.
Mr. Chairman, that's
Go ahead.
Mr. Chairman and members of the committee, I am Jack Rohde, District Attorney for Galveston County, here respectfully to testify against the bill. The bill seeks to amend both the Government Code and the Code of Criminal Procedure, but not amend the Texas Constitution, and to effectively make the Texas Court of Criminal Appeals inferior to the Texas Supreme Court. The language of the Texas Constitution is clear in terms of its establishment of jurisdiction for both the Texas Supreme Court and the Court of Criminal Appeals. Article 5, Section 3, dealing with the Texas Supreme Court. Article 5, Section 5 with the Court of Criminal Appeals. The language of Section 3 dealing with the jurisdiction of the Supreme Court is actually very specific, and it says that its jurisdiction shall be coextensive with the limits of the state, and its determination shall be final except in criminal law matters. Its appellate jurisdiction shall be final and shall extend to all cases except in criminal law matters and is otherwise provided in this Constitution or by law. And Representative Spiller was correct. There have been cases dealing with this issue for well over a century. Both the Texas Supreme Court and the Texas Court of Criminal Appeals have recognized this fundamental separation of responsibilities and that they are really sister courts of equal standing. The founders of our Constitution carefully laid out with sharp delineation their authority. And the Texas Supreme Court and the Court of Criminal Appeals have had a number of opportunities over the last century to change this and have been invited numerous times to step into the realm of the other court and have always declined to do so. The legislation on its face, therefore, is unconstitutional. I know that the committee, whenever we come to oppose legislation, is always looking for us to suggest an alternative. And the way to address this issue is through amending the Constitution. Because these courts are established in the Constitution and because their jurisdictions are laid out clearly in the Constitution and because they've respected those boundaries for over 100 years, it would be unconstitutional to try and address this statutorily, and instead it should be addressed through a constitutional amendment. So I therefore respectfully ask that you not move forward on this bill. Thank you for hearing me.
Okay. All right, Jack, thank you for your testimony. Members, any questions? All right. Alan Place. Alan, I have you testifying on behalf of yourself and the Texas Criminal Defense Lawyers Association, testifying against House Bill 2930. Is that correct?
That's correct, Mr.
Okay,
Chairman.
go ahead.
Mr. Chairman, members, on behalf of TC Delay, our concern over this bill stems from, of course, Texas history and the Texas Constitution of 1876, which provided for a bifurcated system of civil and criminal justice in Texas. The Court of Criminal Appeals was created in 1876 as being the sole and final arbiter of any criminal law matter. Of course, the other court that preceded it was the Texas Supreme Court, which again is solely civil matters. There's been cases that have indicated that these courts are equal in authority, but separate on jurisdiction, civil versus criminal. As Mr. District Attorney on my left here, usually we disagree, but today we're going to agree basically that Texas Constitution does vest sole civil authority in Supreme Court in Article 5, Section 3, while Article 5, Section 5 provides the Court of Criminal Appeals as the court of last resort for criminal matters, such has been the case for over 140 years. It's been upheld in case law as recently as 2011. Our belief is the bill attempts to undo this framework by statute, which we believe that it cannot do, considering the constitutional provisions that were already mentioned and adopted by the people of Texas many years ago. On a philosophical level, and regardless of whether it's, and we do believe it is a constitutional issue, we just think it works. I think division of labor, having 9 justices solely involved with criminal law matters, just like you do in district courts. You have in the bigger cities, you have criminal district courts, you have probate courts, you have courts that are specialized, and we believe that is appropriate. We also believe for civil litigation, it's appropriate to have that vested in the Supreme Court as well. So we just believe that it works as is, Mr. Chairman.
Okay. All right, Alan, members' questions? All right, thank you. Grant, I've got you here testifying on as a resource witness on behalf of the Office of the Attorney General, testifying on House Bill 2930?
Yes, Mr. Chairman.
Okay, go ahead. Thanks for being here.
Thank you, Mr. Chairman. I thought Representative Spiller laid it out well. This bill is an effort to ensure clarity and consistency in some of the most consequential constitutional controversies that come before our Texas courts. In 48 out of the 50 states, this isn't a problem because unlike in Texas and Oklahoma, their state Supreme Court has the last word as to what the state constitution says and requires in a given case. Because we have 2 final appellate decision makers in our Texas court system, the potential for conflicts and constitutional interpretation is unavoidable, as is the resulting confusion and lack of certainty, not only to the lower courts, but also to litigants, defendants, and the attorneys advising them. In short, I think this bill addresses and goes some way to potentially resolving those conflicts and the resulting confusion, and to providing needed uniformity in the interpretation and application of the Texas Constitution. I've had some experience with this as a trial judge for 10 years in Harris County, where I have both the 1st and 14th Courts of Appeals grading my paper, and I've had cases come before me where one says X, the other says Y, and I've had to make a decision in those cases with the risk that I may be proven wrong on appeal because I went with the wrong court. And it's a random appeal from there as to which court my case lands in. So I think the importance of having a final decider is represented here. And in this case, it's the Supreme Court of Texas, which is charged by the government code with ensuring the jurisprudence of the state of Texas, considering that when it grants petitions for review and takes cases into its jurisdiction.
Okay. All right. Member, any question? Okay. All right. Thank you each for being here.
Thank you, Mr. Chairman.
Does anyone else wish to testify on, for, or against House Bill 2930? Thank you, guys. Seeing none, the chair recognizes Representative Spiller to close on his bill.
Thank you, Mr. Chairman. Let me just touch on a couple things. One is there is one way to go. You know, there is an opportunity. You know, if you file and ask for a constitutional amendment, if you know that's kind of the belt and suspenders approach. But my position is that I respectfully disagree with any contention that this bill is unconstitutional. And the reason for that is, as we've said, and I've already quoted what Article 5, Section 3 said, as with the other witness, where it also says, as far as the judicial power, and as otherwise provided by the Constitution or by law, but specifically Article 5, Section 5 of the Constitution, as it deals with the Court of Criminal Appeals, talks about its jurisdiction, and it says, with other exceptions and under such regulations as may be provided in the Constitution or as prescribed by law. The operative provisions in my bill amend Section 22.01 of the Government Code, and the section is A-1, says the Supreme Court has appellate jurisdiction to finally resolve a conflict between the Supreme Court and the Court of Criminal Appeals regarding the interpretation of a provision of the Texas Constitution. on, and it gives the process. So we're not talking about the Supreme Court. This is not giving the Supreme Court the ability to rule on criminal law matters or vice versa. It is only in the very limited circumstance that we're dealing with the constitutionality of a provision, and that at the end of the day, we've got to have somebody make a final decision there, and it's creating conflict and has created conflict for over 100 years in the very rare occurrence when that arises. And so this bill just simply addresses that and provides a common sense approach to resolving any potential conflict that periodically, unfortunately, may occur.
Okay.
And with that, I would close.
Okay, all right. Thank you, Representative Spiller, and we'll leave the House Bill 2930 pending at this time. Thank you for, thanks for your patience today. Committee will stand at ease just for a second. All right, the chair lays out House Bill 2384. There is a committee substitute. Representative Flores lays out the committee substitute to House Bill 2384. Thank you for that. I need you. We've got several members who are laying out bills right now, which is totally fine. This is a really important bill that I'm proud to lay out today. The judiciary is clearly a cornerstone of our system of government. For it to function at the highest levels and to maintain the public's trust, our judges must be exceptional. Many of them, most of them are now, and this really doubles down on that. They must be well qualified and well trained, and the more experience they can get, the better. This bill, House Bill 2384, seeks to address two primary issues. First, that voters have readily accessible information about judicial candidates. And second, that no matter who wins an election, that judge receives additional education and judicial training. The bill requires a judicial candidate's ballot application to include their bar number, to disclose any public sanctions or censures, to state the nature of their practice, legal specialization, and any professional courtroom experience. Additionally, appellate candidates would need to describe any appellate court briefs and oral arguments going back 5 years. The bill, as filed, directs the Supreme Court to adopt rules on judicial training in which a judge would need to complete within the first year of their term, and it authorizes the two high courts to adopt rules regarding the content of the training and education. This bill also directs the Office of Court Administration to develop a standard for identifying courts that need additional assistance and to include disaggregated performance measures for each court, and then to report the annual clearance rate for each trial court. Finally, the bill directs the Supreme Court to adopt rules for a specialty certification for attorneys in judicial administration and requires the Texas Board of Legal Specialization to make it available to judges. The substitute in front of you clarifies that this certification could also be offered to attorneys if they meet those eligibility requirements. The substitute further addresses several concerns that we've heard since the bill was filed. It removes a requirement for constitutional county judges to comply with the provisions of the bill, as few county judges, county court at law judges perform judicial duties. Constitutional county judges perform judicial duties, and those that do, those duties are simply limited. The substitute also clarifies that nothing in the bill affects the Court of Criminal Appeals appropriations or administration of the Judicial and Court Personnel Training Fund. This bill aims to create a robust and, importantly, uniform standards for judicial training and education that I believe will benefit everyone dealing with our justice system in Texas. I'm very proud of the work that's gone into this bill, and I'm happy to take any questions if you have them. If not, we'll go to public testimony. Do you have questions? You want to? All right, let's invite the witnesses up, and we'll open public testimony. The chair calls George Christian, David Brenner, Jack Walker, and Alfonso Charles, just Charles. George, let's start with you. I want to thank you for your work on this. There are many issues over the years, but specifically when it comes to the quality and the high standards that we've adopted here in Texas for our judicial candidates and for our judicial officers at all levels. You've really been at the forefront of that. You have had a huge hand in formulating and drafting this bill and getting it to the point where it is today. I've enjoyed partnering with you on it, and I've got you here testifying for the bill on behalf of the Texas Civil Justice League. Is that correct?
That is correct,
Right,
Mr. Chairman, and thank you. I am George Christian. I'm senior counsel of the Texas Civil Justice League here in Austin for many years, and I'm very proud of this work product, and Chairman Leach, so grateful to you for recognizing what we think is the most important bill for the judiciary in the last 30 years. This is an immensely positive bill. As you know, in the past, a lot of these kinds of efforts have focused on, trying to sort of regulate who could run for judge or before the ballot. This bill focuses on the judge who gets in on the bench. This bill, if it passes, would make us the 46th state in the country that has mandatory judicial training. 45 states currently do. We do not. It will improve the information available to voters so they can make informed choices about their judges. We feel very strongly, that Texans want to elect their judges, and until Texas voters tell us otherwise, that's what we're going to do. And so this bill, I think, really creates a standard both, internally to the judiciary to, create a very positive climate towards improvement of skills and administration, particularly of courts, which, particularly if you're a new judge and don't have a lot of background in litigation, haven't been in the court a lot, this bill will really help, because I think part of the issue is the more judges know, the more confident they are in what they know. And studies have proven that a recent study by the National Judicial College has proven that judges who receive this kind of training, they do a better job in their own mind. They represent that they're more confident, that they make their rulings, and that they manage their business better than they would without the training. And so that's what it's designed to do. And hopefully, if we do create this board certification, which I think is a really innovative idea, Chairman Leach, that attorneys will do it who may want to be judges, and that, judges will want to do it, and we'll create kind of a culture of excellence, and that's our goal. And again, thank you very much, and I'll be happy to answer questions.
Culture of excellence. I like that. Well said. Members, any questions for George? All right, thank you. Chair calls Jack Walker. Jack, I have you testifying on behalf of the Texas Trial Lawyers Association and Texabota for the bill. Is that correct?
That's correct, Chair.
All right, go ahead.
Mr. Chairman, again, I'm Jack Walker. I want to thank you for the opportunity to testify today. I'm actually Vice President of Legislative Affairs for Texas Trial Lawyers Association, but I'm also a member of ABOTA, Texabota, and past president of East Texas ABOTA, and I'm testifying on behalf of both organizations in favor of House Bill 2384. The bill touches on three important aspects, and what is unique about it is the comprehensive nature of the bill that touches on that addresses the qualifications, education, and accountability of judges. The need for a qualified and educated judiciary is a cornerstone to maintain a strong and independent judiciary. Because we elect our judges, it's important that the electorate be able to compare apples to apples, and this bill actually moves the needle forward in that respect. By streamlining the application process to focus more on the factors that are relevant to judicial competency, like courtroom experience, specializations, it allows the electorate to be able to make informed decisions on who they would like to be making judicial decisions that impact their community. With regard to education, the judicial education aspects of the bill have two important focuses that will benefit the community where judges serve. First, administrative education at the outset of a judge's tenure will set the stage for efficient management of often very diverse case dockets. Many judges that run for and are elected to office do not have administrative experience, or certainly not the type of administrative knowledge that goes along with operating an efficient judicial docket. The ultimate focus of education should be to allow judges the ability to maintain that judicial independence. Judicial education that under this bill offers a number of benefits, including enhancing the quality of the justice, assisting justices to keep up to date, and preventing and remedying judicial error. The bill works on establishing also performance metrics, which in turn will make the judiciary more accountable to the community. This will again, in turn, allow the electorate to be able to assure that their judges are focused on the job which they were elected. We are in favor of this bill, and we urge the committee to pass the bill out of the committee favorably, and I'm happy to take any questions.
Thank you, Jack. Members, any questions? All right, thank you. Chair calls Judge Judge Alfonso Charles, testifying on behalf of yourself.
Yes.
On the bill, is that correct?
Yes, sir.
Okay, on House Bill 2384. Go ahead.
Thank you, Chairman Leach. My name is Alfonso Charles. I'm the judge of the 124th District Court in Gregg County, Texas, and also the presiding judge for the 10th Administrative Judicial Region, and I'm testifying on the bill. Most of my testimony is going to be very favorable to this bill. I think the judiciary, I've talked to a number of judges and justices about this bill. The application requirements, I've yet to hear from a judge who has any complaints about those. And the ones that except for one, and that's the type of complaint that probably needs to be addressed, is, I haven't heard from a single judge who has any problem with having to put down what their qualifications are, what they've done the last 5 years, or what their candidates, the ones who would run against them, have done. I think that's excellent. And also that you have to reveal any disciplinary issues, public disciplinary issues, or any Class A or B convictions in the last 10 years. That's things the voters need to know. So I haven't heard any judge who has a complaint about that, nor have I heard any complaints about the new requirement on how the performance metrics are done. Especially, I think there's a lot of judges who look forward to having, instead of it being done by countywide on how how cases are moving, having it being done by court. My region is very rural, and so you look at most of on the OCA reports, you pull up most counties, you know because it's only one judge, so you know how that judge is doing, versus if you pull up Harris County and you have 70-some judges. So there's no complaints about that. The one issue that has been raised by a lot of the judges deals with Section 2 of the bill on judicial education. We have the best judicial education in the nation. The Texas Center for the Judiciary does an excellent job training the judges. It starts with new judges school, which gives the judge 24 hours of education even before they become a judge. And that focuses on administration in the courtroom and also legal issues. And then they put on an annual conference, a regional conference, specialty conferences. We have really good education. What the fear of the judiciary is that the first part of Section 39.002 would have unintended consequences and change how that's done. Right now, the proposal says that the Supreme Court, in consultation with the Court of Criminal Appeals, shall adopt rules for judicial training. What we would suggest is either change it to say the Court of Criminal Appeals should adopt rules, or the Court of Criminal Appeals in consultation with the Supreme Court. The reason for that, it's nothing against the Supreme Court, but that would be consistent with what's currently going on, and also with Chapter 56 of the Government Code, which gives the Court of Criminal Appeals the authority to do judicial education. That's what we're concerned about. We don't want some unintended consequence or some, you know, the basic fear is that this may be a fix that doesn't need fixing on that one issue. And so I'll yield the rest. I just want to thank Chairman Leach and the stakeholders for including me and some other judges in these conversations, and I look forward to continuing the discussion.
Me too, and thank you for your testimony. You know, I'm committed to doing that. Do you have a question? Okay, members, any questions? Okay, thanks to each of you. I appreciate you, you being here and for your testimony. The chair calls David Brenner. Is David gone? Okay, okay, all right.
George,
Give him my regrets. Alexander Kamsudi. I've got you testifying here from the Office of Judicial Education on the bill?
Yes, sir, just
correct?
as a resource witness.
Okay. Did you have prepared testimony, or do you just want to make yourself available?
No, just make myself available if anyone has any questions.
Chairman Merck.
I just have to compliment him on his mustache, so.
Thank you, Representative.
Yeah.
I appreciate that.
Yeah, it's impressive for sure. Members, any other questions? All right. I don't have any either. I look forward to working with you on this.
Thank you for your time.
Thank you. Does anyone else wish to testify on, for, or against House Bill 2384? Seeing none, I will, Representative Flores, do you have questions? Sure, I'm happy to answer.
In terms of the education requirements, would what they're already getting in terms of what was described, I'm sorry. Would the education requirements that they're currently getting, that was just described by one
From the
of
Texas Center for the Judiciary.
Yeah, would there have to be an additional 30 hours on top of everything they're already doing, or would
So
that be?
that's actually a question that I had just noted here myself. I'm not sure I know the answer to that. I don't know if that training is
robust.
I don't believe it would be in addition. Do you want to call up one of the other witnesses, or I will find the answer for you before we vote on it? Let me.
Yeah.
I actually wrote that question, that very question down. I don't know the answer.
Only because they're, especially the first year, you know, judges are, I mean, they're jumping in and they're getting used to their court, and then they have to have this additional 16 hours, and then on top of the 30, you know, the 16 hours is after the year after.
Let me reopen public testimony on the bill, and call Judge, you want to come back up, or George?
Sorry, I should have.
No, that's fine.
I should have caught him.
All right, the chair calls Judge Alfonso Charles. You're here on behalf of yourself testifying on House Bill 2384 as a resource witness. Is that correct?
Yeah.
Okay.
Yeah.
You can answer her question.
I believe the way the bill is written, it's just codifying what already happens. Is the 30 hours that a judge is supposed to take their first year, and then the 16 hours every year thereafter.
So that was my understanding as well. Is right now it's not that training is not statutorily required.
It's not statutorily required, but
so a newly elected judge could opt not to do that training currently.
Technically, yes.
Technically, I don't know if any do or how many don't. But this will codify it and require it.
Yeah. And it's not in, and you know, just one thing on that, the Texas Center for the Judiciary keeps track of our hours, and talking with Mark Atkinson, the executive director, at least in the last couple of years, there's been no judge who has not obtained their 16 hours without an excuse, like being ill, or like with, you know, through COVID, there were some exceptions, but then they've all made up.
I have just a kind of a question that's probably dumb, but I'll ask it anyway. Since they're now judges, but they're still lawyers technically, do they still have to do their legal CLE and do their judicial? That's a lot of CLE for on top of, I mean, I know people do specialization and maybe it's not a big deal, but they're so busy, I just wonder.
The way it works is obviously the state bar requires us to get 15 hours a year. The Texas Center for the Judiciary requires us to get 16 hours a year. So, you know, all the judges are meeting the 16 hours. And, you know, the one provision that the way it works now is that if a judge didn't get their CLE, the bar would take action. I like the idea in this bill that, okay, it gives the State Commission on Judicial Conduct, it gives another way to address that.
Are they on top of each other?
No, they are not.
No, it's,
No.
I mean, one counts for the
Yeah,
other.
if a
Gotcha.
judge does their 16 hours, they've covered both.
Gotcha. Okay, thanks. That's what I.
All right. Members, other questions for the witness? Okay, thank you, Judge.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 2384? Okay, seeing none, we'll close public testimony, and members, I'll make myself available to try to answer other questions you have. Okay, if not, we'll withdraw the committee sub to House Bill 2384 and we'll leave House Bill 2384 pending at this time. The chair now lays out House Bill 2383. And I'll recognize myself to lay this bill out. Representative Vasut offers up the committee substitute to House Bill 2383. Members, over the last few legislative sessions, we've passed bills aimed at modernizing the law as it relates to our court reporters. And we've also worked hard to address the court reporter shortage. This bill seeks to continue and to build upon that work. The bill in front of you provides that a certified court reporter may administer oaths without regard to where the reporter is located and without being in proximity to the witness. It also clarifies existing law regarding who may take depositions on oral arguments. Further, the bill updates outdated statutes that address the payment of expenses of official court reporters, and it clarifies the use of the Court Reporter Service Fund. It also allows judges to jointly hire and remotely use court reporters, as well as jurisdiction for the Judicial Branch Certification Commission when uncertified reporters fail to comply with the requirements for verifying a deposition. Some expenses to be paid to court reporters for travel between counties have not been updated in 40 years, members. This bill allows that the expenses may be the statutory amount or a larger amount set by the employing county. Finally, under current law, an uncertified reporter may be used when a certified reporter is unavailable if the reporter meets the procedures required of all reporters. And it provides a penalty for an uncertified reporter who does not follow those procedures, since there is no license to revoke or suspend. The committee substitute members makes just two simple changes. First, it makes clear that the bill does not affect existing sections of the Texas Rules of Civil Procedure. And included in the substitute is a conforming amendment to make the statutes for depositions on written questions by notary's consent. I'm happy to answer any questions. We've got a few witnesses here to help us walk through the bill. With that, the chair will call our only panel of witnesses on this bill. The chair calls Karen Usher, Steve Bresnan, Gail Fiasco, and Russell Schaffner. Okay, Russell had to leave. Okay. Sure, either way. Karen, Steve, and Gail. Karen, let's start with you. I've got you here registered on behalf of the Texas Deposition Reporters Association and yourself, registering for House Bill 2383. Is that correct?
That's correct.
Okay, go ahead.
Okay, good afternoon, evening, Mr. Chairman, members of the committee. My name is Karen Escher. I am the president of Texas Deposition Reporters Association. I am here to discuss my support for House Bill 2383. In the interest of time, there's a lot of sections to this bill, so I'm going to just hit three sections of the bill I want to talk about. The first area is section 20.001. Section 20.001 deals with notaries public. The current language in the Civil Practices and Remedies Code is ambiguous and requires clarification as to their authority and restriction to conduct depositions on written questions. The purpose of this bill is to provide that clarification. The next section I'd like to talk about is 154.105, section 13. This will allow Texas court reporters to administer the oath anywhere we are. Currently, Texas court reporters must physically be on Texas soil to administer the oath. This bill will help with the reporter shortage because any reporter with a valid Texas CSR license will be able to take a deposition in a Texas case anywhere they are. So let's say Amy lives in Texas, has a Texas CSR, moves to Indiana. If there is a Zoom deposition in a Texas case and she has a Texas license, she can take it. Lastly, section 154.112 of the government code.
The language in 154.112 of the Government Code requires that non-certified reporters, when appearing to report a deposition, must submit an affidavit to counsel present at the deposition. The affidavit must state that a certified shorthand reporter was not available to report the deposition. Currently, the language provides no guidelines in what the affidavit should say, when it should be submitted, or what content should be in it. Oftentimes, no affidavit is even provided, and the attendance of a non-certified reporter comes as a complete surprise to counsel, leaving counsel no viable option other than to go forward without a certified reporter. The intent of this bill is to provide much needed guidance for the provision of a non-certified reporter and for civil penalties for those failing to comply with these guidelines. And I'll open for any questions if anyone has any.
Okay, members, any questions for Ms. Usher? Okay, thank you. Thank you, Karen, all the way from District 67. Thank you. It's great to see you as always. The chair calls Gail Fiasco.
Yes.
Gail, good to see you as well. I've got you here testifying on behalf of the Texas Court Reporters Association and yourself for House Bill 2383. Is that correct?
That's correct.
Okay, go ahead.
Thank you. As you said, my name is Gail Fiasco. I'm an official court reporter in the 59th District Court in Grayson County with Honorable Larry Phillips presiding. I want to thank Chairman Leach for sponsoring this bill. TCRA, Texas Court Reporters Association, has been the leading association in the state since 1939. We have 41% of the certified court reporters in the state of Texas as our members, with also close to 1,200 members consisting of the official court reporters, freelance court reporters, students, and associates. Since 2019, Texas Court Reporters Association has been successfully getting legislation to help support the shortage that we've had, along with maintaining the integrity of the court reporting profession. House Bill 2383 is a continuing bill that will help in this endeavor. Since in December of 2019, we had 2,200 certified court reporters in the state of Texas. Today, we have 2,255 court reporters. That may not seem impressive to you, but if you consider 2 of those years out of the 4 were COVID years. So our trend is going up. We also, currently, Texas has 10 court reporting schools throughout the state. And that makes us one of the leaders, if not the leader, nationally, of states that have court reporting schools. We also have 18 substantially equivalent states, and that's important with House Bill 2383 because that will open up remote reporting. 2383, as has been stated, updates language, broadens the capabilities of the court reporter to remotely report depositions. It will aid the courts to get coverage for their dockets, and it also provides guidance for CART providers in the courtroom. If you're not familiar with CART, that is the communication access real-time that's provided for the deaf and the hard of hearing community. I'll now defer to Steve Bresnan, and he can go more in depth in the bill. Thank you very much for your time.
Questions for this witness? Okay, thank you, and give our best to the judge. Chair calls Steve Bresnan. Steve, I've got you here on behalf of the Texas Court Reporters Association testifying for the bill.
That's correct.
All right, go ahead.
Thank you, Mr. Chairman. The only reason I don't have a tie and a white shirt on today is they told me I would come out better over in State Affairs earlier today, so I had to.
You look like the chairman.
Anyways,
yeah.
So sorry about that.
That's okay.
Anyway, I just want to hit a couple of high points here and not take too much of your time. Okay. This court reporter shortage is a big deal. We have a lot of personnel in the state that the fragmented structure of our court system and our other aspects of our legal system have made it difficult to make available people to where they're needed. And the ability to do this work remotely, we've all found out, is not only possible, it's favorable, particularly in a deposition type of environment. This bill not only allows a court reporter who's licensed in Texas to work from wherever he or she finds themselves, it also allows two judges to hire an official court reporter between them. And that court reporter could actually work remotely between the courts to the extent, or travel that way. So we're doing our best here to use the workforce that we have to extend it and solve those problems. Be happy to answer any questions. Mr. Chairman, you've carried the bill last time, and I think this may be the third time, and it's making a difference out there in the world. And we can't thank you enough for the attention you and your staff have paid to this.
Thank you. Thanks. It's been my pleasure to do so. I've enjoyed working with you. Members, any questions for Mr. Bresnan? All right.
I would like to add just one more thing.
Sure.
Your staff contacted me today. They'd heard from some counties that were concerned about how court reporters got paid. And there's no intention in this bill to change the way court reporters are paid now. Some, the district judges set their salaries, some commissioners' courts. So they'll be, we'll pay attention to that, make sure that we're status quo and not upset the apple cart on that.
Okay, great. Thank you for clarifying that. Members, any other questions? All right, thank you each for being here.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 2383? Seeing none, the chair will make myself available for questions, members, if you have them. If not, I'll withdraw the committee substitute to House Bill 2383 and leave House Bill 2383 pending at this time. The chair now lays out House Bill 2266, and I'll recognize myself to explain this bill. Members, House Bill 2266 seeks to address burdensome local regulations on occupational license holders when those local regulations go further than those regulations imposed by the state. The bill authorizes a licensee to bring an action to enjoin the enforcement of a local law that regulates the licensee's business activity if that local law is more stringent than the state's, or if that local law would result in an adverse economic impact on the license holder, and it lays out the processes and procedures for doing so. An action must be brought in either a Travis County District Court or the District Court that includes the municipality that adopted the local law. A license holder would be required to show the adverse economic impact and could present evidence in order to do so. The burden of establishing that the local law does not conflict with that law, with the state law, and is a necessary and narrowly tailored local law to protect against actual harm to the public's health or safety would be on the municipality. A court could grant any prohibitory or mandatory relief warranted by the facts, and it would require them to award court costs. The bill requires the court to award court costs and attorney's fees to the licensee if they prevail. Members, oftentimes, as we've seen over the years, in more recent years, oftentimes local municipalities go not just a little bit further than state law, but dramatically more so. And doing so frequently results in small businesses specifically being overburdened, economically hampered, in a world where small businesses already struggle to get off the ground and running. The bill seeks to make it just a little bit easier and to protect our statewide standards in many areas while still protecting the integrity and requirements of our state laws. I'm happy to answer any questions. We have a few witnesses that I know are interested in this bill, and if you don't have any questions for me, members, we can go to the testimony. Okay, with that, the chair calls Bill Lauterbach, Ann Bador, Tim Morstad, and Luis Figueroa. Mr. Lauterbach, let's start with you. If you could, I'll tell you what. I've got you here registered on behalf of yourself in support of House Bill 2266. Is that correct?
Yes, Mr. Chairman, and it should show that I am testifying on behalf of Texans for Economic Freedom.
Okay, we can change the record real quick. Hold on. So you're testifying on behalf of yourself and Texans for Economic Freedom?
Yes, sir.
And you're for House Bill 2266?
Yes, Mr. Chairman.
Okay, go ahead with your testimony.
Mr. Chairman and members of the committee, thank you for hearing our testimony this afternoon on House Bill 2266. My name is Bill Lauterbach, as I stated earlier, and I'm here representing myself and Texans for Economic Freedom. In December of last year, Texas Comptroller Glenn Hager issued a report to the governor and to you in the legislature listing all the occupational licenses required by state government. The report identified 802 unique types of licenses issued by 45 different state entities. I'm going to repeat that. 802 unique types of licenses issued by 45 state entities. Honestly, I had no idea that many different occupations required a license from the state of Texas. As of last December, the Texas Department of Licensing and Regulation alone issued 228 separate types of occupational licenses, which are held by about 860,000 people in Texas. That's a lot of bureaucracy. In 2017, Texas has made, since 2017, Texas has made progress in reforming occupational licensing. The legislature and TDLR have reduced the number of licenses required in the educational requirements for others, making it easier for those seeking to enter certain professions. And the 85th legislature removed more than 15,000 licensing requirements. I applaud the legislature for taking these actions. Unfortunately, as Chairman Leach noted, some municipalities in Texas also impose occupational licensing, permit or registration requirements on individuals or businesses that are already subject to state regulation. Some of these municipal laws may be more stringent than those imposed by the state for the same occupation or business. While municipalities collect fees for issuing these licenses, the process is, in my opinion, duplicative at minimum. As the chairman noted, this bill simply the bill allows a state license holder to bring action in district court if the municipal licensing law governing that occupation or business is more stringent than the requirements imposed by the state or if it causes an economic hardship. If the license holder prevails, the bill authorizes the court to enjoin the enforcement of the municipal ordinance and provides for payment of attorney's fees and court costs by the municipality. Simply put, the rule ought to be one job, one license, and you're good to go to work. Mr. Chairman, I'll be happy to respond to questions.
All right. Thank you, Mr. Lauterbach. Members, any questions? Okay. Thanks for your testimony. Let's go with Ann. And I've got you on here on behalf of Texas Appleseed opposed to House Bill 2266. Is that correct?
That's correct.
Okay.
Yeah.
Thank you. Go ahead.
My name is Ann Badur. I'm the director of the Fair Financial Services Project at Texas Appleseed, and I'm here to speak in opposition to House Bill 2266. Our top line concern with this bill is, I understand the chairman's intent to support small businesses, and small businesses are definitely an economic engine. But one of the things that we're really concerned about is that this bill is drafted would likely upend 49 substantially similar ordinances regulating payday and auto title lending at the municipal level in Texas. These ordinances actually support small businesses because many small business owners get tied up in these loans and end up losing their truck, electricians losing their truck, or people losing their way to get to work. And so these ordinances have proven to be beneficial. They cover 11 million Texans currently and run the gamut from cities like Midland, Amarillo, and El Paso in the western part of the state to Bryan, College Station, Waco, and Longview, Houston, Austin, Dallas. It covers a whole range of cities in Texas. And just to give you an idea of payday and auto title lending, right now at the state level, there's extremely light regulation. A lot of the key problems with this area of lending, like uncapped fees that amount to APRs of 800%, often, there's no limit, but I've seen loans 800, 900% APR. A typical $500 loan costs between $1,100 and $3,000 to repay, and the economic impact of these on communities is quite quite harmful. A recent study by the Perryman Group found that these businesses resulted in a $1.6 billion annual loss in the gross annual economic output, as well as an annual loss of the equivalent of 2,100 jobs. So we find these ordinances to be beneficial. Communities have come together because they had a problem that they needed to address, and this has been something that's been successful across many communities in Texas. Many people are invested in these, both faith communities and nonprofits, and even local business leaders. And so I hope that you'll take this into consideration, that this bill, though you may have one particular intent of helping small businesses, the expansiveness of the bill could actually hurt a lot of small businesses as well as financially vulnerable Texans. So thank you very much.
Okay, and thank you. Members, any questions? Thank you for testifying, Ann. Tim Morstad. Tim, I've got you here on behalf of AARP, registered against House Bill 2266. Is that correct?
Yes, sir, Mr. Chairman.
Okay, go ahead.
Thank you. As you said, my name is Tim Morstead with AARP here in opposition to HB 2266. We're concerned that the bill would undo the payday and auto title lending ordinances that Ms. Badur just talked about, and for many of the same reasons. Older Texans have a stake in preserving these ordinances. We know that about 1 in 5 payday lender borrowers here in Texas are 50 and older. And we also know that there's a lot of older Texans helping their kids and grandkids break free from these high-cost loans. And these ordinances that are currently in place are really a backstop. They really are basic protections. So what we do is we're asking for you to take a look at those provisions that we feel would undo the ordinance and remove them from the bill if possible. And thank you for the opportunity.
All right. Thank you, members. Any questions? All right. Thanks, Tim. Luis Figueroa?
Yes, sir.
If you'll, sorry, I have you registered on behalf of every Texan and testifying against House Bill 2266. Is that correct?
That's correct, Mr. Chairman.
All right, go ahead.
Yes, I'm Luis Figueroa. I'm the Chief of Legislative Affairs for Every Texan, formerly known as CPPP. And we are largely opposed to bills that do broad preemption. We're neutral on the fact of whether or not we should have occupational licenses and how many we should have. But to the extent that there are cities and counties that are trying to address the needs of their communities, we don't think that the legislature should undo 49 payday lending ordinances that have been approved by the elected officials in those communities and supported by the local community. And polling has shown that many of Texans feel the same way. 87% of Texans voters believe their local elected officials are better connected to their communities and should be allowed to pass these policies that reflect their community needs and values. But fundamentally, our big concern of this, as stated by Ms. Badur and Tim Morstead, is the impact on payday lending and the financial devastation that it could break on low-income communities, racial and ethnic minorities. They should have a chance to provide for their families without ending up in endless cycle of debt. So we encourage you to try to work with local communities. We can look at occupational licenses, but we'd rather we not completely undo local ordinances related to this broad area. So we appreciate the time, and hopefully we can work together on this.
Okay, members, any questions? All right, thanks to each of you for being here. We've got one other witness, Jenny Andrews. If anyone else wishes to testify on, for, or against House Bill 2266, please. Yes.
I believe I registered.
Okay, hang on just a sec. Jenny, you can come on up.
Thank you.
What's your name? Oh, okay, down here at the bottom.
Yeah, so just had you just registered.
Okay. Chair calls Ana Gonzalez and Jenny Andrews. Jenny, let's start with you.
Okay.
Jenny, I've got you here registered on behalf of the Texas Catholic Conference of Bishops against House Bill 2266. Is that correct?
Yes, sir.
Okay. Go ahead.
Okay. My name is Jenny Andrews. I'm a policy analyst with the Texas Catholic Conference of Bishops, and we're testifying opposed to HB 2266 as introduced. We did meet with your office today and offered some language for consideration that would exempt the payday lending ordinances from the bill, and we hope to work with you on making those changes.
Okay.
the witnesses before spoke to the payday lending ordinances, their importance, why we favor them, and so I won't repeat that. We also have concerns about the bills affecting sexually oriented business ordinances, and would be interested in discussing those concerns with you as well. At this time, we urge for correction to be made to HB 2266 before being advanced from committee. The bishops ask the committee to protect the ability of local communities to protect the poor and vulnerable in their midst, as well as the families and children who may be exposed to sexually oriented businesses. And with that, we, skipping around here. We just want to say, Chairman Leach, that we have great respect for you, and we look forward to working with you on this issue.
Great, thank you. I have great respect for you all too. Members, are there any questions? Thank you for your testimony. Chair calls Ana Gonzalez with Texas AFL-CIO opposed to House Bill 2266.
Good afternoon, Mr. Chairman and members. My name is Ana Gonzalez. I am the Deputy Director of Politics and Policy of the Texas AFL-CIO, which represents 240,000 affiliated working people across our state. I am here to testify against HB 2266. Our biggest concern is how broad the bill is, and we had an opportunity, Mr. Chairman, to visit with your office yesterday. We appreciate your staff's time. But we are concerned about how it prohibits activity that otherwise regulates the occupation of business or business activity of a license holder within the municipality or the municipality's extraterritorial jurisdiction. This goes way beyond limiting actual licensing schemes at the local level. There's really no clarity on how far that might go. As written, HB 2266 could threaten good jobs by potentially preventing Texas City from providing incentives and encourage businesses to hire locally, pay living wages, offer workers' compensation insurance, and additional safety training because those policies might be seen as affecting a license holder. We have concerns that this bill could potentially preempt basic worker protections like rest breaks for construction workers. Also, we have concerns that this bill will not allow cities to continue to require wage and safety standards on certain projects or around economic incentives. We are not convinced that there is a need to limit local authority to have additional licenses. But even if you do, it should not be done in a way that it doesn't go beyond it doesn't go beyond that to affect the connection to the license itself. I thank you for your time, and I am happy to answer any questions.
Okay, members, any questions? Okay, I want to thank you, Chairman Moody.
I don't think I've ever gotten to have you testify in front of a committee I'm on, so I have to take this opportunity. Anna served as my district director after taking some work on my campaign, where she was very nervous about talking to people at the doors.
I'm still.
But I will tell you, she became one of the best and most just efficient, awesome workers, and did an amazing job for the constituents in my district when she was there. And like so many people that, get into this work, they elevate when they do really good things. So I knew one day that she would probably get beyond my office, and I'm proud of all the work that you're doing for working people. Not just, obviously you did that when you were in El Paso, but doing that for all the people across Texas, something that makes me incredibly proud. And I'm grateful that all those skills that I taught you are now going. I certainly have learned just as much from you and your work ethic. And so I appreciate everything that you're doing. And I would just say, you've worked with the chairman's office before. If he's after a certain activity or certain practice, and it needs to be narrowed down, I know that's something that unintended consequences are not something that he takes lightly. So I appreciate you coming and raising those with his office too.
Thank you, Mr. Chairman. I'm definitely proud, and I was very honored that I had the opportunity to work for you and for our city. And thank you for everything you do for working families in our state.
Anything else between the two? Members of the Representative Flores. Representative Flores.
She's just a badass Latina, and you're taking credit for it.
Representative Vasut.
Well, you know, she's under oath, so we could really ask anything we need to know about.
No, they all signed NDAs, sir.
Right. Members, any other questions? All right, thank you both for being here.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 2266? Seeing none, the chair will make myself available for questions. Members, if there are none, I will close on House Bill 2266 and leave House Bill 2266 pending at this time. The chair now lays out House Bill 2778, and I'll recognize myself to explain this bill. Members, the State Office of Administrative Hearings is the executive branch agency created to serve as an independent forum for conducting administrative hearings in the executive branch of state government. Since SOA's last Sunset Commission review in 2015, SOA has taken broad steps to modernize its technology, streamline its organizational structure, and promote greater quality and uniformity in its hearing practices across multiple case types. This bill is intended to codify many of these interim improvements. The provisions of this bill can be broken down into three primary issue areas: technology-related improvements, organizational improvements, and the repeal and update of outdated statutory provisions. They're all very self-explanatory in the bill. Members, in the interest of time, unless you want me to go through the details of the bill, I'll move to close because we do have a resource witness here that is available if you want. But members, at the end of the day, we are working on a committee substitute to clean up and tighten some of the language to address just a couple agency and stakeholder concerns that were brought up, and I'll have that committee substitute to you shortly. I'm happy to answer any questions that you have. And again, we've got a technical or a resource witness here who can answer any technical questions you've got. Okay, doesn't look like you have any questions for me. So with that, members, do you have any questions for a resource witness? Shane Linkus. Shane, come on up. I've got you here on behalf of the State Office of Administrative Hearings, registered on House Bill 2778.
Correct.
Okay.
Yep.
If there's anything that
Here's
you
a
want to
resource.
offer, go for it. If not, I don't think there's any questions from the committee.
Yeah, unless y'all have any specific questions, I'm happy to answer those. I'm also, if there's other witnesses, I'm happy to listen and stay around and answer any questions that might come up in the process.
Okay, members, any questions? All right, thanks for your patience today. Appreciate it. With that, does anyone else wish to testify on, for, or against House Bill 2778? Seeing none, the chair will, still no questions. All right, the chair will close and leave House Bill 2778 pending at this time. The chair now lays out House Bill 4218. Members, I'll lay this bill out, and then we've got a few witnesses here. House Bill 4218 makes an important legislative improvement to House Bill 19 that we passed last session. I do want to make clear at the outset that we are not going to relitigate or re-adjudicate or redo anything that we did last session with House Bill 19, the trucking bill that many of us worked so hard on. This is not an effort to do that. This is an effort to address an area that was left unaddressed after last session. As you may remember, House Bill 19 addressed skyrocketing cost of insurance issues and challenges facing Texas business owners due to the rise of what some could consider to be abusive lawsuits brought against them and their commercial vehicle areas. HB 19 provided, we believe, needed relief for Texas businesses that employ their drivers, but a gap remains that uniquely impacts truck leasing and rental companies who own but do not operate their vehicles. Truck rental and leasing companies have been named in and pulled into suits, claiming that these companies could have equipped or retrofitted the rental vehicle with a device or technology that they claim could have theoretically prevented an accident. The industry refers to these claims as, quote, failure to equip, or, quote, optional equipment claims. And we're starting to see them have a negative impact across the country, including here in Texas. This bill clarifies that a defendant in a lawsuit is under no duty to select or retrofit a vehicle with component parts or equipment that are not required by applicable federal motor vehicle safety standards in place at the time the vehicle was manufactured or sold. Again, under the provisions of this bill, a defendant, it'll be clear the defendant's not under a duty to select or retrofit its rental vehicle with any parts or equipment that at the time the vehicle was manufactured or sold are not required by applicable federal motor vehicle safety standards. I believe, members, this bill is an important step toward curbing what could be an oncoming rise of frivolous lawsuits brought against Texas businesses that are in the business of renting and leasing vehicles. And most of these businesses are making a good faith effort at following the law. They are following the law. They're complying with all safety rules and regulations, and I think that our laws should protect them as they attempt to do so. With that, members, I'm happy to take any questions, and we've got a panel of witnesses that I'll call up to help us walk through this. Okay, the chair calls Jake Jacoby, Jason Boatwright, Steve Bresnan, and Laura Temez. Why don't you all come up together? Jake, let's go with you first. Jake, I've got you here testifying on behalf of the Truck Renting and Leasing Association in support of House Bill 4218. Is that correct?
That's correct.
Okay, go ahead.
Thank you, Chairman Leach and members of the committee. My name is Jake Jacoby, and I'm President and CEO of the Truck Renting and Leasing Association. We're an association based outside of Washington, D.C., and we have about 500 members. I'm here to talk about HB 4218 in support, which is, as the chairman said, is basically making an improvement to HB 19, not opening it up, just filling in what we call a gap. We have seen failure to equip claims that unnecessarily expand civil liability to companies that lease and rent trucks and create exorbitant costs that are largely passed on to your constituents. Trial represents 99% of all companies that rent or lease commercial trucks, tractors, and trailers. Our members purchase and maintain more than 30% of all Class 3 through 8 tractors and trailers in the United States. About 85% of our customers are small businesses. These members of ours demand and require fully compliant Department of Transportation trucks with cutting-edge technology and safety equipment. What HB 19 showed was businesses, when they did their best to follow the rules, perform their best practices, would not be shuttered due to these nuclear verdicts. And I will suggest that while you did terrific work, there is a gap that remains in this failure to equip issue. These claims that uniquely impact leasing and rental companies who do not employ the operators of their vehicles. The plaintiff's bar has advanced theories to circumvent federal law, which prohibits the imposition of vicarious liability on leasing and rental companies solely based on ownership. In the courts, these claims have been allowed to proceed even though in some instances the technology was not available at the time a vehicle was built, the customer did not want such technology, or the law did not require it. The federal agencies that regulate our industry continue to perform additional studies and testing to measure the performance, safety, and efficacy of these technologies. The imposition of state tort liability based on the absence of optional safety technology undermines federal objectives with respect to regulation of this technology and imposes a legal duty that conflicts with the federal government's careful consideration of the issue. So just to be clear, I'm not here to argue against corporate responsibility. If a truck leasing or rental company does not maintain the vehicle or entrusts it in a negligent way, they should be held liable. But if a company follows all the laws, fully adheres to the rules and regulations regarding safety equipment and mandated by law, then it should not be held responsible for the actions of a customer. I would like to point out that my members have seen their insurance rates, many of them doubled just in the last 2 years, in large part because of these verdicts. Insurance rates, premiums, in some cases have gone up 2, 3, 4-fold just in the last 2 years. So when HB 19 was passed, we felt that Texas blazed a path, bringing some common sense back into commercial vehicle personal injury trials. This is why it's so important that we get this right. Passing HB 4218 will close an important gap that was inadvertently missed in the original passage of HB 19, thereby allowing Texas to continue to lead by example. Thank you, and I'll be happy to answer any questions you may have.
Okay. Thank you, Jake. Members, any questions? All right. Thanks for your testimony. Thanks for your patience as well. Laura, we go to you?
Sure.
Okay.
Yes.
Chair calls Laura Temez. I've got you here on behalf of the Texas Trial Lawyers Association testifying against House Bill 4218.
Yes, good afternoon, Mr. Chairman, members of the committee. Laura Temez, Texas Trial Lawyers Association, and testifying on their behalf against the bill. At the end of a very challenging session for all stakeholders involved in HB 19 commercial motor vehicles, due to the good work of this body, as well as you, Mr. Chairman, we were able to come up with a balanced bill for all Texans and companies alike. It's an honor to meet with stakeholders, and at your direction, we did make the attempt over the last couple of weeks to do so. We finally met last night, had a conversation, and came away with the perspective, or a new perspective, because the question became, why would a rental leasing truck company who rents out for personal use want to live in the code that is now Chapter 72? When if Chapter 72 contemplates employer, employee, principal, agent, that where the employer is going to stipulate to course and scope, and that is their employee to derive a benefit of a bifurcated trial, then what would, because there's a Graves Amendment that really exonerates them from vicarious liability, why would they want to be, or what would be the benefit derived in the bill? After, having a conversation and understanding their thought process, and looking at or going back to the history of last session, personal use was specifically excluded. First of all, it is now brought back into this bill. The condition of the vehicle was a real concern in terms of putting vehicles on the road that were dangerous, that weren't properly maintained with equipment. Within the new 053 subsection D, there are, yes, terms like retrofit and component parts and equipment that are not defined, that could be, if as broadly as they are currently, could be they didn't install proper brakes. Negligent maintenance was something that was kept out of the bill. If there was negligent maintenance, that would live in the first phase, and all of the evidence would go into the first phase. But here, in again, subsection D, line 19, evidence related to that is not admissible in any phase of the trial. Evidence related to maybe a new standard of care when it comes to whatever equipment or retrofit is concerned. So without those definitions, it leaves, it's a broad stroke. It would really cover all commercial motor vehicles, not just the leasing company, and those are the concerns that we had. But with that said, before this hearing, we have committed to, since everybody's here, not everybody, but some of the stakeholders are here in town, committed to, after this hearing, visiting with them further, now that we've got a news perspective.
Okay, that's great to hear. Thank you. Yes, Chairman Moody. Thank you, Laura.
Thank you, Laura, and I apologize I missed a portion of that. It's just that time of session. I had tried my best to just kind of forget everything from last session, but you've now brought some of it back to my attention. And I had a great meeting with the folks from Penske, and so understand, and I know the spirit of HB 19. Those were very, very detailed, very, I mean, we got into, minute details of federal regulations. I mean, really got into the weeds on all that up and until the point it came to the House floor, which is a testament to the willingness of everybody to work on it to get it right and to get people to come together on it. But it also means that I think this body, and I'll include myself in that, is going to want to be very sensitive to and very laser focused. If there's something that maybe was missed or needs to be tweaked, I just want to, that's the direction I want to give folks to do, to do a little bit of service to the work that we put into.
Chairman, I made that clear. Did you miss my
I was
my
I had a meeting outside. I apologize.
I said it very clearly in my layout. We're not going back on HB 19.
No, I'm just kidding.
No, we do believe that this.
No, I know. And those negotiations, and everything was, everybody was working hard, very hard at the table, all parties involved. And so I know, and I just want to reiterate that from my perspective. If there's something that needs to be tweaked, I'm not opposed to it, because we know what the spirit of what we were trying to get at in those negotiations was. And so if we can keep in line with the spirit of that without disturbing what we settled, then let's figure that out. And I'm glad that you all are committed to working with all the parties. That's the best way to work these things out. So thank you so much. I appreciate your comment.
Thank you, Chairman Moody.
Yep, thank you. Well said. Members, any other questions for Laura? Thank you. The chair calls Steve Bresnan.
Thank you, Mr. Chairman. My name's Steve Bresnan.
Hang on, Steve. I'm going to introduce you for you. You're here testifying on behalf of the Texas Trial Lawyers Association against House Bill 4218, correct?
Yes, sir.
All right, go ahead.
Okay, thank you, Mr. Chairman. I want to follow up on my president's explanation about how this opens up HB 19 in at least two ways. It strikes the current definition of personal use and replaces it with one that if you make personal use of your Suburban, it's a rented Suburban, and it's over 6,000 pounds, which they run about 6,100 pounds, according to the internet, if you can believe that. Then under this bill, it would be a commercial vehicle because you rented it. And I'm specifically looking at on page 2, lines 1 through 7. It's if you're using it for personal, family, or household purposes, it's not a commercial motor vehicle unless it weighs at least 6,000 pounds, and the owner's liability is governed by, that's the Graves Amendment that's referred to on line 8 there. So it would become a commercial motor vehicle even though you're using it for personal, household, or family use. That's a significant deviation from House Bill 19. The second place it does is on page 2, lines 11 through about 2/3 of line 13. In a civil action under this subchapter, the duty of care applicable to an owner, lessor, or operator of a commercial motor vehicle involved in an accident, I'm going to skip the next phrase, does not include an obligation to retrofit. In the middle of that, or a person renting the vehicle to another person. So the first phrase takes in every commercial motor vehicle. That was not part of House Bill 19. And it goes beyond the renting of a motor vehicle as I read it. Not only that, as Ms. Temez pointed out, that was about vicarious liability, employer-employee relationships, House Bill 19. This provision, whatever its merits, doesn't have a thing to do with employer-employee relationships. It is simply in the wrong place. Even if you like it, it has no business being in subchapter B of chapter 72. A couple of quick more points.
It's not in subchapter B, though. It's in subchapter D.
No, sir. That's a subsection D of that's within subchapter B. Yes, sir.
Okay, got it.
I've passed out to you the current products liability law, which the most recent major amendments were in 2003. The Texas Supreme Court, the Fifth Circuit Court of Appeals, and the First Court of Appeals have held that the provision of 82.008 there, which is on page 2 in the middle of the page, provides a government standards defense where there's a product involved, a truck is a product, and there's a seller involved, and the definition of seller on page 1 clearly includes people who rent trucks. Here's 2 sentences of what the Texas Supreme Court said. The Ruizes have not, for example, alleged that the Spectra is defective because it lacks an additional occupant restraint equipment, such as a third frontal airbag that federal standards do not require. Had that been the case, the presumption in 82.008 would have applied. They applied the right case, and I can give you the citations to all of these, and Hamid applied the right case as well, which was the Fifth Circuit case. The status of the law right now is that this section 82.008 governs this issue. This is not required legislation. The company pled it. The company supported it with citation. They did not prevail on summary judgment. In the one case in this state that's gone anywhere, and it was settled in Dallas. After that summary judgment, they did not prevail on. There are no other open cases, despite a provision, the last provision in the bill, that would apply this bill to pending cases. So the law is already well stated. There's no crisis here. There was one case, and it opens up House Bill 19, which we respectfully request you not to do.
We're not going to do.
Thank you, sir.
Steve, thank you for the members. Any questions? All right, our last witness on this bill, Jason Boatwright. Jason, you're here on behalf of Penske, as counsel for Penske.
Yes, sir.
And you're testifying for House Bill 4218. Is that correct?
Correct.
All right, go ahead.
Thank you, Mr. Chairman, committee members. Appreciate your time. My name is Jason Boatwright. I'm an attorney at the law firm of Dwayne Morris in Dallas. We represent Penske. Penske is primarily a truck leasing and rental company. I'm here today solely on behalf of our client. I'm not testifying on behalf of the state agency or tribunal. In the last regular session, the legislature enacted HB 19, which is a great bill that addressed several important problems. HB 19 provided protection for employers whose employees negligently operate their employers' commercial motor vehicles. HB 19 did not provide protection for leasing and rental companies like Penske, whose vehicles are almost always operated by people who are not Penske employees. In some ways, leasing and rental companies have fewer protections than those who actually employ drivers and operate the vehicles. HB 4218 would fill that gap in legal protection. For now, though, the gap still exists, and plaintiffs have sought to exploit that gap. The cost of the lawsuits and settlements can have significant implications for our state. Eventually, the cost of leasing or renting vehicles will become prohibitively expensive, driving up the price of groceries, retail, or online goods, or basic household items needed by all Texans. All cases are different, but there are a few common facts. For example, someone rents a truck from Penske to move to a new house, or a retailer, manufacturer, or small business leases a fleet of vehicles. The driver of the leased or rented truck is involved in an accident. No employee or contractor of Penske was operating the truck. There's no allegation that Penske negligently maintained the truck was operating improperly, or that Penske entrusted the truck to a person who was not properly licensed or qualified. But the injured party sues Penske based on the absence of optional safety equipment on the vehicle. These claims for failure to equip or optional equipment seek to hold Penske responsible as if it were the manufacturer or the operator. In some of these cases, Penske is being forced to answer for a customer's decision to decline the features when placing an order for new trucks with Penske. In other cases, Penske is being forced to defend a decision not to select technology that the vehicle manufacturers were not recommending, the efficacy of which is still yet to be proven, that the federal government is still studying, and that the law does not require. For years, the National Highway Traffic Safety Administration has researched some of these technologies, including a group of technologies broadly known as collision mitigation systems, CMS. The fact that NHTSA has devoted significant resources to this technology and continues to study the issue 7 years later reflects the complexity of the issue. Penske has argued that the failure to equip claims are preempted. That is because the federal government regulates the kind of equipment, what kind of equipment must be installed in commercial motor vehicles, and Penske complies with all the federal regulations. Penske continues to maintain that the claims are preempted, but because the federal government's evaluation of this new and rapidly developing technology is ongoing, some courts have declined to find these claims preempted, including here in Texas. Section 3 of HB 4218 codifies what we believe to be a sound principle.
No, go ahead.
All right. If a vehicle does not comply with the federal motor vehicle safety standards, then a claim is viable. In this way, HB 4218 forecloses claims when the equipment is not federally mandated. It ensures leasing and rental companies are not penalized for complying with federal safety standards. HB 4218 does not try to absolve leasing and rental companies from responsibility for failures to maintain a vehicle properly or to exercise ordinary care in entrusting a vehicle to a customer. We think the bill is reasonable, appropriately targeted, and necessary. I'd be happy to answer any questions that you have. Thank you very much.
Okay. Thanks for that testimony, Jason. Members, any questions? Can the four of you go lock yourselves in a room and talk a little bit?
Yes, Mr. Chairman, we can do that.
You sending dinner?
Yeah, sure.
Or shall we?
Yeah, look, I appreciate that. Members, any questions for the witness? Okay, or the witnesses. I appreciate the good faith discussions that have already been had, and I would encourage you, I would implore you and request you as the author to continue those, please. and to report back as soon as possible.
Yes, sir. We'll do that. Thank you very much.
Thank you. Members, are there any questions for me as the bill author? If not, I will close on House Bill 4218 and leave House Bill 4218 pending at this time. Members, we're going to take up pending business as we've got all the members of the committee here and present. While you're looking for your pending vote lists, yeah, all of the everything's eligible. Yes, that's right. If you after this, we'll take up my remaining House Bill 3504, and then we'll go into the other pending business. Starting with Vice Chair Johnson's bills, then Representative Schofield and Vasut and Flores, and then we'll end with Representative Slauson and then Representative Toth's bills. So, members, let's take up some pending business. The chair lays out House Bill 2636 as pending business. This is Chairman Murr's bill relating to the liability of a recreational vehicle park or campground entity for injuries arising from certain activities. There is a substitute. Representative Schofield offers up the committee substitute. Members, the committee substitute is alleged council draft of the bill filed, contains no substantive changes. Are there any questions? Is there any objection to the adoption of the substitute? There being no objection, the sub is adopted. Representative Vasut moves that House Bill 2636 as substitute.
Can I just ask a question?
Sure.
Did this get sorted out?
Yes, if I may.
Yes,
Mr. Chairman. It's alleged council draft, but it also contains the one change that we worked with stakeholders to get to. Yes, it is agreed.
Okay. Members, is there any other, are there any other questions? The sub is in front of the committee. It's been adopted. Representative Vasut moves.
He's trying to tell me what they're
Okay.
He's not trying to, I'm trying to ask him, and he's having problems telling me he just wants me to trust him blindly. Oh, Lord.
It's a simple bill, it's an easy bill.
Ma'am, Mr. Chairman. So in speaking with stakeholders, we made conforming changes as far as the language that was being used. And I don't have the language sitting right in front of me, and I'm happy to ask the chairman to give me a few minutes, and I will get that and show that to you.
Any other questions for Chairman Murr? Representative Vasut again moves that House Bill 2636 as substituted be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll. Go for it.
Leach?
Aye.
Johnson?
Aye.
Davis?
Aye.
Moody?
Aye.
Murr?
Aye.
Schofield?
Aye.
Vasut?
Aye.
Slauson? Flores?
There being 9 ayes and 0 nays, the motion prevails. The chair lays out House Bill 603 as pending business. Members, this is Representative Shaheen's bill relating to a limitation on civil suits against persons reporting suspicious activity in good faith. Are there any questions? Representative Murr, Chairman Murr moves that House Bill 603 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach?
Aye.
Johnson?
Aye.
Davis?
No.
Moody? Murr?
Aye.
Schofield?
Aye.
Vasut?
Aye.
Slauson? Flores?
There being 8 ayes and 1 nay, the motion prevails. The chair lays out chair lays out House Bill 1989 by Cook. This is Representative Cook's bill relating to the fees assessed by a district clerk for copies of certain court documents. Are there any questions? Chairman Moody moves that House Bill 1989 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach?
Aye.
Johnson? Davis? Moody? Murr? Schofield? Vasut? Slauson? Flores?
There being 9 ayes and 0 nays, the motion prevails. Members, the chair lays out House Bill House Bill 527 by Wu. Members, this is Representative Wu's bill relating to the exemption of certain civil actions from being subject to a motion to dismiss on the basis of involving the exercise of certain constitutional rights. There is a substitute. Representative Flores offers up the committee substitute. Members, this is a committee sub that was laid out during our March 15th hearing 2 weeks ago. Makes clear that the only exclusion listed in the bill pertains to the initial action against an attorney for legal malpractice from protection under the TCPA. Are there any questions? Is there any objection to the adoption of the sub? There being no objection, the sub's adopted. Vice Chair Johnson moves that House Bill 527 as substituted be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson. Davis. Moody. Murr. Schofield. Basut. Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. Chair now lays out House Bill 530 as pending business. This is Representative Wu's bill amending the Family Code by replacing the phrase mental retardation with the phrase intellectual and developmental disabilities. Are there any questions? Yes.
Is this not like the Craddock bill?
There are the Craddock bill, this is definitely like the Craddock bill, but there are some instances that this bill touches that the Craddock bill did not.
Okay, so it is
The Family
necessary,
Code,
not
correct.
necessary. Okay,
Correct.
thank you.
Representative Basut moves that House Bill 530 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson. Davis. Moody. Murr. Schofield. Basut. Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. Members, the chair lays out House Bill 19 by Murr. This is Chairman Murr's bill relating to the creation of the business courts. There is a committee substitute. Hang on just a sec. I know people are going to have questions, and that's fine. Chairman Leach lays out the committee substitute, and the chairman recognizes Representative Murr to explain the sub, which it was provided to you earlier today.
It was in Dropbox, and there's also paper copies, Mr. Chairman, if members would like paper copies.
Hang on. Everybody, hold on. Hold on. Chairman Murr.
Spider-Man.
Can you explain the committee substitute?
Yes, Mr. Chairman.
What's the number? I just asked for him to, I didn't hear the number.
The bill number is number 19.
Thank you.
Yes, ma'am.
That's what I was asking.
I thought we were still working on this.
And we
Why
are.
are we voting today then? We're still working on it.
We're still working, but we have a committee substitute with some changes.
Chairman Murr, explain the committee substitute.
I'm going to refer to the specific articles. It's all in Chapter 24, Big A. So in 002, it provides that the business court is a statutory court created under Section 1, Article 5 of the Texas Constitution. 003B divides the business court into divisions that are geographically and numerically consistent with the administrative judicial regions established under the Texas Government Code. 004B, it applies a $10 million amount in controversy to all jurisdictional grants. 004B6 narrows this jurisdictional grant to specify that to be within the jurisdiction of the court, the action must allege that an owner, controlling person, or managerial official breached a duty owed to an organization or an owner of an organization. It removes the duty of care from the enumerated list of inclusions. 004B8 specifies that an included action must be one that arises out of a contract or commercial transaction instead of one that simply relates to a contract or commercial transaction. 004B9 similarly narrows this jurisdictional grant to actions that arise out of a violation of the Finance or Business and Commerce Code by the entity of an officer or governing person who, when acting on the entity's behalf, instead of simply those that involve violations. 004B11 removes unnecessary language accepted actions not properly within the jurisdiction of the business court, as those actions would now be clearly exempted regardless under a new subsection E. 004C includes conforming changes regarding the multiple divisions of the court. 004D specifies that unless the claim falls within the business court's supplemental jurisdiction, the business court does not have jurisdiction over civil actions brought by or against a governmental entity, with no caveats. Any claim arising under the DTPA, the Estates Code, the Family Code, or Title IX of the Property Code, regardless of whether or not the parties agree. There's a new subsection E that states very expressly that even if it's within the court's supplemental jurisdiction, the court shall not have jurisdiction over any claims in which a party seeks damages for bodily injury or death. 006A includes conforming changes stating that a plaintiff filing in the business court shall plead facts that establish venue in a division of the business court, and that the action shall then be appropriately assigned to the venue with jurisdiction. 006C includes similar conforming changes regarding geographic territory. 006E, conforming changes specify that the clerk shall assign a removed action to the appropriate division. F, removes unnecessary language if a filing is subject to section 10.001 of the Civil Practice and Remedies Code. A party could already file a motion for sanctions. I includes conforming changes regarding divisions. J specifies that upon establishment of jurisdiction and venue over an action, shall by order declare that the county in which any jury trial for that action will be held will be determined, and so that it's very express and on the record by the judge. 7, that's 007, conforming changes to the appeals section, that if the 15th Court of Appeals were not created, appeals go to the Court of Appeals with regional appellate jurisdiction for the county declared to be the county in which a home trial would be. 008A3 specifies that to be appointed to a division of the business court, the individual must have resided in a county within the division for at least the last 5 years before the appointment. 009 contains conforming changes to specify that each division shall have one judge, and that to promote the orderly and efficient administration of justice, the business court judges may exchange benches and sit and act for each other in any matter pending before the court. D, and that's going to be 017D, non-substantive conforming changes. 020B clarifies that the business court may adopt rules of practice and procedure so long as they are consistent with the Texas Rules of Civil Procedure and the Texas Rules of Evidence as applicable. And then there is a section 6 that staggers the creation of the divisions and specifies that the governor shall appoint judges to the 1st, 3rd, 4th, 8th, and 11th divisions in 2024, and that between July and September of 2026, the governor shall appoint judges to the remaining 6 divisions. In part, that's done in order to make the fiscal implications of the bill less during the 2-year biennium. And I'm happy to answer any specific questions.
Members, the committee substitute is before the committee. Are there any questions? Is there any objection to the adoption of the substitute? Okay, the sub is adopted. The substitute is now before the committee. Are there any questions for Chairman Murr?
So I have a
Representative
question.
Davis.
This is a process question. Typically, when you have these big, large bills like this, and you have people working together, as you indicated to the group prior to this, us voting, the parties get together and they come up with what they can come up with, but they get back and say, we've worked it out. This is what we can do, or this is what we can't do. It's very unusual for us to then just do a bill this large without having gotten somebody getting back saying, we exhausted all our avenues to come in the middle. I get that. I might not know all the legal ramifications. I have one major deal with it as it relates to being appointed judges versus elected judges. But that being said, I think it's important that if we're going to have teams, as Mr. Murr was saying a while ago when he thought I just was trying to ask clarification for what he's doing, that he worked it out with Craig. I guess I need to ask him, did this get worked out with Craig? Because we have no idea what all you've agreed to in his sub. And just saying it this afternoon, it just seems to me like we're rushing this thing. And well, I will clearly admit that there's some things I might not know. but I know when I'm getting run over, and I figured this is what's kind of happening with this going this fast.
Well,
It would have been nice if we would have had some idea that the committee substitute was going to be ready today and that we would be voting so that we could have somebody at least brief us on the changes and the adjustments that have made it better if they did. So that is my comment.
well, I'm gonna speak for myself as chairman, Representative Davis, and then I'll let the author of the bill say something. But I assure you that there's no intent or desire on my part for anyone to get run over. When we heard this bill 2 weeks ago, there's been a lot of conversations about this bill going back many, many, many weeks and months, if not years. This is, but when at the end of the day, Representative, when a member, especially a member of this committee, asks me for a vote on their bill, then they're going to get a vote on their bill, and that includes you, that includes Chairman Murr, that includes all of you.
And
So,
nothing I said would take that away from them.
right.
So I don't want you to misrepresent.
I'm not misrepresenting. I'm just stating
No, but I
my
want to be
policies.
clear that that was never what I was saying. I never said, don't let him have a vote on the committee substitute. I merely said that the way the substitute has come out so fast this afternoon, and it's such a big bill, and we did have working groups on it, that it would appear that we're being overly, we're rushing through it now. That's my thought.
Okay.
But I never said he shouldn't get a vote on. I never said we shouldn't take it up. I'm just saying this is a large bill. There was a lot of different discussion, a lot of different testimony, and there are a lot of components of it. He did go through his bill with telling us what that does, but there's some questions we may have for the other side of what's the net effect of that, and we don't know. We don't have time to do that.
Okay, well, I'm going to let Chairman Murr answer your.
Well, no, mine was a process question, so he can't answer that. Thank you.
Okay. Yes. Vice Chair Johnson.
Yeah, I'm just going to express my disappointment in voting this bill out right now because I had a great meeting with Chairman Murr yesterday, and I left that meeting thinking we were going to work and address a couple of concerns that I had. And so I'm stunned that we're voting this out right now when we just got the committee sub on this significant of a bill. To Yvonne's point, Representative Davis's point, to have a chance to really thoroughly vet the committee sub with other key stakeholders. I think it's inappropriate. I understand why you called it for a vote because a member asked, but I think it's premature, and I'm just expressing my extreme disappointment. I would have expected to have another week or at least a few days to process the committee sub that came out this afternoon.
Chairman Murr.
Just to address some of the comments, I've worked with all stakeholders, will continue. I maintain an open door policy. I also recognize the fact that as a bill goes through the process and gets to the floor, we'll have floor amendments. We'll have a discussion for that as well. Received the input after multiple meetings, which I spent most of yesterday with, and did receive the committee substitute back later this afternoon. That's the process, and that's where we are. So. And in no small part, some of the changes here are in response to meeting with interested stakeholders from all walks of life and including members. So.
Okay. Members, any other questions or comments? Okay. Representative Schofield moves that House Bill 19 as substituted be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach?
Aye.
Johnson?
No.
Davis?
No.
Moody? Murr?
Aye.
Schofield?
Aye.
Basut?
Aye.
Slauson? Flores?
All right. There being 5 ayes and 4 nays, the motion prevails. Members, that's all we're going to do tonight for pending business. The chair lays out House Bill 3504. Representative Basut offers up a committee substitute to House Bill 3504. Members, this is my bill. This is addressing mental health services and changes that need to be made to the Texas Mental Health Code to ensure that all Texans have access to the care that they need during a mental health crisis. As you know, Many of you know Texas is experiencing a mental health crisis, and those Texans who are often face significant barriers when seeking help, such as long wait times, limited access to care, and outdated processes. However, this bill seeks to answer some of those concerns, seeking to modernize the court process for mental health cases and to increase access to behavioral health services for those who need it most. The bill ensures that physicians have the ability to apply to a judge for emergency detention order electronically. Secondly, the bill includes the same clarification on jurisdiction that's in Representative Julie Johnson's, Vice Chair Johnson's House Bill 186, that's now passed out of this committee unanimously twice. As a reminder, that provision ensures that an order of protective custody can be filed either in the location where the patient is currently receiving treatment or in the county in which an EDO is executed. Third, the bill ensures that if there is a judge or magistrate on duty after hours, then an application for court-ordered mental health services must be accepted, and it must be accepted in the same manner as other court documents. Fourth, this bill clarifies that an emergency detention order is not a prerequisite to the issuance of an order of protective custody. And finally, the bill allows physicians to testify remotely for good cause shown, including disruption to care of other patients, assuming the court has reasonable available technology. The committee sub adds a number of changes that will address certain court processes that have created the unintended outcome of denying court-ordered mental health care to vulnerable patients. Members, I'm happy to answer any questions. We've got a couple good witnesses here who can help us understand the problem and walk us through what the bill is meant to address. Do any of you have any questions for me as the bill's author? All right, I will reserve my right to close, and we'll call our panel of witnesses on this bill. The chair calls Brad Nitschke, Jennifer Tharp, Steve Wolub, and Chris Ponder. Thank you all for your patience today. Brad, we'll start with you. Brad, I've got you here testifying on behalf of the Texas County Hospital District, doing business as Parkland Health, testifying for the bill. Is that correct?
Dallas County Hospital District, that's right.
Okay. Testifying for House Bill 3504.
That's correct.
Okay, go ahead.
Thank you, Chairman Leach, Vice Chair Johnson, and members of the committee. My name is Brad Nitschke. I'm Associate General Counsel for the Dallas County Hospital District, better known to our patients and community as Parkland Health. I'm testifying on behalf of the health system today in support for HB 3504. This bill is a critical tool to ensure that Texans experiencing a mental health crisis, their families and their communities are afforded the fair, transparent, and effective mental illness court system that they deserve. As Dallas County's public hospital and a regional leader in behavioral health care, Parkland operates one of North Texas' only dedicated psychiatric emergency departments. Patients who are emergently detained at Parkland under the Mental Health Code account for a very significant portion of involuntary treatment cases heard by Dallas County's Mental Illness Court. Parkland's flagship hospital also houses an inpatient mental health facility where patients experiencing mental illness are able to receive both voluntary and court-ordered mental health care. As a result, Parkland's physicians and staff are frequent participants in the process of seeking involuntary treatment for patients whose mental illness puts themselves or others in imminent danger. Through that participation, Parkland's identified a number of structural barriers that have grown up and today stand between some of our most vulnerable patients and access to the treatment that their treating psychiatrists recommend and that the law affords them. Too often, our physicians and behavioral health staff are forced to spend precious time in mental health emergencies, navigating an arcane and ever-changing set of local policies and customs that run afoul of the Mental Health Code and risk delaying or denying treatment to patients whose mental illness has thrown them into crisis. The impact of these barriers, which range from outdated court procedures to unwritten and unpublished procedural rules to court-created jurisdictional criteria that aren't grounded in the plain text of the statute, cannot be overstated. When our physicians and our staff are forced to rely on less than current court procedures to seek legal protection for a patient in a crisis, limited resources are needlessly diverted from bedside patient care. And when hospitals in Parkland's position are ordered to discharge patients who meet the stringent statutory criteria for involuntary mental health care because a court has determined of its own accord to impose a jurisdictional test that not only lacks support in the statute but also disregards the severity of the patient's illness or the imminent threat that their emergency poses to themselves or others, then patients, their families, and the community at large are needlessly placed in harm's way. These barriers are exacerbated by an uneven burden of evidence and burden of proof in some mental illness courts, which requires treating psychiatrists applying for a court order for treatment to explain in written detail how the patient's condition meets the statutory criteria, but allows other interested parties to merely check a recommend or not recommend box in opposing treatment without ever affording a live hearing to test the merits of the parties' positions. That decisions denying treatment based on such an incomplete record lack a clear pathway to appellate review creates a clear and present danger for many of our patients. The reforms that are set out in HB 3504 will together help safeguard precious mental health resources and ensure that patients, their families, and our communities are not endangered by the improper denial of necessary mental health care. I thank you for your time and urge your support of this bill.
All right, Brad, thank you. Thanks for your testimony. Members, any questions? All right, thanks for being here. Is Chris Ponder here?
He was here earlier.
He is.
See him.
Okay, Lee, come on up too. And while you're coming up, Jennifer, the chair recognizes Jennifer Tharp. Jennifer, I have you testifying on behalf of the Comal County Criminal District Attorney's Office and yourself testifying for the bill. Is that correct?
That is correct.
All right, go ahead.
Good evening. My name is Jennifer Tharp. I'm the elected criminal district attorney for Comal County. Prior to being elected, I served as the role of chief civil prosecutor for many years, and I can tell you for our county the last 20 years, what 3504 addresses is some of the hangups that we've had. Specifically, Section 2 and 3, which allows for electronic filing of the paperwork, is going to be a tremendous asset for not only the courts, but also for the attorney's office. And then finally, what I'd like to close on is Section 5. As very eloquently stated by the other witness, we don't have a facility in our community. Most of our citizens in mental health crisis typically travel at least 90 miles to Kerrville, Texas. And so what that leads to is if the court retains jurisdiction in our community, because that individual, when they're released from Kerrville, will come back to Comal County, it's a huge inconvenience for not only the medical professionals, but the psychiatric professionals to provide the needed testimony for the court to consider what's required under the order for protective custody. It's this smart legislation. We already have incredibly limited resources for mental health issues. So I'm testifying again in support of 3504, and I thank you for filing.
Yeah, thank you. Thank you, Jennifer. Members, any questions? Jennifer, thank you for your help on this and so many other bills, and thanks for your patience today. The chair calls Lee Spiller. Lee, I've got you here testifying on behalf of the Citizens Commission on Human Rights on House Bill 3504. Is that correct?
Yes, sir.
All right, go ahead.
All right. Yeah, as the bill was filed, we had no problem with it. We've gone to your office twice looking for a committee sub. We don't know what's in it. We're sensitive to this issue of detentions and holds because for a number of years, like we deal with rights in mental health. And for a number of years, one of the number one calls we got was, help, I'm in a psych hospital and I can't get out. And in some of those cases, it was a lot of cases. A facility up in the Dallas-Fort Worth area got prosecuted for illegally holding patients against their will. They finally pled guilty to one count. We've got to be careful how we do this. I definitely want to look at this committee sub, but we have concerns. It's just so easy to have this happen. You know, this can really be misused because, you know, like, we're so reliant on peace officers to make sure that people are, you know, that these, like, they're really the ones that need to do detentions, and we're concerned about that getting watered down because the peace officer is the one that doesn't have a dog in the hunt. The provider's going to make money off of it.
Okay. Lee, thank you. Members, any questions for the witness? All right. Once again, Chris Ponder. Okay. Does anyone else, thank you guys for being here. Thanks. Look forward to working with you. Does anyone else wish to testify? Y'all can go.
Okay.
Does anyone else wish to testify on House Bill 3504? Okay, seeing none, the chair withdraws the committee substitute to House Bill 3504 and will leave House Bill 3504 pending at this time. The chair lays out House Bill 3952 and recognizes Representative Schofield to explain the bill.
Thank you, Mr. Chairman, members. This bill would give a statutory county court at law a concurrent jurisdiction with the Justice Court in cases of forcible entry and detainer and forcible detainer. Texas Justices of the Peace are overwhelmed with eviction cases. In January of 2022, Harris County Precinct 4 alone had 275 eviction hearings in a single day, which is nearly 34 and a half eviction hearings an hour for a normal business day, which they never get to conduct over there. In Harris County, evictions were up 65% over the average in February of 2022 and 80% in March of 2022, of course, due to the backlog due to the pandemic, and they just can't keep up with that rate. Additionally, we have some justices of the peace who are just announcing that they're not going to follow the law, a theme that we've had here in this committee, and just said, I'm not doing them, I'm not ruling on them, and I'm not granting any, which is not following the law. And therefore, this would give the plaintiff a second venue in which they could file. Now, it doesn't change the rules for any of the courts. So if you want to file in justice court, you get the rules you've traditionally had there. If you want to file in the county court at law, you get the rules that apply there, which is not as quick a timeline. But if you're in an area where you're not going to get any relief, a longer timeline may be better than none. And so, Mr. Chairman, I think we only have one witness, but I will be delighted to answer any questions.
Okay. Members, are there any questions for the bill's author? All right, thank you, Representative Schofield. You've reserved the right to close. The chair calls Corey Rogers. Corey, thanks for your patience today.
No worries. Thank you, Chairman.
Yeah, thank you. I've got you testifying on behalf of the Texas Apartment Association for House Bill 3952. Is that correct?
That is correct.
Okay, go ahead.
Thank you. Chairman Leach, members, my name is Corey Rogers, and I'm an attorney that's practiced in the landlord-tenant area for the last 15 years here in Austin, and I'm here representing the Texas Apartment Association regarding supporting House Bill 3952. And we really appreciate the fact that this bill provides plaintiffs with options in eviction cases. The eviction process in Texas is governed by the Texas Property Code and the Texas Rules of Civil Procedure. It's designed to be relatively quick and accessible to both parties. The statewide framework should theoretically take about a month to go through the whole process from a notice to a writ of possession. Sometimes it takes longer, and in recent years, I and other members in the industry have observed that some justices of the peace are holding off evictions specifically by formal order or sometimes informal action. More options are better. For scenarios where there's a known delay or an issue with being able to have a trial, having access to another court would be very helpful. Currently, property owners must file every eviction in the particular precinct where their property is located. They're at the mercy of whether that particular JP in that particular precinct will allow the case to proceed pursuant to state law and the rules of procedure. If a JP is singling out evictions for delay or not hearing them, property owners are deprived of their property and the ability to access the legal system. I've personally dealt with a case that involved more than 5 months delay, lost over $16,000 to the owner. And even when a JP is operating normally, accidents or errors by constables in not timely serving case can cause delays. And some precincts are unfortunately more prone to these errors than others. Evictions are obviously a last resort, but they're a necessary one. Nobody likes evictions, but sometimes there aren't alternatives. Beyond non-payment of rent, there are many other kinds of cases. Sometimes you have squatters. Sometimes you have people causing property damage or harassing other residents, and they otherwise refuse to leave. House Bill 3952 would allow county courts concurrent jurisdiction over these cases and empower property owners to choose whether it's best for them to proceed in the justice court or the county court. This isn't about judges who do a great job. It's just about creating more options. And with that, thank you very much for your time, and I'm happy to answer any questions.
All right. Thank you, Corey. Members, any questions? Thanks for your testimony. Does anyone else wish to testify on for or against House Bill 3952? All right, seeing none, the chair recognizes Representative Schofield to close on the bill.
Mr. Chairman, I appreciate your consideration and would hope the bill would be voted out. And with that, I close.
All right. I have one question. You got a question, Chairman Murr.
And I missed your layout a little bit. Did you address fees? Will there be a variation, or if there's an option to choose, does that affect the person involved?
The rules of court don't change any for either court. Whatever court you file in, you get the current law.
Okay.
Current fees, current timelines, current everything.
Okay, so that doesn't change, and so do you think that there's any undue burden for anybody? or it's really more of they get to choose?
It's a venue. You choose which venue you want.
Okay. Thank you.
All right. Members, any other questions for the bill's author? You close?
I close.
Okay, thank you. Members, with that, the chair will leave House Bill 3952 pending. At this time, the chair now lays out House Bill 2432 by Vice Chair Johnson, and the chair recognizes Vice Chair Johnson to explain the bill.
Thank you, members. Chairman, appreciate the opportunity to talk to you about 2432 relating to the liability of an owner, lessee, or occupant of real property in connection with the use or entry. The recreational use statute, as codified in Chapter 75 of the Civil Practice and Remedies Code, was designed to protect private landowners who generously offer the use of their private property to others for free for designated certain activities. For example, a rancher allowing a Boy Scout camp, a troop, to use his property to hike or camp or something like that. The problem is that the statute as currently written allows landowners, regardless of whether they charge admission to their property, to cap their damages only to be liable for gross negligence by purchasing a minimum amount of insurance. House Bill 2432 would allow landowners to permit people to use their land for the statutorily allowed purpose, either for free or a nominal cost, without having to fear that they will be subject to lawsuits if their guests are injured. But with these changes, if a landowner does charge excessive fees more than a nominal fee, he or she cannot avail themselves of this limited liability solely because they purchased insurance. Last session, this passed favorably out of the committee, and I would appreciate your favorable consideration again.
Okay.
With that, I reserve the right.
All right, thank you. Vice Chair Johnson, members, any questions for Vice Chair Johnson? Okay. You've got 2 witnesses who've registered to testify.
I think they're gone.
Well, they're both against the bill, so I guess that's a good thing, but let's just give, let's give it let's give it a swirl anyways, okay. All right. The chair calls Charles Maley. Come on up. Sorry, that was a... Let's make sure that they're gone
I know.
before we
I
advise
thought they
the
were
chair
gone.
that they're gone.
I was told you were gone.
And then Eric Obiela. All right.
Eric is.
Charles,
Eric is.
thanks for sticking with us. I've got you registered on behalf of yourself and the South Texans Property Rights Association against House Bill 2432. Is that correct?
That is correct.
All right, go ahead.
Thank you.
Take your time.
Good afternoon, Chairman Leach and members. My name is Charles Maley, and I am Advocacy Director for South Texans Property Rights Association. With a membership base dispersed across the 35 to 40 million acres known as South Texas, we're a leading advocate for the rights of rural landowners. This afternoon, I'm here in opposition to House Bill 2432. 2432, as written, will erase all of the Chapter 75 liability protections for many rural landowners and ag producers across the state. Specific protections that were asked for and granted by this body in 2011 to protect from actions of third parties over which we have no control, as well as protections that encourage relationships with our urban neighbors to visit our rural operations for the health and well-being of them and their families, providing a glimpse into the activities of a working farm or ranch and a better understanding of what it takes to provide food for their tables. A loss of these protections would mean no limited liability for the actions of third parties, whether from a trespasser and their actions or from the inadvertent actions of emergency personnel. Some of our South Texas landowners could now find themselves financially liable based upon the activities of cartel-driven drug smugglers and human traffickers that routinely crash through gates and fences to evade capture by law enforcement. Not only can we not afford to lose current protections, but legislation presently moving through this body to increase some of those protections surrounding criminal activities would also not be available. The resulting loss of these protections could easily cost our rural ag producers and landowners $50 to $100 million in increased premiums and perhaps a complete loss of coverage by their current insurance providers. As of this point, we have been in contact with the bill's author and are hopeful that the committee substitute will keep the vital protections for ag producers but eliminate the abuses of the statute that the author intended.
Okay, thank you, Charles. Members, any questions? All right, thanks for your testimony. Thanks for your patience. Does anyone else wish to testify? Eric's not here? Okay. Does anyone else wish to testify on, for, or against House Bill 2432? Seeing none, the chair recognizes Vice Chair Johnson to close on the bill.
Thank you, Mr. Chairman. I don't believe the bill is as broad as he says it is. It's pretty narrow. I don't believe it has those same risks. But having said that, always willing to incorporate language that satisfies her concerns and look forward to working with that. I closed.
All right. Members, any questions for Vice Chair Johnson? Seeing none, the chair will leave House Bill 2432 pending at this time. The chair now lays out House Bill 3937 and recognizes Vice Chair Johnson to explain the bill.
Okay. Thank you, Chairman, Committee. I appreciate the opportunity to talk to you about 3937, which requires the Office of Court Administration to establish a statewide electronic database of sentencing information free of charge and accessible to the public. This is a John Turner bill from last session, my good friend. He's not here to refile it, and so we filed it for him. The current absence of a centralized database to evaluate sentencing trends to limit the ability for effective public policy making. Today's sentencing data is neither contained in a standard format nor held in a central location. Texans have little insight into the effectiveness of taxpayer dollars spent on the criminal justice system. Without transparency into these processes, we as lawmakers cannot effectively manage criminal justice efficiency and outcomes. Furthermore, this lack of data creates difficulty in understanding the trends driving prison populations and whether statutes are implemented as intended. Access to this data would allow for a cost, benefit, and equity impact analysis. HB 3937 would create a statewide database of sentencing information administered by the Office of Court Administration to include data on demographics, specific information on sentences, and the context in which sentences were handed down. The funding for this necessary IT upgrade at OCA reflected in the fiscal note is already accounted for in both the House and Senate-based budgets. With that, I reserve my right to close, and I think we have one witness.
All right. Thank you, Vice Chair. Members, any questions for Vice Chair Johnson?
I'm sure John is watching just to make sure.
I hope John is watching. If you are, we miss you, John.
All right. The the chair calls Luis Sobron and we got two Lewises. I said Lewis, you both jumped up. Luis and Lewis, correct? All right.
Correct.
Luis Sobron and Louis Tomasetti. Let's start with Luis Soberón. Thanks for your patience. I always love hearing your testimony. If you could, well, I've got you registered on behalf of Texas 2036 for House Bill 3937. Is that correct?
Yes, sir.
All right, go ahead.
Well, my name is Luis Soberón. Thank you, Mr. Chairman and members. I'm here with Texas 2036 in support of the bill. Well, I want to also thank Vice Chair Johnson for refiling the bill on behalf of my old boss, John Turner. I'll be sure to send him, former boss.
Be respectful of Mr.
Maybe I won't send him the video after all from the hearing. I think one of the things that this bill represents is bringing, it's the fruition of the promise that we have in the principle that like cases should be treated the same. Currently, with the data that we collect from district and county courts, we just can't know that for sure. You know, one of the questions, Mr. Chairman, that you asked over the interim when you were discussing Operation Lone Star was how do we do good policy without data? Which I want to have that quote just plastered all over Texas 2036 because that's our motto, and it's the fundamental question. I think in terms of judicial policy, it's really important to try to collect as good of quality data as we can, and particularly in the criminal context. I think this committee, multiple times in committee reports, interim reports, the Texas Judicial Council again and again has cited the need for collecting case-level data. We finally have funding for that in the budget. We've reported a couple of bills out that ask OCA to start collecting case-level data, and this is the natural next question. What do we do with case-level data? And this kind of sentencing information in a publicly accessible database is certainly one of those things that would be a benefit not just to the public in understanding the criminal justice system, but judicial policymakers as well. I'm happy to answer any questions you have, and thank you again.
Luis, thank you. Members, any questions? All right, thanks. Louis Tomasetti, I've got you here registered as on House Bill 3937 as a resource witness. Is that correct?
That's correct.
All right. Go ahead.
Good evening. My name is Louis Tomasetti. I'm the Director of Government Relations for the Office of Court Administration. I'm here on the bill as a resource. Happy to answer any questions.
I don't have any questions. Members, any questions? All right. That's a dedicated resource witness. Thank you. Thank you. Yeah. All right. Thank you both for being here. Does anyone else wish to testify on, for, or against House Bill 3937? Seeing none, thank you, guys. Seeing none, the chair recognizes Vice Chair Johnson to close on the bill.
Thank you very much. Appreciate you sticking around, and I close.
All right. Members, any questions for the bill's author? Seeing none, the chair will leave House Bill 3937 pending at this time. The chair now lays out House Bill 2559 and recognizes Representative Basut to explain the bill.
Thank you, Mr. Chairman, members. Under current law, a municipal court judge and the judge of a court of record, along with a retired municipal court judge and a retired judge of a court of record, can administer oaths. Justices of the peace can administer oaths, but retired justices of the peace cannot. This bill simply allows retired justices of the peace to administer oaths, to have them on the same parity as retired judges of courts of record and retired municipal court judges. Happy to answer any questions and reserve the right to close.
Yes, Representative Schofield.
Is there any age limit on when the retired JPs can
shoot?
Age is just a number. So no.
All right. Members, any other questions for Representative Basut? All right, seeing none. Does anyone want to testify on, for, or against House Bill 2559? Seeing none, the chair recognizes Representative Basut to close on the bill.
I close. Please send to local if it's unanimous.
Okay. Your request is noted. The chair will leave House Bill 2559 pending at this time. All right, Representative Flores, one of my favorite bills. Should we make her go down in front? Have you laid a bill out in committee yet? Okay, well then, yes, you got to come down here. And I like this bill a lot. Representative Basut, you need to be careful with whatever you're doing with that. Okay. Representative Flores, the chair lays out House Bill 3756 and recognizes Flores to explain the bill.
Good evening, Mr. Chairman, Vice Chairwoman, and members of the committee. Thank you for this opportunity to present my very first bill. I'm doing this also on behalf of a former colleague of ours.
Everybody get your cameras out.
Representative Celia Israel, and several others who came before her that have tried to bring this, have brought this bill to the attention of this body. And so, I'm hoping that I can get this across the finish line. And this bill, which I commonly refer to as our hot dog bill, but it's no laughing matter. This bill, 3756, would release civil liability for those that act in good faith to remove domesticated animals from locked cars that are heating up. It's been worked up by, as I said, quite a few of our members over the years, and some of the items that had raised concerns before have been addressed, such as clarification that it refers only to domesticated animals, and that you must first contact first responders before acting. And I bring this bill up because it's important, because given the temperatures that we've been experiencing in Texas, especially more recently, hundreds of animals suffer fully avoidable deaths. So when the temperature is 90 degrees outside, and we know it gets much hotter than that now, it takes only 10 minutes for a car to reach 109 degrees, even if it's not in full sunlight. And so, animals have a lower body temperature than we do, and so they don't have as many mechanisms on how to release the heat that's building up. So they much more quickly succumb to the dangers of heat. So it's the exact same bill that was passed out by this committee unanimously last session. So I hope we can do the same this time, and I'm happy to answer any questions. And I don't know if I don't have anybody testifying.
You have and you reserve your right to close.
I do reserve my right to close.
You've got a number of witnesses that have registered for the bill.
Yes.
Only one against, and no one has registered to testify. So, members, are there any questions for the bill's author? Okay.
I have treats.
Oh, okay.
Hey, no legislative bribery.
Dog bones.
So does anyone want to testify on, for, or against House Bill 3756? Seeing none, the chair recognizes Representative Flores to close on her bill.
Well, thank you again for the opportunity, and I look forward to your support on this bill, and I thank you, and I close.
Thank you, Representative Flores. We will plan to vote this out in our next meeting. Congratulations on your first bill. And with that, the chair will leave House Bill 3756 pending at this time. The chair lays out House Bill 888 and recognizes Representative Slauson to explain the bill.
Thank you, Chairman and members. I appreciate the opportunity to lay out.
Representative, is your microphone on?
The light's on.
Okay.
Hello? No.
Tap on it. There it is. Okay, go ahead.
I appreciate a live mic and the opportunity to, I don't know if it is live, Chairman. Seems like no. Yeah, okay.
Y'all can hear it out there? Okay.
All right.
All right. Go ahead.
Thank you. House Bill H-88 relating to the statute of limitations on certain healthcare liability claims involving gender modification drugs and procedures administered to or performed on minors. I appreciate that this is a particularly sensitive topic with passionate Texans on both sides of the issue, but all of us having what I believe to be an underlying and deeply held shared concern for how we best protect our children while they're minors and shepherd them safely into adulthood. We recognize as parents and lawmakers and healthcare providers that the development of our brains and bodies during adolescence is complex and a sometimes difficult, oftentimes even, process. Science and medicine tell us that the frontal lobes of children, areas responsible for executive function and things like impulse control, don't even finish developing until somewhere around maybe 25 years of age. Because of this, the law in several ways recognizes, respects, and protects the incapacity of a minor in voting ages, ages to purchase alcohol and tobacco, driving, ability to enter contracts, and even by extending the ages after majority when a minor can bring a claim in certain legal proceedings for harm suffered while they're still underage. Currently, under our healthcare liability claim statutes, some minors have an extra time period beyond the 2-year statute of limitation to bring claims. If they're under 12 when the cause of action accrues, they have until 14, and it's, I think, been this way since 2003. In the last 20 years, though, and particularly in the last several years, we're seeing increasing situations where children are being prescribed medications and having procedures performed to modify their gender while they're minors, only to later believe that they may have been harmed by lifelong consequences to their health, their sexual function, their fertility, their ability to have children by those drugs or procedures. And it's with all of this in mind that House Bill 888 will provide these minors an extension of the statute of limitation until they're 25 years old for a claim based in malpractice for providing a puberty-blocking drug or cross-sex hormone or performing surgery on a child when the purpose is gender transitioning or reassignment. I thank you for your time. I thank those in advance who have come here today to testify on this bill. I yield for questions and request a right to close.
Okay. Thank you, Representative Slauson. Vice Chair Johnson.
Thank you. I have quite a few questions. Normally, I'm all for expanding statutes of limitations. Typically not opposed to that in philosophy, except this seems very discriminatory and targeted to me. And I'm curious as to how many potential malpractice cases are you aware of that have not been allowed to proceed because of the current statute of limitations?
I don't have data on those that would have not been.
Yeah, because I would probably guess that there aren't any that have been dismissed or refused because the statute is what it is. And the other thing is, my question is, if we're going to address statutes of limitations and claims for minors and give them a broader stroke to address issues, why are we just limiting it to this? For example, let's just take Ritalin. Ritalin causes gynecomastia in boys. And it causes and there's with the rise of ADD, the rise of prescription of Ritalin, it causes young boys to develop breast tissue. And in fact, this actually happened to my son. And he had to have surgery on this issue because he took Ritalin when he was 8. But this didn't manifest until he was much older. So why would we not want to extend the statute of limitations for minors in that case?
Well, perhaps we would, Representative.
Okay. Then the next issue is, what about minors who, we have a case where a fertility doctor put his sperm in place of other cases and fathered like 300 children and way past statutes of limitations, and when it was discovered, why wouldn't we want to give them an opportunity to sue?
Are you speaking of the children who were born?
Yeah.
Or the patients who were born?
Yeah.
And what is the current statute of limitations?
Well, it's the current statute of limitations in medical malpractice that you outlined. I mean, why?
Or a child to bring a wrongful birth suit against a parent?
Well, yes, he used his own sperm as opposed to their natural father. Let's say if they were having fertility treatment. Let's say if you and your husband were having fertility treatment and they were supposed to use your husband's sperm, but they didn't. They used his own. And now he has like 300 children running around out there. And he's still licensed to practice, actually, which is unconscionable to me. But
what is the criminal statute of limitations in that instance?
I don't know criminal law. You know, I'm a civil lawyer. I don't know.
No, I understand.
But I'm just saying, there's all kinds of situations out there where we can argue the statute of limitations, and I just don't see. I mean, if you're concerned that you want to extend the statute of limitations for minors to the age of 25 across the board, I'm all for that. If you think that minors have unique situations of their development, we can sit here and come up with 8 million examples of how minors may take certain medications, whether they're gender affirming or not, where they can develop consequential damages or negative inferences down the road and would benefit from a 25-year statute of limitations. So I don't understand why we only care about the transgender kids and targeting them specifically. Why don't we open it up for anyone all minors to have their statute of limitations extended to 25? Is that something you'd be open to?
Well, I think I would consider it on a case-by-case basis as those bills are filed. I don't.
Well, we're talking about your bill and your statutes.
If you're speaking to an amendment, if what you're asking me is if I would amend this bill to include all children, no, I wouldn't be open to that.
Why?
Because this bill is very specifically crafted to address this particular situation where we see testimonies coming out from children who have reached adulthood who feel as though they suffered a harm when they were a minor. And it doesn't manifest, like you mentioned your son, until they were older. And they're without the ability to redress that within the current.
I understand that, but this is I'm not aware of any case out there where someone was prohibited from bringing a claim because of this. So this is a problem, a solution without a problem. And if we're concerned about children and medicines that provide them harm, where those harms may not manifest until down the road, it seems to me if we want to extend the statute of limitations to all children, but I don't understand why we have to discriminatorily just target a very small section of children and minors who could use access to the court system.
Well, I think that we have created a number of exceptions over the years when we have found instances where minors needed additional time to bring claims. We've done that for sexual assault of a child, aggravated sexual assault of a child, both in the CPRC and over in the Code of.
But we're talking about medical malpractice. You're talking about the healthcare liability statute. Whether or not you have criminal liability on other issues, that's not the issue. We're talking about medical malpractice cases for medicines, pharmaceutical treatments, other medical practices where kids have suffered a damage as a result of medical negligence, and the statute of limitations for that claim. And we're not aware of any case where this bill is trying to address a wrong that has happened, but there could be benefits to children in a lot of other circumstances that would benefit from a 25-year-old, to extend the statute of limitations to minors to age 25, especially with a lot of side effects from medicines, especially in the ADHD realm. There's a lot of side effects that come from that don't manifest until later. And this could be beneficial. I'm just gonna kind of leave it with that. The next question I have for you is, if you, how do you respond to the fact that multiple federal courts have found that this type of legislation is unconstitutional and that it unfairly targets or specifically targets the transgender community, and providing them enhanced statutory rights, and essentially would discriminate against children, based on sex in this case?
I'm not aware of a federal case directly on point to this statute, but would be happy to look at those if you would like to forward them to me.
I think I'll save some of my questions for other people that are going to testify. Thank you.
Thank you, Representative.
Members' questions. Representative Vasu.
You think it'd be a curious thing that providing someone who has gone through gender transitioning with a claim for malpractice, giving them that right, that would be unconstitutional? What due process right can you possibly think of that would be violated by giving someone the right to a claim?
I'm not familiar with it, but I would be happy to look at cases to that point.
Say that again, Representative.
I'm not familiar with what the constitutional complaint would be, but to her question, if she has cases on it, I'd be happy to review those.
Comments were made to the effect that you're targeting transgender youth, but your bill gives transgender youth a claim for malpractice. Isn't a claim for a malpractice something that's been done to them that they believe violated the standard of care, and providing them a redress for that? Isn't that a benefit?
Correct.
Okay, I thought I was hearing something different.
Members, other questions? Okay, and Representative, you reserve your right to close.
Yes.
Correct, okay. All right, we're going to open public testimony. The chair calls Michelle Evans. I think Michelle had to leave. Jonathan Covey. Anna Wynn. Ever Hayward. Is Mary Castle here? Mary Castle?
She's on her way.
Okay. Okay, Jonathan Covey. Michelle Evans, I know, is gone. Anna Wynn, Eva Hayward, and Callie Butcher. Do we still have the overflow room, or is it closed?
It should be so.
Okay. I'm going to say names one more time just to give everyone time to possibly get over here from wherever they are in the building. Anna Wynn, Eva Hayward, and Callie Butcher. Jonathan, I've got you registered on behalf of Texas Values for House Bill 888. Is that correct?
Yes, sir, Mr. Chairman.
Okay, you can start.
Thank you, Mr. Chairman, members. My name is Jonathan Covey, Policy Director for Texas Values, testifying for the bill. This bill grants minor victims a right to sue healthcare providers who perform these procedures on them or provide them treatments for civil damages up until the victim's 25th birthday. I think the statute of limitations up until 25th birthday is appropriate. They talk about there's a honeymoon period in gender transitions. It's said to be somewhere between 2 and 4 years, and this gives several more years after that for victims reach the age of majority to come to terms with what was done to them and to bring a cause of action if they desire. We appreciate this approach because it seems to really work towards providing real help and restitution to the victims, and I'd ask you to support this bill.
Members, questions for Mr. Covey? Okay, thank you, Jonathan.
Thank you, Mr. Chairman.
Ash Hall, Stephanie Perdue, Sophia De Loreto Chudy, okay. Ash, is that correct? I've got you registered on behalf of the ACLU of Texas and yourself against House Bill 888. Is that correct?
That is correct.
Okay, go ahead.
Right. My name is Ash Hall. Here on behalf of myself, ACLU of Texas, against the bill. I'm sort of amused that we're talking about this as if it's going to be helpful to people who are receiving care around gender transition and gender dysphoria, because as far as any of us who have analyzed this bill, the only real purpose of it is to scare doctors into refusing to treat us. That's really the only possible reason that you would go ahead and say that it's okay to extend this particular
Go ahead. That doesn't
limitation, the statute of limitation for this, and literally nothing else. There's no other reason that would possibly exist to do that. I agree with the idea of actually extending that statute of limitations for everything. I think that makes a lot more sense. I think youth who receive any sort of treatment that ends up going wrong would deserve the right to pursue that later on if they so choose to. But only doing it for the transgender community is not meant to help us. Nobody is actually fooled by that. It is meant to keep doctors from treating us. And so the ACLU vehemently opposes this. We've noticed that there is, of course, no other sort of treatment out there for which there is this extension. It is literally only this. It flies in the face of Texas malpractice law. And so with that, I close on this. This is ridiculous.
Okay, Chairman Moody.
Thank you. I want to follow up on that. There's a number of, I know I've seen you multiple times in the hall this session. I think that's probably because there's a number of things that you're interested in engaging on. I know that obviously we're here on this bill right now, so I kind of want you to limit your comments to the bill that we have in front of us. But what the fact that this discussion is happening, talk to me about negative health outcomes. So the way that you posit the purpose of the bill is to essentially chill any doctor's maybe inclination to help folks that may be transitioning.
Correct.
So that if that's the goal of it and that's the conversation that surrounds it, what are the negative health outcomes for transgender Texans opening this thing, having this conversation, and being here and kind of raising your community into a limelight like this in this way?
Right. So this bill is part of a broader strategy that's designed to target transgender people across the United States. And part of that strategy includes trying to make it as hard as possible for allies to support the community. And so this bill falls into that category. It's meant to target allies who would help us. Speaking on Texas specifically, the Trevor Project did a survey of LGBTQ Texas youth after the last session and found that 86% of them reported that recent politics had negatively impacted their well-being. So I think it's safe to assume that even just having this conversation, of course, would add to that. It is also worth noting in that same survey that 47% of the youth surveyed had seriously considered suicide in the past year, and 16% actually made an attempt.
Is that information that you've provided to us, the Trevor Project data?
I have provided it in other hearings. I did not get a chance to print for today, but I can provide that to this committee shortly.
I think those are numbers to always take into account. We're talking obviously about lives of folks. The other point I wanted to talk about, because I'm looking, and you had mentioned in your testimony gender dysphoria. So I see terms gender transitioning or gender reassignment. I don't see anything regarding a diagnosis of gender dysphoria or severe gender dysphoria. What would be the reason for not including the diagnosis in a bill like this?
I think the idea here is to trivialize the care that we have been receiving. Because gender dysphoria is something that actually shows up in the DSM. This is like an actual medical diagnosis. It is something that we are meant to take very seriously and something that has been treated and approved of by every major medical association. And so when you refuse to call it that and you make it sound like some sort of elective kind of treatment that people are seeking, it makes it easier for folks to justify trying to take that care away or trying to convince doctors to not provide that care, when we know gender dysphoria is quite serious and that receiving care for that lowers the risk of negative mental health outcomes that come on the basis of discrimination.
Thank you very much. I appreciate your time.
Thank you, Chairman Moody. Members' questions? Representative Sloss.
Yes, I have a question. Thank you for coming to testify today. So when you mention that you think that this trivializes the care that folks have been receiving, are you familiar with any stories of people who have reached their early 20s and maybe feel like there are side effects or things that they didn't anticipate that they're dissatisfied with as a result of any of the cross-sex hormones or puberty blockers?
In terms of folks who are actual members of my community, most of the doctors, any of the stories that I've heard, in fact, like doctors have been very clear about what expected side effects are, what the risks may be. And what I think actually stands out a lot is that we choose to go through this with this anyway, despite what the possible risks are, despite the side effects, because it is literally worth it to be your full embodied self and live with those risks rather than keep being somebody that you are not and keep suffering with gender dysphoria.
My question, though, is are you familiar with any who are dissatisfied with the way that's being lived out, whatever the risks were, that they are experiencing some negative side effect to that?
I don't personally know anybody. I am aware of the detransitioners that will sometimes come to testify. And my thoughts there are that that's unfortunate. I don't agree with these studies that have been manufactured that make it sound like the rate of regret is super high. It's actually quite low, which is fabulous. I think, if I'm not mistaken, the rate of regret for getting a knee surgery is higher than getting treatment for gender dysphoria. But what I would argue is that everybody deserves access to health care, whether you are having regret about gender dysphoria and the treatment for it or not.
Do you agree then that even if that rate is low, that this bill doesn't trivialize that, but actually gives those citizens an opportunity to have a redress for their situation?
Then why not call it gender dysphoria in your bill?
Because we are focused on the process and the procedure there.
Process and procedure for what?
For the administration, and with respect, this isn't questions back and forth, but for the administration of the medications and the performance of the procedure.
Which are used?
Without regard to the diagnosis.
You have to have a diagnosis for gender dysphoria to receive the treatments. So I think we are starting to perhaps talk in circles around each other. But I assure you, you can ask any accredited doctor in Texas and they'll be able to tell you more about that.
Thank you.
Representative Vasut.
You mentioned about that the doctors that you're aware of, correct me if I'm wrong, because I'm trying to remember what you said, that doctors that you're aware of, I think you said, go over in detail the potential side effects. Is that a fair summary? Did I get that right?
Correct.
Okay. So, you know, a malpractice claim is premised on the notion that a doctor deviated from the standard of care. And let me give you a hypothetical. Let's say that there are side effects, and let's say your typical doctor lays out those side effects, like you mentioned. But maybe this other doctor does not. And a member of, somebody that goes through this procedure, they don't appreciate those side effects for them until they're 18, 19, 20, 21, 22 years old. Shouldn't we give them the right to a claim because they were not provided with the information about side effects like others that you say good doctors do?
They already have the right to a claim. This bill just expands it, and solely for this. And I am telling you, I believe the only reason we would do that for this particular type of treatment and nothing else is to discourage doctors from helping at all, including the good doctors who are happy to inform patients of the risks and help them get the treatment that they need.
Respectfully, under the current law, if you're 16 and you are in that position where a doctor tells you about the side effects and this particular doctor doesn't, they deviate from the standard of care, unless you bring that claim within 2 years, you don't have a claim. If 3 years, 4 years, 5 years goes by, this bill is removing the general.
That's not the statute.
That's not true, sir. I'm no med mal
Then I will
attorney.
I will allow somebody to clarify that for me, because the way I understand this bill is that it's providing a right to a claim up to the 25th birthday for somebody that has this procedure prior to their 18. Are you saying that as it exists right now, it's your understanding that if somebody was 16, had a procedure done, that they could sue all the way up till 25 if they didn't learn about the claim until later?
It wouldn't be up till 25, but the point is, this is a standard statute of limitations across healthcare. Singling us out is the problem. If you want to extend the statute of limitations for something like this, you need to do it for all types of treatment, for all types of procedures, illnesses, whatever you want to call it.
But if those individual bills were brought up to extend the statute of limitations in those instances, they could and would get a fair hearing in front of this committee, just like any other bill. This isn't the only statute of limitations bill we will hear this session.
But there's a reason this particular bill is showing up now.
Well, look, you can question the motives of the author of the committee all you want, but if any member of this committee had filed a bill relating to extending statute of limitations for Ritalin or a knee surgery or any other procedure, they are fully able, have the right to do so, and I'm quite certain that if they requested a hearing, this committee would give them a hearing. The absence of extending statute of limitations in other instances should not compel us to oppose this extension of the statute of limitations by itself.
I don't think it makes sense to ignore the current political climate that we're in while we're talking about this, sir.
Well, this to me, I'm speaking for me, is not a political issue. This is a policy issue about protecting children. And no part of this here, I will not allow this hearing to be political.
I think it's too late, sir.
I don't think so. I think the members are asking you questions about policy.
By even having a hearing on this bill, it has become a political hearing, sir.
But this is a policy that the author believes and that other members of this committee believe, including me, protect children and give them a right, as Representative Vasut said earlier, until they're 25 to sue for malpractice. But if any legislative, Vice Chair Johnson, like I said, or anyone else had brought another bill relating to another procedure, we would hear it.
And yet, if I actually thought this bill was operating in good faith, I suspect I would have heard from any of you.
With all due respect, and we've testified in front of our committee before, and I respect you and every other witness who's here, but I will not let you impugn the motives of the author of this bill or any other member of this committee, period. I wouldn't allow that on this bill or any other bill. Let's talk about the policy itself. Let's not talk about the politics or the motives that you may believe exist. Let's talk about the policy. Representative Vasut, do you have follow-up questions?
I do not. Thank you, Mr.
Okay. Members, other questions? Chairman Moody.
And I don't want to speak for Ash. I think Ash does a good job of that. But I think the policy implication that was laid out very clearly, without getting into motivations or courage, is that the net effect of having this in policy is to limit access to health care for these Texans. That is the net effect. Motivation or not motivation. I mean, that's one thing. We can always divorce out what I think. We have this debate all the time on the floor. I don't know what's in your heart and your mind when you file something. I can never know that. But I can know what I think the bill will do in practice.
Right.
And I think what I hear is the bill in practice, while there may be a subset of folks that could avail themselves of a longer statute of limitations, the broader impact would be chilling, essentially, the any inclination a physician in our state would have to offer this care to Texans who need it, who have a diagnosis. So if we want to distill down, I think that's really what the core of it is. Right. And Chairman, to your point, we can set aside, it's hard sometimes in our world to try to set those things aside. But I think the concern you're raising is that this in law would cause that impact in the real world to real people. And maybe, let's put it like that. Maybe there are some folks that are going to avail themselves of that. And then you're weighing against what is the greater good? Is the greater good to give that extended statute of limitations to a small subset of folks that are I guess, have regret about the treatment they received? Or is it the vast majority that don't have regret about that treatment who are going to probably not have the access to that treatment because physicians are going to be afraid to get into this arena? And that's the decision we have before us. And let's weigh that. I know where I come down on it, and I appreciate you being here and helping us kind of zero in on that.
Members, other questions for this witness? Okay. Thank you, Ash. Sincerely, thank you for being here and for your testimony. The chair calls Stephanie Perdue. Stephanie, I have you here registered on behalf of Central Texas Pride Community Center, LGBT Rex, and yourself testifying against House Bill 888. Is that correct?
That is correct.
Okay, go ahead.
Thank you, Chairman Leach and Vice Chairman Johnson. It's a pleasure to be here before you again. And Representative Slauson, I'm actually your constituent. I've been in your office multiple times this session already. I've been in most of your office this session. You may have seen me walking the halls as a giant dinosaur to draw this attention. So I'm a little bit crazy sometimes. I do apologize for that. I'm in opposition to this bill because, as Ash said, it is very clear to me that the result would be to limit care for transgender people. If a doctor's worried they're going to get sued because I'm going in there as a younger person getting care, then they're not going to want to take care of me. The longer you delay treatment for these people, the harder our lives get. I transitioned at 21 years old. I have never looked back. I have never been happier with my life. And I feel sorry for those who do have regret. I hope that they take the time to take responsibility for what they've chosen to do themselves. I think it's important. I am by no means a lawyer, but my plain reading of this bill also seems to exclude those who are intersex, who do have treatment given to them against their will. And if we're going to address people that have that have issues, those are the people we need to look after. That's just my opinion. That's all I have.
Okay, members, any questions for Stephanie? All right, thank you. Thanks to both of you for your testimony. The chair calls Brian Jackson, Alma Salcido, Connie Lingus, hold on. Okay. Yeah. Okay. That's going to be on YouTube. Is Alma Salcido here? Okay.
It'll be a highlight.
Brian, hold on. I need to stand at ease just for a sec. I have you registered on behalf of the Texas Alliance for Patient Access on the bill. Is that correct?
Correct, Mr. Chairman.
Okay, you're recognized to start your testimony.
My name is Brian Jackson. I am testifying on House Bill 888. I have been a medical malpractice attorney for 33 years. I also serve as general counsel for the Texas Alliance for Patient Access, also known as TAPA, a consortium of doctors, hospitals, medical clinics, nursing homes, and other groups working in healthcare. In 2003, our state faced a medical liability crisis. The legislature worked to strike a balance between a patient's right to file a lawsuit and the need for doctors and hospitals to have certainty with liability exposure. In response, the legislature made some hard choices and enacted tort reform as set out in Chapter 74 of the Civil Practice and Remedies Code. Those hard choices worked. The crisis subsided. The number of doctors in Texas has grown significantly. Access to care has increased due to tort reform. Our group is always concerned when any bill whittles away at those reforms. The statute of repose is important to physicians because it helps make tail insurance policies more affordable. If a physician moves to another community or moves to a different medical practice, they have to buy tail insurance to cover previous patient encounters. It was prohibitively expensive in 2003. Because of the statute of repose, in part, it is much more affordable now. Revising and lengthening the statute of repose could make tail insurance more expensive. We recognize that HB 888 is limited to a unique set of circumstances and will impact very few future cases. However, we are still concerned that this might be a first step in watering down an important facet of existing tort reform protections. That is why we are testifying on this bill, to make the committee aware of our concern that HB 888 could be a first step in lessening the successful tort reforms that have served our state well. Thank you.
All right. Brian, thank you for your testimony. Members, any questions? Yes. Representative Flores?
We were trying to read the statute, and I'm sorry if I missed this, if you may have said it, but I find it interesting that this seems to be going in the opposite direction of, medical malpractice cases, because normally it's to cap damages and it's to shorten, not shorten timeframes, but keep the timeframes that you can bring a lawsuit, to the 2 years or the 10-year statute of repose. And I'm not sure I understand all that completely, but so this goes contrary to all of that, doesn't it? Because it's extending the amount of time that you would be a target for a lawsuit, and would this seems to be going contrary to the will of this legislative body for the last, I don't know how many, 20, 30 years now?
Well, Representative Flores, the caps that are in place have been there since 2003. So they've been there for 20 years and have not changed. The statute of limitations has been there for 20 years. The statute of repose has been there for 20 years. So I don't get a sense that the legislature has made that more conservative or more detrimental to plaintiffs or anything of that nature, but there has not been a change either adding or subtracting to caps or adding or subtracting to limitations. So I think we've just had the status quo for 20 years.
So this bill would be inconsistent with that, maintaining that status quo over the last 20 years, would it not?
This bill would expand the statute of repose for an amount of time, and we have not had an expansion of that statute by the legislature since 2003. But I do think, with all transparency, in my humble opinion, as an attorney that does this, the Texas Supreme Court has ruled that the statute of limitations for medical malpractice cases does not expire till someone is 20 years old. And so the statute read 12 and 14, and the court said that violated the open courts provision, and they said no, a minor has the ability to file a lawsuit 2 years after they become an adult. So right now you can file a case until you're 20. However, the statute of repose has remained at 10 years. And the Supreme Court has not definitively said whether that 10-year statute of repose could impact a minor or not. There's only one case out there on it, and it involved parents that weren't diligent in following up, and so it doesn't set an overall precedent as to how that would work. But the statute of limitations, in my humble opinion, as it stands now, if someone filed a case for a minor would be that the minor has until they're 20 years old to file the case. They could actually have 75 days beyond the expiration of their 20th birthday if they filed a notice of claim with an appropriate medical authorization. Before they were 20, they could get an extra 75 days to do that.
So, but for all medical procedures, et cetera, you know, it's the same statute and statute of repose. And so
Correct.
Singling out a particular treatment, is that unusual?
Well, I think that sometimes you do have various standards because of what we call the discovery rule in Texas. So, you know, you may have a different statute of limitations for a sponge case, because if you leave a sponge in someone, but you don't know it's there, you get 2 years until after you discover that sponge, versus if you knew about a bad knee surgery or something when it happened, you get 2 years from the surgery. So there are some different ways the limitations work based on the different procedures and the different injuries and the damages and that type of thing. But at the same time, this is unusual to have a statute of limitations for particular treatments be different than the general statute of limitations set out in Chapter 74.
Thank you.
Representative Assouf.
I appreciate you laying that out. It's helping me to navigate these two provisions here.
And that's my opinion on what that was.
Well, now,
I'm
but
not a judge.
I hear you. But in your opinion, based off of what you know, so if the minor is 14, and then as you understand it, it's 2 years beyond 18, so they could go up to 20.
Correct.
But the repose would cut them off at 24. Is that right?
Correct.
So under the bill that stands before us for the class of activities covered, they would get an extra year because it would now go to 25.
Well, they could actually get an extra 5 years because limitations is still going to run at 20. So this bill was going to give them to 25. So, you know, if the statute of limitations expires, the repose doesn't matter.
Right.
So,
okay,
So you're actually giving 5 more years.
Okay.
In the scenario you spelled out, my humble opinion is you're giving 5 more years.
Okay. I thank you for that. And I understand that's your opinion, but I do appreciate it. Thank you.
Members, any other questions? Okay. Thank you, Brian.
Thank you, Mr. Chair.
Sophia De Loreto Chudy. Hi, Sophia. Good evening. I have you here testifying on behalf of yourself against House Bill 888.
Yes, that is correct. Thank you.
Okay, thank you.
I actually, I'm sorry, don't have a prepared testimony because I came here today for a very different reason, but I learned about this bill just about an hour ago. And to me, it was something that I had to speak on because as a just normal, plain citizen, I am not transgender myself. I don't have any transgender family members. Reading this bill in plain language, not as a legal expert, not as a medical expert, it is so very clear to me that this will have a chilling effect on medical care provided to specifically transgender individuals at a time right now when it is dangerous to limit access to medically necessary health care for young transgender individuals. And it's just really disheartening to see that this committee is spending time on an issue that very specifically only affects transgender individuals when they represent such a small portion of our population, when we have really big issues in this state. I'm a third grade teacher, and our schools lack adequate funding right now. We are suffering from so many different things in this state, and to be focusing on something that would very specifically harm transgender kids when they represent such a small portion of our population, as a Texan, it just really hurts my heart to see. And so I just came here to say that.
Okay, Sophia, Vice Chair Johnson.
Agreed. Well said. Thank you for coming.
Thank you, Representative. Appreciate your time.
All right, thank you. Is there a Connie Lingus here? What about Anita Dickenming? Or Holden Middick? Okay. Are any three of those people here? All right. You got your moment. I hope you enjoy it. Does anyone else wish to testify on, for, or against House Bill 888?
I have registered, but I changed my mind in testifying.
You're not Connie Lingus?
I am not.
Okay,
Or any of the other names you mentioned.
that's fine. Come on up. Thank you. What is your name?
Andrea Segovia. Segovia.
Segovia.
S-E-G. I registered maybe like.
Yeah, there she is right at
Okay,
the bottom.
I was like right before the bill.
All right, Andrea, thank you. Sorry about that. I've got you registered on behalf of yourself against House Bill 888. Is that correct?
Correct.
Okay, thanks for your patience today. You can start your testimony.
One, thanks for the laugh. I don't think I've laughed all week. And two, I just want to reiterate what's been said, right? This wouldn't help trans kids or people. It would strip away care. And I'm saying this as somebody who has also talked to doctors who have been providing care, who are concerned about what their statutes of limitations, like we're saying, right, would look like, what their medical license would look like, as they've spent so much time in educating themselves in what care looks like. And I think also as somebody who had 35 facial reconstructive surgeries in my lifetime before the age of 18, I understand what we're trying to avoid here, right? I had many doctors mess up the procedure and say, whoops, we can try again if we want. And that's not what's occurring here. And I just want to be very clear about that, that I've received so many calls of parents and families who are concerned that they're not going to be able to find a doctor for their kid because their doctors are worried about what the future holds for them as they're just trying to do their job. It's clear that this bill was written with harm and not help because also, too, no one's really reached out to say, hey, how does this affect trans people before it was written? And again, right, I hope that the statute can get expanded for all, and one day, hopefully, that we'll see that in this committee, as the chair has mentioned. But again, that I just want to reiterate, credible health organizations support the care that is happening. I cannot reiterate that enough, that we have to let doctors be doctors and do their job and hold them accountable. I'm not saying to not hold them accountable, but this is clear discrimination against trans youth. Thank you.
Okay, Andrea, thank you. Vice Chair Johnson.
Andrea, I just want to take a moment to thank you and Emmett and everything that you guys do. You are the leading voices in the fight for transgender equality and LGBTQ plus equality. And as a member of your community, I just want to thank you for always shining the light on the pain that we cause in this building. And I am sorry that we're having to go through this week. I feel it with you, and I just want to thank you for being here.
Thank you. I appreciate it, and I've never gotten emotional in front of any committee, and I've been doing this work since 2017, but I really want y'all to understand how harmful the 140 plus bills against anti-LGBTQ people is happening in this state, and these kids and these people deserve so much more than what's occurring. People's lives are on the line, and I just need y'all to understand that, please. I've never pleaded before. I do policy work. And it's so important that you understand the power that you'll have over the control of kids' lives. And I'm happy to have that conversation, not emotional, in my professional self. But I just want to have the conversation and have open ears to what's occurring, what's really occurring. Thank you.
Representative Slauson, before you leave, Andrea, Representative Slauson.
Thank you so much for coming today. I just wanted to clarify real quick if you were testifying for yourself or if you were testifying for a group, because I heard Representative Johnson reference a group.
I'm testifying as myself, but I'm also the senior field and policy advisor at the Transgender Education Network of Texas.
Just,
I didn't imply she was testifying.
okay, yeah, so it's just so the record is clear.
It's just myself.
Okay.
Correct.
Thank you.
Andrea, you're welcome here in front of our committee whenever you want. We're glad you've blessed us with your testimony, and though we might disagree on some issues, I promise that, at least for our committee, and I know the bill author very well, that there's no part of this bill that is born out of any hate at all. We can disagree on policy and do so in a respectful way, and you've proven that tonight. Thank you so much.
Thank you.
Okay. Does anyone else wish to testify on for? Come on up. Did you register? Okay. You're going to have to go out to one of the kiosks?
It wouldn't let me. It said it was closed.
Okay. It's open back up. We'll wait for you. Take your time. If anyone else wishes to testify on, for, or against House Bill 888, please make your way to the kiosk now. Is it Soren?
Yeah.
Soren Aldaco. Sorry, I'm going to
It's
be
okay.
real careful on names going forward. Soren Aldaco, you're testifying on behalf of yourself. You're for House Bill 888.
Yes.
Okay. Go ahead. Start your
So I actually testified on 1686 yesterday, and so I'm going to read you what I wrote for that because I think you guys need to hear it too. Hi. My name is Soren Aldaco, and I'll be testifying for HB 888 as someone who experiences gender dysphoria and who's found peace outside of medicalization. I believe that children deserve better than plastic surgery and hormones, but this legislature needs to prove to families that there is a path forward through expanded access and funding for mindfulness-based therapy programs. As contradictory as it sounds, I'm both trans and detransitioned. I began social transition at age 11, started testosterone and estrogen blockers at age 17, and by age 19, I had undergone a double mastectomy. Massive complications did not elude me, however, and I was gaslit, then ghosted by my medical providers after demonstrating weeks of concern. Emotionally vulnerable and with zero pain meds, I spent 8 hours in an ER bed alone before they cut my scars back open, sewed drains in, and aggressively expressed over 3 cups of blood from my raw chest cavity. This got me thinking, why do we uphold material solutions as the end-all be-all treatment for distress that's mostly mental? What could I do to conquer this beast while accepting that my greatest fear, my female body, was just as much a part of me? Less than 6 months later, I stopped hormone replacement therapy and began what I like to call a process of reclamation. Material solutions pushed me deeper into my ego, so I became determined to integrate with the world around me. I questioned my conceptualization of manhood and womanhood in the context of sexism and pain, and I learned how we develop our sense of identity through comparison to other people. So in thinking of my 10-year-old sister and what kind of other I wanted to be for her, I realized that I needed to find an alternative way of addressing my gender dysphoria, one which didn't posit my body as wrong or my negative feelings as triumphant. I achieved part of this through self-compassion, which, according to research done by Kristen Neff, involves 3 key components. Mindfulness, or the practice of accepting negative thoughts and emotions like gender dysphoria for what they are. Common humanity, or the practice of recognizing that all humans are imperfect and prone to pain. And self-kindness, or the practice of extending grace to oneself always, especially when it's hard. Our handling of gender dysphoria is not an exception to this nation's mental health crisis. In fact, the gender-affirming care I experienced in adolescence was an elaborate placebo, and placebos work, but it allowed me to identify outside of a lifetime of neurodivergence, trauma, and gender nonconformity. I was no longer a loud, butch, autistic, weird girl. I was a cool, happy-go-lucky lad. Kids need affirmation, that much is true, but how we affirm them matters, and if this bill is to move forward, we have to ensure that there are mechanisms in place to support self-expression, resilience, and healing. Not everyone who transitions experiences gender dysphoria, and not everyone who experiences gender dysphoria transitions. Just know that right now, best practice, is code for only practice, and accountability for a medical system that prioritizes ease and conformity over health. It's the first step towards developing care that actually systematically works. And by the way, I'm from Texas, born in Texas, and this is happening in Texas. I also couldn't sue because my statute of limitations ran out.
Soren, thank you. Thank you for your testimony. Members, any questions? Representative Slauson.
I just want to tell you thank you for coming in and testifying again. I know you were already here this week on a very long day.
16 hours.
And I appreciate you coming and sharing with me.
Yeah, no problem. I heard about this like while I was sitting at home trying to make dinner, and I was like, this is a little bit more applicable because those providers, that provider that treated me and did my my double mastectomy, he came to Texas because of the laws here. He had 8 malpractice suits, and don't quote me on that, but like an absurd amount in California, and he knew that here he could get away with it, and he has.
Thank you.
Soren, I would like to, your testimony was wonderful, just like all the witnesses who were here to share their thoughts. We welcome that, but yours especially was impactful, and I'm sad and sorry that some of the other members weren't here to hear it. And so if you wouldn't mind, maybe at some point this week, writing some written testimony for us to submit, I will personally hand deliver it to the committee members who, for whatever reason, decided not to be here to hear your testimony, because I think that they need to hear it. Because according to right before your testimony, their position was that this never happens in Texas. It's never happened in Texas.
It happened in Austin. I'm from Fort Worth.
And your testimony proves that. And your testimony is exactly why we need this bill, period. Members, any other questions? Thank you for being here. Does anyone else wish to testify on, for, or against House Bill 888? Seeing none, the chair recognizes Representative Slauson to close on her bill.
Thank you, Mr. Chairman and members. I appreciate your time, and I close.
Thank you, Representative Slauson. Members, any questions? All right. With that, the chair will leave House Bill 888 pending at this time. Our final bill of the day, House Bill 1952, is laid before the committee, and the chair recognizes Representative Toth to explain the bill.
Thank you, Chairman, members. The current rule at the Department of State Health Services requires birth certificates to include sex if known. House Bill 1952 would require birth certificates to list the biological sex of a newborn. I'm working with doctors and stakeholders to prepare a committee substitute that will take into account children that may be born intersex. And in those situations, the sex would not have to be listed until a later time. Another change I'm planning to make will clarify that sex listed on the birth certificate of a minor cannot be amended unless the changes to correct clerical error or to complete the birth certificate if the sex was not listed or if the child is intersex and the sex is later determined. I'm happy to answer any questions if there are any.
Thank you, Representative Toth. Vice Chair Johnson.
Does your bill prohibit an adult who has fully transitioned from getting their birth certificate modified?
The only thing that can't be modified is the biological sex.
But if
It would.
why would you not?
So if you're already, let me just answer you. So if you already have a birth certificate, it's not going to require your biological sex at birth. You already have a birth certificate. If you're born today, though, it will list your biological sex.
I understand that. My question is, if you are an adult and you have fully transitioned, and does your bill prohibit them from going back and getting a modification of the birth certificate?
If the biological sex is listed, they can't change that.
What is the purpose of prohibiting an adult who is
It's to maintain the integrity of our state records. It's also to maintain accuracy of state records. And it's also to maintain integrity of who you are in the event that, if at some point in time a person commits a crime, are they allowed to change their identity so that no one knows who they are?
I would say that it's not the same thing. So because when you transition, it's important to be able to have your legal documents reflect who you are. And if you've changed and transitioned into your gender, you have to present a driver's license.
Right.
You want that to affect how you are. And a birth certificate is an important document for identification purposes.
Right, and so this would, moving forward, for children born moving forward, their biological sex would be checked in the box in a separate designation.
So why are you opposed to adults being able to have, go back and amend their birth certificate once they have fully transitioned?
This bill is looking forward. I'm not against it.
No, but in the future, child is born tomorrow, 25 years from now, they transition.
And their biological sex would be on the birth certificate along with...
I know, but can I finish my question?
I'm sorry, I apologize.
If they fully transitioned, then they would like to be able to modify the birth certificate to reflect their current gender identity. Why are you opposed to that?
Because it would still list the biological sex.
That's not my question. My question is, why are you opposed to them getting a modification of their birth certificate?
Because it's not accurate with state records. It doesn't reflect that a man is a man and a woman is a woman.
Well, it does if they fully transition, and they have transitioned from one gender to the other. Then we want the record to reflect who they in fact are, so that it is accurate.
I love you. I respect you. I just disagree with you.
That's obvious. Okay, I'll let testimony happen.
Representative Flores.
Sorry. Well, I understand wanting to maintain the integrity of the records. However, to Representative Johnson's point, if somebody has fully transitioned as an adult and they are now, presenting as female as opposed to male at birth, and say law enforcement or somebody needs to identify, somebody, and their records should reflect their current sex, should they not?
It would on their driver's license as well as the birth certificate, but it would, again, recognize the biological sex at birth.
But that's not who is presenting, and so that would cause more confusion, in my opinion, would it not?
Not really.
Members, other questions? Okay, let's open public testimony. Chair calls Jonathan Covey, Texas Values, Michelle Evans. I think Michelle's gone home. Carrie Moore. D.B. Bannock and Callie Butcher. Is there anyone over in the overflow room still? Sergeant, can you just check over there and see if there is? I'm gonna wait to start the testimony on a panel until we fill the panel. So DB Bannock, Callie Butcher, Sophia, I still see you here. Sophia De Loreto Chudy. I'm not reading that one. Ash Hall. Ash.
Right there.
Ever Hayward. Eva Hayward. Or Ever Hayward. Carter Hogan. Carter Hogan. I'm not reading that one either. Samuel M. No one's over there? Okay. Samuel M. Not reading that one. Anna Wynn. Anna Wynn. Alice Nutt. Okay. Jonathan, let's start with you. I've got you registered on behalf of Texas Values, registered for House Bill 1952. Is that correct?
Yes, sir.
All right, go ahead.
Do I need to restate my name, or is that?
No, it's fine. Go ahead.
Mr. Chairman, committee members, we didn't have anything to do with the approach this bill takes, but we agree with it at least conceptually because it's vitally important to know a person's sex at birth and also to have a process in place for the occasion when a modification needs to be made because of some clerical error. The current process to change the sex listed on a birth certificate in Texas requires a court order. Texas statute actually doesn't specify what is required to be submitted to a judge. It's up to individual judges to decide what documents are required. It's also particularly important in light of fairness in women's sports competitions where girls and women compete for unique opportunities and scholarships, and where fairness is not being upheld, and where 96% of female CEOs say they wouldn't be where they were today without the boldness that they got from sports. The interesting thing about this bill, and I know he has a committee sub, but scientifically, the presence or the absence of a Y chromosome is the determining factor in whether you're male or female. So there are different studies out there, some talking about like Klinefelter's syndrome and Turner's syndrome. Klinefelter being XXY being an additional X chromosome, and Turner syndrome being missing an X chromosome, but the Y chromosome actually still holds up. So anyway, we'd ask you to please support this bill.
Okay, thank you, Jonathan. Members, any questions for the witness? Okay, Jonathan, I might have missed it, but I do want to ask you a question just to clarify. Do you
Yes, sir.
Do you have a position on whether someone should be able to come back if they fully transitioned and amend their birth certificate?
Yes, sir. We don't believe that someone should be able to come back and amend.
Should there be any sort of notification on a birth? Because if someone has fully is fully transitioned and you need your birth certificate to get other identification documents. In many instances, you have to have that document. What a pain it is to have to go get a birth certificate. Is there any instance in which someone should be able, according to your position, I'm not putting you on the spot, I'm just asking for my edification. Is there any instance in which someone should be able to go back and have that notification maybe added to their birth certificate?
If they, like a notation that they had transitioned?
Yes.
I don't think so, because I think that we're acknowledging the realities that a man is a man and a woman is a woman.
Yeah, and I agree, and I think the intent of the bill, I'm open to the testimony here, but the intent of the bill, the intent of a birth certificate is a snapshot in time of this certifies when you were born, the date, where you were born. I think your parents' names might be on there, where specifically the hospital you were born, and your biological sex. That is a snapshot in time. That's correct?
Yes, sir.
So
it's usually when you're, the time when you're born.
So if someone has fully transitioned, what does it say on their death certificate?
Yeah,
is gender I honestly, I don't know. I don't know the answer.
I really don't either, Mr. Chairman. I don't know what it says on death certificate.
May I?
Yes.
But I thought that the representative stated that currently it doesn't have it, and so this would be going forward to include it. So if it's not included it for all these, it does?
It does. I'm under the understanding that some counties add it and some counties don't.
Okay, because he just pulled one up and it has it, but I had heard Representative Toth say that we were doing this moving forward and doing it and requiring it. Maybe it's not required.
Or maybe right now it's just, it's county policy. Maybe they all include it, but
Maybe
it's not
it's-
required in statute.
Exactly, not
We need
required.
Representative Toth, we need to find the answer to that question.
So,
Jonathan, I'm not putting you on the spot.
You're fine. I think it is required in statute, but we can look that up for you.
But, so to the chairman's point, if somebody needs to get identification, this is and they now are presenting as a female as opposed to being born male, you're denying them their ability to get identification. And that's just, to me, that seems very, very unfair. They're not going to be able to function. And I just think don't you think that's just patently unfair? I mean, why can't there be an amendment to that certificate if an adult has fully transitioned and is now presenting as a female instead of a male at birth?
I mean, we just fundamentally disagree that it's denying them, identification. I mean, it's denying them a identification based on what they would consider to be gender identity, but we don't agree with the concept of gender identity.
We're talking about, and I do want to move on to the other witness testimony. At least my question was predicated on someone who has fully transitioned, and so I don't know if there needs to be some sort of amendment if there's some other document that can be filed that can be issued by a county clerk or by an official government entity that can identify someone who's fully transitioned as their gender. I don't know the answer. I'm asking questions out loud. Do you have anything? Okay. Thank you, Jonathan, for your testimony. The chair calls Ash Hall. Ash, I have you testifying on behalf of the ACLU of Texas and yourself, testifying against House Bill 888. I'm sorry, against House Bill 1952. Is that correct? All right, go ahead.
Right. We oppose this bill. For one thing, not having accurate birth certificates jeopardizes the community's health and safety. When you have a birth certificate that doesn't reflect somebody's gender identity and outward gender expression, it puts them in unsafe and dangerous situations. It pretty much immediately outs the person in question to whomever they're presenting their birth certificate to. So an example of this would be actually my younger brother who's trans. He has a full beard. If he were not able to get the gender marker changed on his birth certificate, presented it to somebody, and it showed female, and the person took a look at him and saw a young man, there is a chance, especially given the climate in this state right now, that he could be assaulted at worst or harassed at best.
Which is a crime under Texas law.
Yes, and something I would very much like for him to avoid in any circumstances.
No, I understand, but no one, Ash, is stating that activity is okay. No one.
Good.
So what we have to ask as this committee, again, putting the politics aside, asking what should be on a birth certificate, a snapshot in time, legally, what is on a birth certificate, period. That's the question. What should it be able to be amended?
Right, and
Just for the chair's edification, I looked in the administrative code, and from what I saw in the administrative code, sex is listed as an item to be on the birth certificate in the administrative code. The statute that is in Representative Toast's bill that's referenced, if you go back up to that provision, it says the department shall provide, yada, yada, yada. And in the administrative code, the department has adopted a regulation that sets out that.
This is already a thing.
Council members, is it okay to interrupt someone's
Hold on.
testimony?
Ma'am, hold on. You're not registered yet. Member, any other questions for Ash? Yes, Representative
Just
Flores.
a comment. In terms of policy, because you said,
Sure.
We're trying to
Sure.
create good policy, and to Ash's testimony, about, wanting to prevent somebody from experiencing a dangerous situation. I mean, wouldn't it be state policy that we don't want to have the situation where somebody is exposed and to potential danger, to danger? I think as a state, we should want to protect our citizens and not expose them to unnecessary, harm or danger. And so I think for state policy, I think that would be important to allow them, if they are now presenting as a different sex than for what shows up on their birth certificate, that they should not be put in that situation. Is what I'm saying.
So what, I guess I would ask in response, what other parts of the birth certificate can be amended? Are all of the items on the birth certificate subject to amendment?
Well, what if you legally change your name?
Then your birth certificate doesn't change.
It does not.
No. If you legally
But there's
change your
got to
name-
be some a way to present documentation as to what your legal name is going forward.
Yeah, I don't know what that.
And if it doesn't match your birth certificate, I mean, I don't know. They might think you're a fraud. I don't know.
I have a comment.
Yes, Representative Johnson, Vice Chair Johnson.
Ash, I think you're testifying. I'm going to direct my question to you.
Thanks.
I think, to me, one of the most concerning parts of this legislation is the sentence, the end sentence, which says the method of classifying a child's biological sex used under this section applies to other laws of the state of Texas, the state with respect to determination of a person's sex or gender. So this is much broader than just a birth certificate bill.
Right. It's
And I have a lot of concerns about that, because a driver's license, for example, a driver's license is not a document that's designed to determine a point of time of a birth.
right.
It's a different document. And so this would also prohibit a transitioned person from getting a driver's license that matches their current gender.
Correct.
Do you read it the same way?
Yes, I do. And that opens us up to more opportunities to be harassed, discriminated against, and possibly assaulted.
Right. Thank you.
Members, any other questions?
I didn't finish my testimony. I got maybe 10 seconds in.
Okay, Ash, you go ahead and finish your testimony.
Thanks. So yeah, jeopardizes people's health and safety. It erases people who are non-binary, like myself. There are only male and female options under this bill, and I know that Texas doesn't have a third option yet. I like to hold hope that maybe one day folks like me will be recognized. That also does not bode well for intersex people, but I have friends who will testify more about that later. And then, of course, it is unconstitutional. It violates equal protection. It violates due process, and it violates free speech. So naturally, the ACLU is vehemently opposed.
Okay, great. Thank you for your testimony. Members, any other questions? All right, thank you. The chair calls Sophia De Loreto Chudy. I have you, and am I pronouncing your name right or no?
No, but it's all right.
Can you tell me how to pronounce it?
It's Sophia Di Loreto Chetty.
Oh, okay. Sophia De Loreto Chudy.
Di Loreto
All right,
Chetty.
testifying on behalf of yourself, and
Yes.
you're against House Bill 1952?
Correct.
All right, go ahead.
Yeah, again, I didn't prepare a testimony, so I apologize. But
Okay.
as you can see, I have a very difficult last name. It has caused me problems my entire life. And one of those problems, specifically very recently, was when I first moved to Austin, Texas. My car was stolen, and in it was all of my most important documents. And it has been a pain and a half to get those documents remade or original copies of them. And because of that, I was actually denied my ability to vote in my first election here because I didn't have my birth certificate. My birth certificate is the only federal or state document that has my name legally spelled correctly, and it's the document that is the hardest to get back. So I know firsthand, as a just plain citizen of Texas, not a transgender person, not non-binary, how difficult it is to get my identification correct to match the person that I am. My driver's license is incorrect. My passport is incorrect. All of my documents are incorrect except for my birth certificate, and my birth certificate is the only one that I don't have. This, again, I didn't read the bill before today. I read it just within the last couple of hours. And again, it is so clear to me that this is an attempt to harm trans people as a policy. It is a policy attempt to harm trans people. And as Ash mentioned, the forced outing when people will be showing their documents, because again, you need your birth certificate in order to get your driver's license, in order to get your passport. And if those documents show a sex or gender that is different than the person presenting that document, it's going to cause a lot of problems. It just is, and we know that. And I urge you as this council, as this committee, to drop this bill and drop this attempt to harm trans people. Thank you.
Members, any questions? All right, thank you. Is it Alice? Is that correct? Okay. Alice Nutt, I've got you here registered on behalf of yourself against House Bill 1952. Is that correct?
That's correct.
Okay, go ahead.
Great. So, as you know, my name is Alice Nutt. I'm currently a student at the University of Texas at Austin, where I also happen to work as a student staff for the Texas Leadership Education and Development Office. I also happen to be intersex. I was born with partial androgen insensitivity syndrome, also known as PAIS, and that means that I have multiple variations in sexual characteristics. As such, I was born with XY chromosomes, as the condition is only clinically significant to individuals with a Y chromosome. For this reason, along with other supporting congenital factors, I was sexed as male. The majority of people with PAIS are raised male, additionally. I have faced heavy discrimination and irreversible harm on the basis of this designation, including but not limiting to masculinizing genitoplasty, the registry of testosterone as a supported treatment, and heavy social discrimination as a result of secondary sexual characteristics predominantly associated with the female sex. I was pushed to maintain male-gendered expectations on this ideological basis. These aforementioned measures were made in accordance with standards for medical care given to doctors in response to this syndrome, against my consent, and in the case of genitoplasty, sometimes before I was even capable of consenting. This classification of sex will inevitably lead to the continuation of this violation of other intersex individuals' bodily autonomy. The enshrinement of this information on a birth certificate will ultimately be informed by an ideological rather than a scientific approach to sex. Once again, this bill will inevitably lead to harm as it assumes the notion that chromosomes are the sole basis of sexual differentiation. I hope that you recognize the dangers of this bill on the intersex community on Texas, and thereby I urge you to vote no to House Bill 1952.
Okay, thank you. Thank you, Alice. Appreciate your testimony. Members, are there any questions for the witness? All right, thanks to each of you for your testimony and for your patience today. Calls our final panel of the evening and of the day, Stephanie Perdue, Soren Aldaco, Alma Salcido, and Alicia Weigel? Weigel, okay. Is Alma Salcido still here? Does anyone know Alma? Okay. Stephanie, let's start with you. Thanks again for your patience. Stephanie, I have you testifying on behalf of Central Texas Pride Community Center, LGBT Rex, and yourself against House Bill 1952. Is that correct?
That is correct.
All right, go ahead.
Thank you, Mr. Chair and Madam Vice Chair, once again, for being able to testify once again. I am in opposition to this bill. For many of the same reasons Ash has said, it's basically about safety and about outing myself. But just as an additional concern, what comes to mind immediately is if I can't change my documentation, I told you earlier during this meeting today that I have a felony record. If I was to be incarcerated and my record said that I was male, where would I be housed? Think about these things. What our identification says affects all kinds of areas of our lives, and we need to reflect who we actually are. That's all I have to say.
Okay, members, any questions? All right. Alicia Weigel?
Yeah, that's it. I have a point of order, though. First, can I ask? I haven't been able to see the committee substitute, and there's an exception.
Hang on, let me recognize you before.
Yeah, I just don't want to waste my 2 minutes before I can hear what the exceptions are that are written into the substitute.
I have to recognize you. You've testified you've registered to testify on this bill. We'll get to your question in just a sec. Alicia Weigel, registered on behalf of yourself. You're a human rights commissioner for the city of Austin, is that right? And
Yes.
You're testifying against House Bill 1952?
That is all correct. Thank you.
Okay. Go ahead, and if you need to ask a question, you can.
Yeah, but just before I waste my 2 minutes, I would like to know what the changes are in the committee
There is no
substitute.
committee sub currently in front of the committee, and so we can't talk about a bill that doesn't exist before the committee.
Oh, I was told there was a committee
I
sub.
think there's going to be, but there's not one in front of the committee, so we have to be real careful about keeping our comments to the actual bill in front of the committee at the present time.
Okay, got it. Thank you. Can I start my time now?
Absolutely, yes.
Thank you, Chair.
None of y'all are on a clock, by the way, so
Okay.
take your time.
Thank you. Yeah, my name is Alicia Roth Weigel. There's a lot of stuff I could talk about, but I was also born intersex. I have XY chromosomes, but I was born with a vulva and a vagina. It seems absurd to have to talk about this. It probably makes you all uncomfortable. It makes me uncomfortable that we have to talk about any of this in the first place. But I am part of the nearly 2% of the world's population that proves that this bill is biologically incorrect, logically fallible, just doesn't. You open any standard biology, high school biology textbook, and it just shows that this is untrue. I'm happy to submit genetic testing, a karyotype. My parents had to do all of that to figure out how to best care for my body. We face huge inequities in terms of our care already, but just enshrining into law that I'm a man is just really weird. I would have to pee in the men's room. Maybe if y'all want to add a fiscal note to this bill and start furnishing plastic funnels in the men's room so that I can pee in a urinal, that just makes this all more expensive, but it's kind of absurd in the first place. Yeah, this just, again, it ignores biology. It ignores the natural occurring existence of human beings. It just makes no sense. I don't even think something like this should get a hearing. Yeah, I'm happy to answer any questions, serve as more of a resource witness. And my last thing I would share, I guess, before I open up to questions, there is a movie coming out about intersex people. It'll be in theaters June 30th. That's called Everybody, and I think it'll help educate a lot of people on this particular issue. And so if you want to wait until after this session to try to pass, again, biologically unsound, logically fallible legislation that's going to harm a lot of people, I would wait that you ask to watch that movie first and kind of educate yourselves. Where 150 million people around the world are born like me. We're not some negligible small percentage of the population.
I think that Representative Toth said he was going to address that issue in the committee substitute. I'll let him speak towards that at the end, but I do think that he addressed that at the beginning.
That's what he said. Okay,
that's what he said. So I know you'll be looking forward to seeing the actual language of the committee sub.
Yeah, because they often say that they're going to address it, and it doesn't get addressed. And there's so many, if we want to really help children, I have tons of ideas to offer of ways that we could help intersex children like me, preventing non-consensual surgeries on our bodies that mutilate our genitals and leave us sterile, as what happened with me. There's a lot of ways that we can prevent harm on intersex kids without also harming trans people. There are a lot of different ways to do that. There are countries around the world that have banned non-consensual surgeries on intersex kids, from Kenya to Greece to Germany, and they also do not target trans people in the legislation that they're passing. So there are ways to do it. We're just really behind here in the US, and it just takes listening to intersex people, listening to people who have lived with these bodies our whole lives.
Okay, members' questions, Representative Vasood.
So, and I apologize for asking a personal, let me ask an academic question, but, or maybe personal. I want to make sure, because what I want to make sure is that the bill addresses this issue. So did they have to record a biological sex on your birth certificate?
Yeah, so it was recorded as female on mine because of my external genitalia.
Okay.
But again, like, so I have XY chromosomes. I have a Y chromosome, but I also have a vagina. So it just proves that this bill, it's like, why are we even talking about this? Like, we could be fixing climate change.
But, okay, so for your personal situation, do you desire or have or know of anyone that has a need in the intersex community to change their birth certificate and has not been able to?
Yeah, absolutely. Sorry.
Whoa.
Pardon me, I'm
Yeah.
sorry. Absolutely, without the F word.
We'll strike that from the record. Okay, so.
Well, we need to change that.
Well, we need to, this is low-hanging fruit. Representative Toe, got to have in the committee sub or whatever that comes out of this bill, we got to have the language that says that if you're intersex, you have
But
the
why
option.
just intersex people? Why can't trans people also, if it's insufficient on their own documentation, why should only one type of person be enabled to change this document?
I think that,
Isn't that discrimination based on like the basic definition of discrimination on the basis of sex? I think that's prevented in the Constitution.
legal Constitution aside, I think on this intersex issue, we need to, there is no constitutional provision that talks about sex discrimination. It's Title VII, Civil Rights Act.
Title IX as well.
But I think absolutely we need to address this situation.
I agree.
100%.
Yeah, and this bill is not it.
Okay, thank you. Members,
Thank you.
Members, are there any questions? Any other questions for the witness? All right, thank you.
I'm here all night if you have any additional ones. Thank you.
Okay, thank you. If I could ask the two of you to wait for the final witness to share her testimony?
Oh, sure.
That's what we've been doing all day, and I want to end on
Yeah, absolutely.
a positive note here. So, Soren Aldaco. Soren, I've got you registered on behalf of yourself on House Bill 1952.
Yeah, hi. So I admittedly did not fully understand what exactly the intent of this bill was. But hearing some of the other testimonies, which thank y'all for talking. I think discussions are necessary for anything people have disagreements or are confused on. I think that's one of the beauties of having language is to be able to meet each other where we're at. But I'd like to first differentiate, or at least clarify that I don't believe that everybody is using the words like sex and gender the same. I think a lot of people conflate them, though in a lot of academic areas, and I study sociology and humanities, they are used differently, which I think leads to some areas of nuance we need to have in discussing a bill like this, where gender identity as something distinct from sex. I personally think that designating sex due to the fact that, there obviously are examples of intersex people that are very real and need to be recognized, but for 98% of the population, we do fit into two categories that are pretty observably distinct. And it's not just chromosomes, it's a list of things like mammals aren't always, they don't always have live births, like platypus or platypi or however you say it, lay eggs, but they're still mammals, right? Because they fit the majority of those characteristics, just like males and females do. For sex, that is, not mammals. We're all mammals. But I guess what I'm saying is I'd like to see us recognize gender identity as different from sex, because transgender people are using it differently than how we are in this room for the most part. I would like to recognize trans safety, because I do understand the difficulties of having at least appearing to be a sex that, on your birth certificate you are not. And I don't want any, situations to happen where somebody's life is in danger. At the same time, I do ask, like in situations where someone would be presenting their birth certificate, what actual safety risks are there? Like if you're at the DMV, is it actually reasonable that someone's gonna get away with hurting you, like from behind the desk, you know? And that's something that I'd like to see if there are examples brought up, because while that is like a very terrifying thing in the hypothetical, I want to kind of consider the realistic outcomes, you know. And I do agree that, you know, the birth certificate is a biological or is a snapshot of what is happening at birth, and that does include biological sex. But again, it's a little bit more nuanced than I think some of the positions I've heard so far are recognizing, which is why I'm on.
That's well said. Thank you. Members, any questions for the witness? All right. Thanks to each of you.
Thank you.
Okay. Does anyone else testify on, for, or against House Bill 1952? Seeing none, the chair recognizes Representative Toth to close on his bill.
Chairman, can I talk about potential committee sub language?
Yeah, you can talk, yes. Yes.
Okay, so the language over in the Senate is a person is not required to list on the birth certificate or report to the local registrar the biological sex of a child whose biological sex is not determined at birth because the child is determined by a physician, has atypical or ambiguous sex organs, chromosomes, or androgynous profile for either male or female, which goes to what we just talked about or what she just testified about. And if we need more clarity to that, I'd be happy to work on that as well.
Is it Alicia? Is that right? Okay. Representative Toth, thank you for clarifying. I would encourage you to sit down with Alicia, as I know you will be open to doing, and working out some language that that I'm not sure you're ever going to get to a point where you support the bill, Alicia, but to where she might be, her situation would be covered by it, which is certainly what we want. Go ahead with your closing.
Yeah. I got a call 2 hours ago. From a constituent back in Montgomery County. She's an LPC, and she heads up an organization called Love Heals Youth. And the kids that she loves up are predominantly foster care children who've experienced a lot of trauma in their life. And they have extremely high rates relative to the general population of kids that have gender dysphoria. And she said, Steve, I just hope, she said, I'm calling you because I'm just really hoping this bill's going to go through, because I'm hoping and praying that it's going to cause kids to hit the pause button so that we don't hear more stories like hers, like we don't hear more stories like Chloe's or Prisha's, and all the kids that were here on Monday evening that have such severe regret over the fact that no one encouraged them to slow down. No one encouraged them to hit the pause button in the midst of this, these life-altering, inalterable decisions that these children are making. She said, that's why I'm hoping that this bill goes through. I said, it's not the intent of the bill, but I can appreciate what you're saying. So with that, I close if you have any questions.
Chair Moody.
I appreciate the sentiment you just expressed there in your closing. What I'd like you to do too is in that same space that you want to have care for those folks you mentioned, I want you to think about the folks that I've met with whose children are no longer here because of the severe bullying and intimidation, isolation that they've received because they feel targeted by things like this. These are parents who have lost their kids to suicide, to substance use disorder. And so I want you to put those stories side by side with those that you just talked about, because they are just as important, and those stories should break your heart as well. And it is important to understand how difficult it is to navigate in a world where you feel like you're alone. And so I know you'll do that. I know you're going to take time to meet on some of these other issues, but sit those stories right next to the other ones that you've been hearing, because they need to be heard as well. So thank you.
Absolutely, and I appreciate those comments, Chairman.
Okay, members, any other questions? Thank you. Thank you, Representative. With that, we'll leave House Bill 1952 pending. Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection to adjournment? Hearing none, the committee stands adjourned, subject to the call of the chair. Thank you, members.